Writ petition dismissed. Sorry, sir. Publish.
And there is nothing to the petitions, it's 97/24.
Writ petition dismissed. Dismissed. Sorry.
Morning starts with dismissal.
Wait, please, Your Lordship.
Yes.
I'd like to mention item number 7, my lord, with the due consent of the other side.
Yes.
We have filed an affidavit. We are filing an affidavit today, my lord. We have served them a copy.
Item
We have received, my lord. Item 7. my lord. 7.
Yes. With the prayer of Mr.
A. Fukan, my lord.
This is part or better.
Yes,
My lord, Your Lordship, on the last
What is
occasion,
your instruction?
Instruction, my lord, we need to some time to go through it, my lord.
we have filed the affidavit today, my lord. They
Saying
will,
what? Saying what?
my lord, it's a big consolidated affidavit because it's an old matter. We have been newly appointed, so we have filed a affidavit on behalf of respondent number 2. And on the last occasion,
GAD.
GAD, my lord. Your Lordship
Yeah.
asked me to file. So
Huh.
I have filed today. They have received it. They'll file a reply, my
We
lord.
need some time
What
to go.
reply? Part or matter?
Lord,
We
sir,
just go through it. We'll take it up today.
No, my
My
lord,
lord.
today my senior is also some difficulty, lordship.
Lordship will have it on the next week, my lord.
Next-
What is this?
Next week, my lord.
Oh, 3 months you want?
Yes, sir.
Just because you are eligible.
Lordship. No, we need some time to go through it, lordship, and.
Go through it now.
But we
How
are-
big it is?
My lord, it's big, my lord. It's quite big, voluminous.
big
my lord.
affidavit.
We are filing it, my lord. On the process of filing
Next
it.
week, lordship.
You try it. We'll take it up 2 o'clock.
My lord, we are-
Today my senior is also difficulty.
today some difficulty, my lord.
Today some-
Because we are also
Next
filing it
week,
today, my lord.
take up, lordship.
Sir, we're dismissing the writ petition. Why you are not trying to understand? What is this?
Next week, my lord, will dismiss.
There's nothing.
Next week, lordship.
But any
Just
other
formality's sake, we have adjourned this matter, keeping it part hard all the time. In that case, you will release from the part hard. All right?
Lordship,
Release from the part hard.
lordship, we need some time.
Then I will not release.
Lordship.
Lordship will keep
Next
it.
week,
I have heard it many times.
But next week, any day, my lord.
I
Any
just
day.
wanted to know something.
Lordship.
I mean,
Next week,
some
any day, lordship.
clarification from them. How the promotion, the process has undertaken. That's all.
Lordship,
It's
take
a
up-
matter of 3 months only.
Yes. But
What
that
is
the
your
selection,
right?
lordship, therefore, we have bodies on.
That's what I'm saying. 3
Yes.
months, how can you?
Next week, madam, next Monday, lordship. Affidavit will also come in the record, lordship.
We'll call the affidavit
Lordship,
now.
My senior is also difficult.
Where he is?
As both have his, some difficulty, lordship.
He's not around.
Yes, lordship.
He's in the High Court premises.
No, lordship.
Where he is?
But he's a viral fever.
Tomorrow.
Tomorrow. Day after tomorrow, lordship.
Day after tomorrow.
Day after tomorrow. Right.
Mr. A. Fukan,
My lord.
learned standing counsel GAD, submits that in terms as per the order of this court, he has filed the affidavit to this court. However, same is not taken to the, no. However, in view of the above, and as agreed to by learned counsel for the parties, list this matter on 05/06/2025.
My lord.
Can it be 06, madam?
06, I'm leaving.
No.
I'm leaving early. Hello.
Fifth, my lord. Keep it.
May it please your lordship.
Yes.
Lordship, I have prayer in regard to item number 15 and in regard to item number 10. Lordship, in these two matters, Mr. Surajit Dr. Senior Advocate, he will be appearing, Lordship, but today he has some personal difficulty.
15 and 16.
15 and 10,
10 and 15. On the prayer MS,
IDAS.
I thus learned counsel appearing on behalf of item 10, huh?
Item 10 for the petitioner.
S. Roy.
No, I'm appearing for the, for Mr. Datta itself. Yes, sir.
Appearing on behalf of Mr. S. Dr. Land Council for the petition. List this matter after 3 weeks.
Lordship,
weeks.
in regard,
And
in the
15, item 15.
15, we have been engaged newly, Lordship. Yesterday only we have been engaged.
I'm a so and so, I so and so, Land Council. Submits that she has been engaged recently, therefore, she may be granted some time to prepare the case listed. Let this matter be, in view of them, let this matter be discussed. 3 weeks.
Deeply obliged.
Therefore, adjournment in item number 13 also.
13,
Lordship,
yes,
the arguing counsel in this case has had to go to Manipur as her mother has expired.
on the ground that Mr. B.D. Cole.
Not
senior-
VD Code, JM Code. And
Huh?
Mrs. JM Code was appearing in this matter.
Who?
JM Code.
What happened?
Her mother expired. She is in
On the
presently
ground
in
of Mr.
bereavement.
JM Cole, his name, her name is not there.
Maybe in the course because she has been appearing in this case.
No, B.D. Cole is there. She is the wife of B.D. Cole.
Yes.
Would you write? Her name is not there. On the ground that Mr. B.D. Cole, London Senior Counsel, appearing for the petitioner is in bereavement.
Doctor, sir is here in the court, but in this case, JM Code is appearing now.
Okay,
She is the arguing counsel.
okay. On the ground that MS
JM Code.
JM Court, London Council for the London arguing counsel for the petitioner is in bereavement, Mr. So-and-so, London Council prays for adjournment. Mr. Praise the Lord, list better after 3 weeks,
Lots of 2 weeks.
2 weeks. Huh?
I'm obliged.
There you go, it's an item one.
My lord, I have already submitted, my lord, the impugn order, my lord. Saying that the SMC did not have the power in view of the provincialization order is wholly, my lord, untenable, because the order of provincialization was, my lord, particular date, 27/9/2013, and he was dismissed from service on 27/4/13. So it doesn't make.
Before the provincialization.
My lord,
Before the provincialization.
yes, before the order was issued on 27/9/13. So it cannot be said that whatever the SMC has done is wrong. In view of that, my lord, I have given a judgment, 2012 6 384. So that explains the matter. So in this view of the matter, the order of the division bench passed by this honorable court of division bench, but subsequent order passed by the Commissioner Education pursuant to the order passed by the division bench is not tenable. And the petitioner, in view of his his service was provincialized on 11/5/15, and since then he has been serving, because in writ appeal in this present writ proceeding.
What was the order or something like that? It was not communicated.
This is the order, madam. If your lordship may kindly see, may I just take the lordship through the facts again?
Yes.
Hello, this petitioner, he was appointed in the year 2005. Then thereafter, my lord, proceedings of the SMC, the respondent number 5 has been dismissed from service in view of these irregularities in service.
Yes, yes.
And thereafter, my lord, his service was provincialized, and this provincialization order was challenged before this court by a way of a writ petition, which was
By you.
by me, my lord.
Okay.
And because of, the learned single judge dismissed the petition, allowed the petition, and upheld the dismissal order of the SMC.
Hmm.
And thereafter they filed the.
That is 27/4/2017.
27/4/2013.
13, yes.
13.
Ah.
And then thereafter, my lord.
Division bench.
Division bench directed the commissioner to decide the matter
Ah.
as regard the disputes between the petitioner and the private person. And the commissioner, my lord, education, he said, my lord, provincialization order is there with provincialization order is dated 27/9/2013
Hmm.
with effect from 1/1/13. So therefore, his termination order dated 27/4/13 could not have been passed because at that time it was a provincialized.
Okay, okay.
This is
So
what the-
according to you, this, since the order was issued, provincialization order was issued and passed on 27/9/2013,
13.
though have a retrospective effect,
Yeah, you cannot have a.
before it is
retrospective
released, I mean, before it is
effect
communicated,
communicated. And
he was already terminated.
he is already done.
Okay.
So therefore, if he has any problem, my lord, as regard, my lord, his service during before the provincialization, he can go to the tribunal as per the division bench judgment. That division bench judgment has constituted a tribunal for deciding the matters of the teachers in the while they were in they were appointed or dismissed by the SMC, School Management Committee. So therefore,
I think it's too late in the day.
well, yes, no, if they.
2013.
Otherwise, well, the order passed by the division, by the Commissioner Education is
Page.
explicitly wrong.
Yes, yes. Page
That is at 79.
79.
On page 84. Okay.
Page 79 from paragraph 8 onwards. No, sorry, my lord,
No, this is not 79. 84.
84.
In SMC Amantilal Aid Community Services,
Finding, my lord,
which is violation of the provision under section 6 of Assam Convention. Upon permission, the SMC concern loses its power to take any action. Okay. So according to him, since the provincialization is with effect from 1/1/2013
13.
and having the dismissal order having been passed after that, the SMC doesn't have authority.
So this is the thing, my lord, in section 6, you will also will you see. Look, it is retrospective effect, you take away all the action taken by the SMC.
I think there must be some saving clause.
No, my lord, ultimately this act was, my lord,
No, that's what I'm saying.
Yes.
After the 2011 only. So there must be some saving clause in this present act.
Present act is 2017.
Yes.
This 2011 has been, 11 act has been
Yes.
ultimately struck down.
No, this has been provincialized
Provincial.
under 2010. 11, sorry.
2011.
2011. Okay.
So this was struck down subsequently, I think by an order dated.
Yes, this is okay.
2016
No issue.
by Honorable
There's no
Justice
dispute.
H. Roy.
Yes, there's no dispute.
Then thereafter, my lord, a new act was passed. That is, I think.
I just wanted to
2017
know, I think there must be some saving clause.
In
2011, yes.
2011.
649 page.
Which one? 11? Yeah. 11.
Power to make rules, delegation of powers. Every rule reasonable section shall be laid as soon as. This, I didn't find, my lord. Yes. Assam Venture Education Institutions, Provincialization of Service Act 2011. Page 6, relevant is 657. Judgment to 2012. For the.
There is no saving clause.
It is. 2012.
Although this has been struck down, no longer, I mean, in force, but then,
Saving
since
clause.
they have taken a decision to, give the retrospective effect, like the present one, maybe there were so many, I mean, other matters similar to this, ought to have been saving clause.
Should be. Well, 2012 6 SCC.
Anyway, it's good for you. It's good for you.
Yeah, good.
I thought that if there is a saving clause, it could help Mr. Chaudhary.
Otherwise,
Not there.
also, my lord, they are all communications orders are from the. date
Yes,
of
yes,
receipt.
I've understood. Yes,
It's a.
Yes. But what is my case, my lord?
yes.
Removal, my learned friend is saying then 27/4/13, removal order. Where is the removal order, my? It is a decision, it is a resolution only. They have decided to remove me. Where is the removal order, my? That is the case, my lord. We have categorized idea also in writ petition, my lord.
You are technically correct,
Yeah,
but then you are not challenging the order of this,
we have challenged.
no, this impugn
No,
order,
in this, not,
present impugn order.
no, I am not, my lord. What I am saying, my lord, your lordship will find one order is there. We have filed another petition, my lord, writ petition, challenging that one, my, that the resolution. Saying that we have received neither the copy of the resolution nor any termination letter is there, my.
Hmm.
Till today, they have also not produced, not government produced, where is the termination letter, my?
So what happened to that writ petition?
Yes, that writ petition, my lord, I am giving the order, that was closed saying that all the points which you have raised, you raised in this petition, my. This is the, my lord, your lord's kindly zone.
In this present petition,
Yes,
okay.
your lordship will find case number present, idea petition 4492, my. 4492. Your lord kindly have a look.
During the pendency of civil.
Paragraph 311, my.
Triple six, this is 666.
Yes,
Okay.
present one is 666, present one. And I take your lordship to division bench order, my, just division bench, page 80, my. 80, the division bench.
Yes,
Yes. Your lordship from paragraph 2, my. 80. The matter pertains to provincialization to the post of assistant teacher of so-and-so in so-and-so school. Appellant, that is the present by the respondent number A. Appellant Saibur Rahman was appointed as assistant teacher of Bencher School on 15/8/94. And as the senior most assistant teacher, he would normally have a priority claim for provincialization. But the service of the senior most teacher, Saibur Rahman, was purportedly terminated for alleged absence by the school managing committee on 27/4/83. By the school resolution, my lord, terminated for resolution by the school managing committee on 27/4/13. Therefore, although the service of the senior most teacher was provincialized on 21/1/14, as the instance of the writ petitioner who was later appointed in the school on 10/2/15, the provincialization of seventh respondent, that is that is present petition, respondent was quashed by the writ court, and consequential direction was issued in WPC number 1086 to consider the later appointment of provincialization. Agreed by the decision of the writ court, the seventh respondent has filed the writ appeal number so and so, where it is projected that the concerned records of the SMC were manipulated to confer under benefits on the junior teacher Altaf Hussain, the present writ petitioner minor. As you will kindly note, as the principal of the school and the president of the SMC are own brothers of the junior teacher. Therefore, Mr. H. so and so learner submit that the benefit of provincialization was rightly given earlier to the senior most teacher who was appointed on so and so, and the writ court should not have interfered with the provincialization order. On the other hand, Mr. So and so submits that although appellant was appointed on 15/8/94, he was not regular in his duties, and therefore the SMC were forced to terminate his service on 27/4/13. We find that the termination order dated so and so, it is not a termination in fact matter, is challenged by the Saibur Rahman through WPC number 4492 that just your lordship has seen. And that case is pending consideration of a writ court. In the meantime, on account of the status quo order passed by the division bench on 23/6/15, all the consequential order was passed for provincializing the service of the Altaf Hussain in so and so school under so and so, so and so, so and so. The salary, etc., has not been disbursed so far. The IA is filed by the respondent, writ petitioner for recall of the status quo order passed by so and so division bench. At the stage when the writ petition came to be allowed on 17/3/15, the counter affidavit of seventh respondent was yet to be filed. Therefore, the court was not apprised of the report given on 15/11/13, wherein the BO Badarapur had indicated after verification of the record, the Shahidullah has been regularly working as an assistant teacher of the so and so school since 15/8/94, and his name was included in all official correspondences, and he received his share of the grant in aid sanction for the school for the year 10-11. The report of the BO further indicates that the head teacher is manipulating the school record to appoint his younger brother Altaf Hussain present writ petitioner minor by replacing the older teacher by older teacher Sahibur Rahman through forging the documents. But Mr. So and so, on the other hand, submit that the inquiry conducted by the district officer claim of the supports the claim of the petitioner. The claim for provincialization in a bencher school is to be considered on the basis of the length of service, and if the assistant teacher appointed on 15/8/94 is serving with sincerity, he deserves to be provincialized. On the other hand, it has also to be verified whether the school records were manipulated to wrongly show that the older teacher, that is senior teacher, was irregular in his duties as reflected in the proceedings of the SMC. Confronted with the above factual controversy, it is submitted by the departmental lawyer that direction be issued to a senior officer of the education department to verify, your lordship kindly know, to verify and decide who among the two claimants is entitled for the benefit of provincialization. This submission of the department always is acceptable to the learned counsel for the two contesting parties. In the above circumstances, the commissioner and secretary to the Department of Elementary Education is directed to decide whether Saibur Rahman, as the eldest serving teacher of the school, deserves to be provincialized or whether his service was rightly terminated by the SMC for his alleged irregular attendance. Depending upon the outcome of the verification exercise, provincialization of the deserving teacher will be made. The two contesting claimants must be afforded due opportunity to project their respective version before a final decision is taken by the commissioner. The ordered exercise should be completed in 3 months or so. Accordingly, that order has come. Unfortunately, that order also does not reflect about the other things, which was the direction of the division bench. Page 84. 84 only, my lord, this your lordship will find next page. That is the impending order, my lord. The order talking about the That's what it is. Page number is it? No. The aesthetic page number was- The page of time. That's so the restriction. Four, five, six. Okay, that's fine.
Your 1086 was filed by you.
Yes. Against my provincialization order.
So that was set aside.
Right, set aside.
Have you been thereafter provincialized?
Yes,
Writ petitioner.
that order my set aside is my dot 17,315.
Thereafter?
So thereafter, my writ appeal was filed by us.
Page 65.
Thereafter, writ appeal filed by us, my.
Yes.
That your loss will fine. But during pendency of the writ appeal, that his service was provincialized.
Okay. 65.
Yes. No, 58 is the High Court setting aside order, my.
No.
Page 65 is the appointment.
Okay.
Yes.
Mm.
11,515.
Yes.
Yes. So now your lordship will find, my case is, my lord, that in our affidavit also, in this present case, your lordship kindness is a category you have stated in the affidavit, my. What, affidavit too?
Page.
Yes. Yes. Your lordship kindness is page 5, my lord, the pagination, affidavit filed by the respondent number 8, my lord, on 27/2/20. Hey, hurry to all of them. Our affidavit. 27/2/20, it was filed. 20.
105.
Asset of, no? No, the-
105. Yes.
Hello?
105.
Yes.
Para.
Yes, paragraph your lordship kindly see. First, our contention is start from my lord, paragraph 4. 4, 5 and 6, my lord.
Yes.
Yes. Make
You
really,
make your submission.
my lord.
You make
Yes.
your
Now,
submission.
we have categorically stated that, my lord, in page 5, your lordship would find that the deponent further states that he received neither the copy of the impugned resolution nor any order of termination till today. Your lordship, page 5. That the deponent begs to say the service of the petitioner was provincialized with effect from 1/1/13 under the provision of the Assam
That
Panchayat.
we cannot deliberate on because division bench has also said termination. And the commissioner education also said your termination was not correct because the SMC doesn't have the power. That issue you have.
No, I am not on that matter.
No,
That's
no, that's what I'm saying. It's law. It's
not, if there is a termination, my question, where is the termination order, my lord?
no, we're not on that now.
There is no termination order, my lord.
Your this by impugn order.
Yes.
What is the decision?
By impugn order, the
Your
court,
termination was wrong. The termination by the SMS was illegal because SMC doesn't have the authority
two things, my lord.
after the coming into force of
Exactly.
the
That is
2011
there, my lord.
on you
But
mechanism.
division bench say, division
not
bench
go
says,
into-
my lord, who is
Sir,
senior.
will not go into, let us be very clear. Let us now go into whether the termination was communicated to you, whether it has been done, because that has been taken cognizance by the division bench also, as well as the commissioner, which you have not put to challenge. What the commissioner's decision, they are agreed.
Right.
They are assailing because they say the termination, your termination by SMC was much before coming into the order of provincialization.
But my lord,
That point of time, the SMC had an authority. Now, the commissioner said, no, SMC doesn't have the authority because after the coming into force of the 2011, because it's valid section 6. On that you just said.
but.
Because the veracity and
No, no, my lord, only
legality
the
of the
lordship is
termination
taking only
order,
one point.
we cannot decide.
No, your lordship is taking only one point, whether it was coming before or after.
Hmm.
Let us get for the time being. What I am saying, division bench order has specifically directed them that who among them is senior, who is entitled to provincialism. What is there, madam? Only by,
In that case, we'll send it back because what I'm saying, what I could
so
see.
there
is-
must, madam, they must deliberate on that because
No,
my,
if that is the case, you have not challenged it.
no, my code, it has gone in my favor, my lord.
Yes.
So I
But
have
the-
the challenge.
How it has been gone?
But
What is
now
the ground?
now they must say, my lord, who is, and as per division bench order, my lord.
That you cannot assail now.
But
The order is in your favor.
that
The
is,
grounds they are challenging, the order could not have been passed. The grounds which the commissioner has taken to come to a decision. All right?
decision they have got, simple they have gone, they act before or after, my lord. They have not gone to that aspect. So they have not gone to the aspect who is the division when directed to see whether out of among the 2%, who is that, my lord? Who is the senior one? That part has not been there. Remember, we have challenged. That is also your lordship kindly said this is also another way. It is also your lordship to hear whether there is termination or there or not. Whether I have received termination. There is no termination order at all, my lord. You're on the record, my lord, that decides to terminate. Where is the termination order, my lord?
Then why the commissioner has to say?
My lord, that is
termination-
commissioner's, your lordship. I am, the commissioner cannot go before your lordship.
No,
Cannot see it over the
are you
judgment of
supporting the order, the impugn order?
impugn order, my lord, they have challenged the impugn order because it only on that ground.
We'll have to see the legality of
So-
the impugn order only.
But your lordship should be impugn order passed in reference to the division bench order, my lord. Your lordship must have to see, my lord. What is the direction given to the
That's
respondent?
what I'm
Bhagavan?
saying. Are you supporting or are you opposing?
No, no,
the-
I am supporting my since I am entitled to get, they have given, but reason is given otherwise, madam. The reasoning is something else. But my case is, madam, a specific direction of the division bench. What is the specific direction of division bench? You have to see who is senior, who is junior, who is entitled, who is not. It is not question has come that because of the act has come subsequently or otherwise, my lord.
Hmm.
Who is entitled to get profit, especially what is the direction is there, man.
That's what I'm saying. You are not challenging the impugn order.
That might have, that can
You
be-
cannot also. obviously.
But that point also you all should see, my lord. Direction was that impugn order was passed with reference to the division bench order. It is not independent of that, my lord. It is in response to that order, my lord. What is the direction? Again and again, they have also said the manipulation is also, that was also come in the division bench order, my lord. My brother is headmaster, my another brother is president, my other brother is assistant teacher, other one is a peon of the school. I don't know. It has come in the BO's report also, my lord, it has come.
Your brother.
Yeah, no, their brother, my lord.
So why are you saying my brother?
Yeah, it is statement is there, my lord. One is headmaster, one is president, another is teacher, one is peon, Bantiwala. Everything is my lord. All the same family. This is the case, my lord. It has come on the record also, my lord. The division bench, our submission is recorded, my lord.
No, no, recorded.
So that finding must be there, my lord. I
Your
want on
submit-
that, my lord.
Your submission has been recorded only.
No, submission is recorded, my lord. That has come from the, my
It's
lord.
not the view of the court.
So they must find out, my lord, whether they record
But
manipulate.
only the division bench has taken a cognizance that the termination order, 27-1.
Yes. No, division bench, my lord, again, if your lordship, if I, division order, just one or two paragraphs, my lord.
No, you just read
My lord, paragraph 3 about the brothers, etc., my lord.
para 5. We
Yes,
find that the termination order is challenged by the so and so, so and
so
so.
and so.
So you have
And-
challenged the termination order.
No, there
This
is
is
no
a
order, my lord,
termination.
resolution.
Then
You have
you-
challenged- That is a specific case, my lord,
You could-
resolution.
You could have get it corrected.
Hmm.
Right?
Yeah,
This is your appeal. The order is on your appeal. This has been passed.
yeah,
Division bench has clearly said, we find that the termination order 27E4 is challenged by so and so.
yes. And that case is pending considering the writ court. That's
Okay, that's why I'm not, we'll come back. First on the, regarding the termination order. Because you are making an argument that there's no termination order.
exactly. Everybody is
How the
saying,
finding could be reached there.
Madam, everybody is saying, we also say terminate order, they have also said, court also said, my lord. Everywhere termination order is there.
Sir,
There
what-
is no termination.
Sir,
order.
once this
does your
once this is the cognizance is taken by the division bench, saying that termination order,
They have
clear
not-
cut.
They have not vacated or that
See.
system.
Look at this, para 5.
Yes.
We find that the termination order is challenged by so and so.
Hmm.
How do we change this?
So now challenge this order,
So that's why I'm saying we'll not go into the termination order.
but
The-
everybody
whether-
is saying
whether
termination.
there was a termination order or not, we're not going.
No, your lordship to see the judicial notice of that. Everybody is saying termination order,
that's
termination order.
it.
my lord.
This is a clear-cut findings of the division bench saying that we find that termination order, that is 27.
Madam, that was because 27/4/13, that was under challenge. That is a resolution.
Then
But everybody is saying my termination order, my lord.
that you should have get it corrected, resolution that is.
On the records, everywhere it is resolution, my lord.
Huh?
Everywhere it is resolution.
So
Nobody
cannot-
annexed the termination order. my
We
lord.
cannot change it now.
No,
today.
I'm not saying your lordship change it. Your
But I'm
lordship cannot
saying
seek
that
about the division bench order. my
That
lord.
is a clear finding of the court that we find that
Right.
termination order.
Now,
We'll
we
accept that
find,
it's a
we
termination.
find that the termination order data is challenge. We
Yes.
find, my lord, in the writ petition, that is 27/4/13 is under challenge, my lord. In the writ petition, my lord, 10.
Yes, next.
No, this is, so my case is, my lord, there, division, what is the finding, my lord? That at this stage, your lordship can is paragraph 6, my lord.
Hmm.
At the stage, paragraph 6, at the stage when the writ petition came to be allowed on 17/3/15,
Hmm.
your lordship got it, my lord. Paragraph 6, page 81. Division bench judgment, my lord. Page 81.
Yes.
My lord, paragraph 6. You know, got it, my lord.
Hmm.
At the stage when the writ petition came to be allowed on 17/3/15, the counter affidavit of the 7th respondent was yet to be filed. Therefore, the court was not apprised of the report given on 15/11/13, your lordship. That order, your lordship, can see our in affidavit it is there. Wherein the BO Badalpur had indicated after verification of the records that
See, after this, pursuant to this division bench order, only the commissioners taken a decision
yes,
which favored you or in your favor. I will not say favor, in your favor. So how can you question now when you are not challenging it?
No, since this question has come now, my
I
lord.
understand since it is in your favor, therefore you could not have challenged it.
Naturally, my lord.
Now, how are you making a submission on that?
No, I am saying because what is the
You
terms
have
and
to justify if you are supporting the order which is in
No,
your
no, I am
favor.
supporting him. Till now, I am
Then
supporting.
you have
But
justified.
it is there to say that.
What is the ground of the passing the order in your favor? What is the ground?
My
Read-
ground
read
is that.
Kindly read the.
No, no. What I am saying, my paragraph 6.
You are taking us. I'm enlightened to. You are enlightening this court the background. Background, we are not that interested.
No, no. Background make up
Well,
because
first we'll have to see how this order
now
is.
yes, whether impugn order touch all the points which has been reflected in the order of the division bench. Your
So-
lordship to see, my lord, whether impugn order, whether it reflects all the points raised
Then
by.
we'll set aside and send it back, remand it
That
back.
is up to your lordship, my lord. That is up
Is
to your
not it?
lordship. I cannot.
Because you are saying
I
that
cannot
this is-
dictate your lordship.
No,
It's
no,
up
no.
to your
It's not a
lordship.
question of dictation.
Yes,
If you are saying that this order, which is in your favor,
yes.
is not a good order or it's a bad order because the direction of the division bench has not been taken into consideration, we'll remand it back.
That your
Set
lordship
aside the judgment.
No problem, my lord.
Is not it?
Yes, your lordship.
Okay. Then what about his argument?
No, his argument, my lord, it is naturally he will argue in his own way.
No, no,
Every-
he has,
No, my lord, they are fine. My whole question is that what is the terms and reference of the division bench? Where is the finding of the respondent one in impugn order?
exactly, I'm repeating you. Are you challenging that? Are you challenging the
I
impugn
have
order?
to challenge that part because it is gone my favor, my lord. Now what I meant to say, my lord,
Well,
if
it
you-
is in your
for the
favor.
ends
What
of justice, my lord, what I am saying, my lord.
Yes,
Admittedly, this person senior most, my lord, 94 and 2005. Your lordship kindly see
there's no dispute.
how things happen. Manipulation is there, no finding about manipulation. Officer is saying there is a manipulation, my lord.
So when there is no finding,
Now, officer is saying there is a
Correction.
manipulation. So you must give a finding on that.
it's a manipulation, it's a very serious allegation, should
Serious-
have been.
that
By
also-
saying, somebody is saying is not,
No,
I mean,
officer
it will
also
have-
saying, when we put it
it
before the
will have
court,
an
also the
implication to the person
division bench
against
also we
whom
have
this
said.
allegation is made. So
Of-
until unless it is proved, at least
So that there must be
by
a
of
finding, my lord.
departmental inquiry, something, just say
Just
will
my
not
lord,
do.
one officer's letter, my
Sir,
lord,
I have
about
seen that.
manipulation.
Sir, I have seen that.
Yes.
That's what I'm saying. I'm privileged to have the background of the case. But for the purpose of deciding this matter, first we'll have to see the validity of this, legality of the impugn order.
Order, my lord, in the for the ends of justice, my.
I'll record that, sir.
Yeah, no.
I'll record that.
No, that's my lord, because this
So
one part.
it will make my job, make this
No,
course easy.
Your lordship kindly
I don't have to look
Your
into all
lordship,
these things.
because we are for the justice, my lord. This man, this division bench has given two things. One, you have to decide whether who is senior among
That is
them.
not done.
That not done.
Yes.
Whose fault, my lord? For that, my service goes, my lord, of a senior more than 10 years, my lord. So your lordship may remind, I have nothing to say, my lord. Because your lordship put my in my mouth also, my lord.
No, because the way you are making a submission, what I have understood is that
One part.
the impugn order is not correct.
No, not that I am not saying, man. I am saying
Indirectly you are
one part
saying.
in the imperial.
Indirectly you are saying.
No, I am saying, madam.
I want, sir, I want you to argue on the point which the petitioner has raised.
The petitioner is only, madam, what is this? Section 6 and 10(4), madam.
Ah.
That is the only their point. My point is, this is not the only point which the division was directed
Sir,
to
you
decide.
cannot you cannot argue a case
I
on
understand your lordship.
others
I
petition.
understand your lordship. I cannot take two steps. That I understand what your lordship mean to say, madam.
I have understood what you want to make, and I have seen it. I have read it also. Your graph. I mean, whatever you have taken defense.
Now,
whatever is there.
without putting my mouth also, your
Now,
lordship may
Yes,
demand it.
now I would like to hear you. Want you to argue what the points raised by the petition.
My lord, if there there is no foundation, termination is not there, then how this, whether coming into effect, when it has come to effect, no.
Agree. Then
No, so this is,
I agree with
so
you.
other points should be taken, my lord.
Sir, I agree with you.
Yeah.
Come to the point raised by the petition.
That is what I am saying, my lord. His point is only one point, that is impugn order, my lord, just impugn order. He is saying, your logic can see impugn order only one paragraph.
Not paragraph.
What?
What he is, you
No,
have
he has
heard,
raised this thing.
you
my
have
lord.
heard this.
No, he is saying that his service was
Let us-
provincialized.
Senior colleague argued other day.
No,
The
that I have
point is
seen,
very
I have
simple,
heard,
very simple point.
I was there. His only point is, my lord, his service, I was terminated, his service was subsequent, he was upgraded, thereafter his service was terminated, is provincialized. This is his case. Now, if everything, my lord, remains controversy or some other way, my lord,
Beyond that.
no, beyond that, my only question about division, what is that?
Little, come, I mean, recollect a little deeper.
Oh, no, my lord,
What he has said is,
yeah,
since here the respondent, service of respondent 8 was terminated on 27
for,
for 2013, and the school was provincialized thereafter on 27/9/2013. The ground taken by the commissioner, saying that the action of the SMC after coming into force of the act having no authority is illegal. Therefore, your termination is not, there's no validity, you have not been terminated validly, or the termination is non-nest because it doesn't have the authority. Therefore, what it said is, since the school was provincialized, after the service was terminated, at the time when the SMC has the authority, was the question of violation of Section 6. Because the order of provincialization was much later. And Section 6 says the effective date of provincialization
I am not
will be from the date of publication. Right? Am I correct?
Yes, sir.
Am I clear?
I'm not disputing that one, madam.
So if you are not disputing, we'll
That
allow
part,
the
madam, I'm not
petition.
disputing that one.
Yes.
About so far the effect date of the provincialization order or the termination order.
So do you agree that the learned council, the learned senior council for the petition, do you agree with the submission?
No, I cannot agree, my lord. I am,
When
what I am saying, madam,
that is what I am trying.
no, your worship,
Sir, what I have said is what the learned learned senior lawyer has submitted
yes.
in favor of his case. So on that, I would like to hear you.
Now, on that I am saying, my lord, assuming, my lord, it is correct, what I am saying, my lord, assuming that his submission is correct, my lord,
Yes.
where is the other parts? What is the direction of the division bench? I am only on that, my lord. One party you have chosen, that's true, my lord. The other, where is the other part? Existence, whether I was there or not. They are saying, everybody in collectively saying that you were not there. I have been thrown out on record. Also, I am always, all the time I am going to the school, my lord, for since 1994 till today, my lord.
Sir, that was not the issue. That was
No,
not
this is the issue given by the division bench.
division, but then
They have to address that point, my lord. That
so, division bench is over now.
no, about division.
Pursuant to the division, that's what I'm saying. If you are saying that this order is not in accordance with the division bench,
Yes.
so this has to go.
So that I'm saying, my lord, this order is not according to the division bench order because of the reason not by submitted by him, but because the reason for my division bench order has might have reflected in that here, my lord. Not because of that one. I do not know whether I might have could convince your worship or not, my lord. My question is, yeah, this imperial order has come in reference to that division bench order.
I have understood.
That's yeah. The rest I leave
According to you, this commissioner has not taken into consideration the
of the directions given by
issues
the
or the direction given by the
division bench.
division bench, although it is in your favor. All right.
Yes.
That I've understood. Therefore, are you supporting that? Having submitted that, how can you support the impugn order?
No, I am not saying, madam, I am saying, madam, main part, basis on who is this order was passed. If termination is there,
The
then question,
basis is that the SMC was not having an authority by then.
it is only
Therefore,
thing,
the termination of the petitioner, the respondent number 8 was wrong.
I am saying that you must give a finding on termination. You must have this, there should have given a finding on that. There is no finding. division was especially stated by beneficial parties there, other things is there, since question of fact. So the.
Sir, I have understood all those things.
Then
What
I
I
will
wanted
ask
to argue, what I am asking is, what about the submission made by the learned senior counsel for the petitioner? That is what I am saying.
No,
This is
this-
like argument.
No,
If you
that is
agree,
not a
then
question, my lord. He has argued one point, and other point is I am saying it cannot be taken into consideration, my lord.
I'll take into consideration everything,
Yes.
every
So
argument.
then I did
yours.
your lordship, my lord.
Now, I just wanted to know whether you are agree or not agree, why you are not agreeing and why you are agreeing.
No, I do not agree on the part that the basic things, the main suggestion or direction given by the arbitration bench has not been taken into consideration in one part. Without taking into consideration, they have on the ground of effect date, my lord. Effect date, my lord, your lordship.
Sir, for a time being, I'll accept that it's absolutely correct.
Yeah.
Then next, further.
Next, they have to readdress the matter, my lord. That is
Hmm.
what would be my argument. Your lordship, best part is the respondent one is to reconsider the matter, address the matter, my lord.
Strictly in terms of the division bench.
Strictly
Order.
in terms of division bench, my lord. That will be my prayer.
Indirectly, what you are saying
No,
is,
that is, it may be against me, my, I understand.
indirectly,
But
you
I
are
have no other way, my lord.
okay.
A person is till today, but since 94, a person is served, my lord. I am only one there. Where is the finding, my lord? Let them say, my lord. In the affidavit also, they have, my lord, your lordship, and we have stated everything in our affidavit. It has not been controverted also, my lord. Our affidavit, your lordship, can they know? The termination we have, there is no termination.
Normally,
They have not controverted it, my lord.
sir, normally I should have
Yeah, he is to justify.
heard him first.
Yes.
Since
Yes.
you are a senior lawyer.
So my part is over.
was given to you.
My part is over now, learned friends will.
Both the seniors.
But I am recording, I'll be recording that your submission.
There is a risk of my,
That-
but I am not
You
saying
have,
that.
you have not made any submission with regards to the
No, I made my doubt only on the ground
the
that,
point and the submission made by learned senior counsel for the.
no, my case is my doubt that termination, there is
Your
no,
case, I'll record.
no
everything.
question of effect does not come.
I'll record it. It is given in your para 5, 6 and 4, 5 and 6.
Hmm.
I'll give him that. But particularly, I'll be recording it that no submission has been advanced to the point raised by
No,
the-
I am saying, man,
regarding the communication
no,
and all
no,
those.
my
So,
submission was no, my doubt, that I will not.
That I was asking for
No,
the
no,
last one and a half hour.
What
30
I am
minutes I
saying,
was
my lord,
asking.
no marriage took place, my daughter. How children will come, my lord. Marriage is invalid. Children also illegitimate, my lord. There is no termination. That is what I am saying, my lord.
That I'll record it.
Yes, your lordship.
What you are saying is,
Uh,
since there's no termination, whatever the action, whatever the submission, whatever grounds they have taken, including the commission education, is inconsequential.
But I am saying,
Inconsequential, right?
Yeah.
Inconsequential.
yes, in concern of the division bench order.
In sum and substance, whatever the actions, until the time you find out whether there was a valid termination or not,
Not
any
valid
other
invalid, there is
action,
no
any other
termination at all.
any other decision, whether there was a termination or not,
Not valid or invalid, there is no termination at all, my lord.
since there is no termination, whatever decision,
Yes,
either by including the decision on the order passed in the impugned order, is inconsequential. That is your
that
submission.
is up to your lordship.
My lord, only one point I just like to show, my, because learned friend was thinking, my lord, he's challenging the order, my lord. Well, page 61.
Hmm. 61.
It's part of the judgment passed by the learned single judge.
Yes.
Yes. Your lordship, last part, my lord.
Hmm.
Neither the respondent number 6 or 7, nor the respondent number 2 has chosen to file their respective affidavit in opposition. The principal contention of the
There's no page
petitioner,
61.
6-1, my lord. This is part of the judgment.
One
Learned
page
single
is
judge has
missing.
passed the judgment, my lord.
One page is missing here.
One page is missing.
Yes. 465, 1, page, they're all defects. Page 61, page 161 is missing.
I'll provide the proof that time. But anyway, I'll.
No, anyway, it's no, we're not concerned
No,
now.
it
Because it
only
was
say-
taken, no,
it
it
only
was
s-
taken to a division bench. Division bench has taken some view and remanded back.
I'm just pointing out,
Yes.
because my learned friend was saying the termination order where it says, my lord, I'll just read
But
that.
he has a point also,
No, no.
when he challenged that, this thing, this has been, I mean, in view of the order passed,
By the division bench.
Division-
This is not his petition, madam.
huh?
This is not his
No,
petition.
no, in his petition, the point he raised in the petition, while
Yes.
closing it, the liberty was granted to
Yes,
take
a
any points. he
division
has
bench.
taken.
Division-
So the point which may not be whatever is there, but then he has been allowed to take in his writ petition while closing the writ petition.
No, no, that writ
In
petition
view of the
order,
passing of this impugned order,
I'm trying to just read that judgment only, just. I'll
no,
just
that's
read
what
one
I'm saying,
sentence.
is this is Learned Single Judge.
Yeah,
That has
Learned
been
Single
taken
Judge.
to appeal.
Learned single judge judgment, I'm just pointing out that what it says, the
Yes.
principal contention of the petitioner supported by the respondent is that service of the respondent was terminated on 27/4/2013, which your lordship.
Supported
Which-
by 7-3. Who
No,
was respondent number 3?
27/4/13, which has never been challenged by the respondent number 7. This was the finding of the learned single judge in the report. I'll provide a copy of the full judgment.
No, no, that's why they have challenged this. After this order only he has
Yes,
challenged.
writ appeal.
No, no, he has filed a writ petition also.
Against this
Respondent
order,
number-
they filed a writ appeal.
No, sir. He has produced a
Separately, yes,
copy
separately, yes,
separately.
separately.
Before the judgment or after the judgment of the learned single judge?
This is-
After
I
the
think
learned
after the-
single judge?
I've not seen that, after the judge.
No, you were there also when this was,
It was.
That should have-
when did you file this writ petition?
The petition was filed, my petition was filed, my lord. That is
23.
4492. It was
Huh?
filed on 31st/7/15.
2015.
15. 31st July 15.
And this order was passed on 17/3/2015.
Yes, madam.
Very good. Got it.
Yes,
But I wanted to know
yes.
that writ petition is filed on
31st July
Ah.
15.
2015.
Petition number 444492.
WPC
The petition number 4492.
4492.
Yes.
It was not adjudicated.
No, no, just, sir, there's a reason I'm asking.
Yes.
This order is
31, what that is?
12/9/20.
17/03/15.
12/9/23, order.
No, no. This single bench or the judgment was of 17/3/2015, right?
Yes,
You have filed your writ petition 31/7/2015.
yes.
Reason being, after this judgment,
After judgment was single bench.
yes,
Single bench, my lord, the
you,
single judgment was.
you realize that you have to challenge your termination order.
So I have challenged.
Yes,
I have
that's the
challenged,
reason I wanted to know.
because that it was filed by them.
Am I correct?
Yes, yes, ma'am.
That's
That
the
was
reason.
Always correct, madam.
Because of, no, I may not be correct.
I'm not saying.
I know. Actually, I may not be correct.
No, because my lord, that order, High Court set aside their petition.
Sensing that the learned single judge has clearly returned with a finding
Right.
that you have not challenged, they have not opposed
But
the
ultimately challenge,
termination.
ma'am.
Then after no, nobody is saying that you have done wrong.
Yes.
It's your prerogative.
I have challenged and there is order also, ma'am. This is the order we also.
And I am very thankful that you are fair enough.
No, madam, I cannot be unfair, madam.
No, no,
Part
nobody-
of the court, madam.
No, well, we'll never expect you to be unfair. You should not be.
No, madam. That, for the entire the client, we cannot mislead the
But
court.
I am I'm
Obliged to it.
it's a compliment
Obliged.
that you are very fair.
I'm grateful to you.
You are not unfair. Anyway,
My lord, as far as the department stand is concerned, we have filed our affidavit, my lord.
Ah.
And accordingly, my lord, the same thing I would reiterate and reaffirm, my lord, that in terms of section 6, my lord, the date of the provincialization, the power of superintendent and control of the educational institution vests with the state government. Therefore, the order of termination issued by the SMC has been passed in violation of the Act of 11, my lord, the previous year. And my lord, and also, my lord, the authority has rightly passed the order dated 15/11/2018, and my lord,
How it is right?
my lord,
When the respondent is also saying that it was not, it is a wrong order.
therefore, my lord, I pray, my lord, that since there's already a mechanism in the new act, my lord, in section 14, my lord, the matter may be again, my lord, be remanded back to the concerned authority, but detail, my lord, both party stakeholders be present, my lord, and give a reasoned order, my lord. Because
it's too late.
as they are saying that reasoned order has not been passed in the previous order,
I think
which
this-
has been, which is in challenge now.
distance point of time and it's too late. In a day.
Because there is a
We'll
mechanism, my
decide.
lord, there is a
We'll decide.
mechanism available
We'll
at section
decide.
14, my lord, if you lordship please, at section 14 of the 17
I
act.
have understood.
my lord.
They have nobody availed it.
Because, my lord,
And division bench, after the division bench order only, they have decided. So I think it would not be proper to remand it back.
I leave it to your lordship, my lord.
Now, again, same, this thing. You,
I leave it to your lordship. Because both
I have
seniors
not,
are here,
I
my
have
lord.
not decided as yet. Whatever the learned senior counsel for the petitioner has argued, you make a argument on that.
Lord,
At least reply.
I have already given at paragraph 5 and 6, my lord, our stand
This
is,
is just you are
that is
reiterating
the limited stand we
order,
have, my lord.
reiterating the orders
That is the limited stand.
or the
actually, my lord.
replica of your order only. Other day also I said
Uh,
exact ditto.
That is the limited stand, my lord, and.
So whatever
subsequent
the,
also-
no, sir, the legal issue, the order was passed, provincialization order was 27/9/2013,
13, my lord.
right?
And with effect from
And the termination has
27 April,
27.
April 13.
Huh.
So prior to the
Yes.
provincial.
Then why you are saying that the SMS was not having an authority?
Because it was a venture school. Actually. It was a venture school. at that point
Pachitar
in time.
Singh and
It was
all
a-
these cases has been referred. I told you to go through those judgment.
My limited standard, my lord, is that
Sir,
the
have you not been provided this judgment today? This is Bipron trading.
One judgment is.
Basitar Singh, that has been relied. It's one of the, on the point, one of the judgment is Basitar Singh. So no other, no more submission.
my lord, my submission is based on the limited, my lord, affidavit which you have
No,
filed.
I want you to argue on the law point.
My lord,
That's why we have to adjourn this matter.
lord, otherwise, my lord will.
You are evading,
No, my lord.
you are
Section four-
evading
I'm
to argue the law point.
Section 14, my lord, my lord.
It amounts to
My lord.
acceptance.
And my lord, there's a violation, my lord, and my lord, the authority has rightly.
There is no violation. Read section 6.
I've read, my lord. I've read. I've
From
gone
the
through
date
section
of
6 of
coming
the
into-
11 Act, my lord. I've gone through
From the
that.
date of publication, when it was published. Obviously not before 27/9.
My lord.
Should be on the same day or maybe after that. When it was published. Okay,
My lord, I leave it to your lordship, my lord.
now leave it to me. I just wanted to
Please
hear
clear
you from both senior counsel and the learned standing counsel. Anyway,
Only one aspect.
otherwise we should not have heard you today.
His order of provincialization was,
Given the thing.
petitioner's order of provincialization is dated 11/5/15.
No, after the judgment on.
Yes.
Learned single judge.
Yes,
Okay.
and he is not getting his salary because of the pendency of the case.
Huh?
He is not getting his salary.
Who is working now?
He is working.
Both are claiming matters, both are working.
Both are working.
I am also attending.
How he is attending?
You are getting the salary.
No, no, my lord, salary, nobody is getting salary.
Therefore, my lord.
Why
it-
don't
it-
you adjust
It may be
Yes. My
remanded,
lord,
therefore, it
Adjust-
will be remanded
Adjust
back, my
both of
lord.
them.
Yes, we
My
can
lord,
just.
They've been working
Therefore,
so many
my
years.
lord, therefore, my lord, let them
Furkan,
place the
Furkan,
case before the commissioner and secretary, my
I
lord.
request,
Let them verify, my lord.
no, no, I request you to.
My lord, because
adjust-
give,
adjust
my lord,
both of
my
them.
lord, at this point of time, my lord, if both have, both are claiming for the same this thing, my lord, let them verify and check, my lord.
Let them, both,
Because, my lord,
you
bo-
provincialize both the service, both of them. And giving the seniority to him. All right.
Madam, page 64, your lordship.
I agree, whatever
Kindly
suggested.
stick to
I
page
just-
64. His served, his
Correct.
provincial order has been passed,
Both doing, sir.
set aside.
No, I am on the middle part. Right.
Madam, it
Why
has
don't
to-
you appoint both of them?
My lord, I have to take instructions, my lord. on
That's.
that. I cannot give any statement today,
And
my
Mr.
kindly, my lord.
BD Das, London Council, London Senior Counsel, assisted by Mr. Swenson, London Council for the petition. And Mr. A. Fukon, Standing Counsel for respondent number,
My lord, elementary education.
London Standing Counsel, Elementary Education Department for respondent number
All the respondents, my lord, except for the private respondent, my lord.
I am for it.
1 to
He's for
6.
it.
Huh?
1 to 5.
And Mr. HRS Chaudhary, London Senior Counsel, assisted by for respondent number 8. You? Okay,
J.M. Sulaiman.
yes. Hearing concluded. Judgment reserved.
Deeply obliged.
If you have any information, come back to me.
My lord,
I'll wait for 10 days.
my lord.
Obliged.
I am appearing in item number 2, my lord.
Yes. Item 2, madam, we'll close this. You
No.
argue in the item 3 and 4.
Lordship,
Because your challenge, the challenge which you have been made in this writ petition
my lord.
is no longer there because your certificate, this degree has been accepted by the university.
Yes, they said it's a valid degree.
Then
Yes.
matter ends there.
Matter and Lordship, please to, because I was a regularly selected candidate.
No, no.
Lordship.
Here, what you have challenged.
I have challenged your lordship, the report dated 23/7/2021 submitted by the Inspector of Schools.
Page.
Lordship 23/7 is page 33. Page 33 of the writ petition, Annexure 6.
33.
Yes. With reference to the subject cited above, I have the honor to furnish herewith the detailed report along with necessary documents regarding the B.Ed degree obtained by Bharat Chandra Talukdar for compliance of the Honorable High Court order dated 3/2021, passed in the above writ petition number under so and so. In this connection, it is mentionable that the related documents in support of this obtaining B.Ed degree from SDP College of Teacher Education, TU, are seen and verified and meticulously in addition to accepting statements in his presence in person at his office on 15/7/2021 at 1:30. In connection with the application dated 15/7/14 for permission to study higher.
No, no,
education,
no.
Lordship,
You are challenging this page 34.
no, Lordship, I have challenged 23/7/2020. Let us come to the prayer portion, my lord.
What?
23/7, then 27/7, my lord. Impugn order.
23 is a
23
detailed report.
33,
Report of the
report of the inspector.
Inspector of the school.
Yes, and the other one is the impugn order dated 27/7/2023. Page 49 and 50 of the writ petition, my lord.
Just wait. Promise to study higher education, it will be stated no recording regularly or signature.
Appointment order of which was issued in my favor was cancelled, your lordship.
Hmm.
The
The petitioner Anupama Devi,
based on the report,
yes.
that is cancellation is page for 34 is what?
Page 34 is a speaking order, which was
Okay.
passed by.
Based on the report,
Yes.
that has been
Yes.
still in existence.
Lordship, unless your lordship
Speaking
interferes
order,
with it,
this
my
is
lord.
also there.
Yes.
And then,
Then page 49 and 50.
hmm,
50 is the relevant portion whereby my appointment order of regular principal was quashed, your lordship. Last 6 line from the bottom. Considering the facts of the case, the speaking order number so and so related with legitimate B.Ed degree from the SDP College Education Tihu in respect of Bharat Chandra Talukdar, an appointment order of principal dated 3/9/2022 issued from this end in respect of Bharat Chandra Talukdar as principal Boroma Higher Secondary School, Boroma, both is hereby treated to be cancelled. The petitioner Anupama Devi, Vice Principal Boroma Higher Secondary School, Boroma is hereby temporarily allowed to hold the in-charge principal of Boroma Higher Secondary School, Boroma, by Sri Bharat Chandra Talukdar, till regular principal is made and Bharat Chandra Talukdar is rewarded back to his original place. So I have challenged that. In the meantime, Guwahati University filed an affidavit stating my degree to be a valid degree, your lordship. So lordship is very much
then-
correct.
then if it is valid degree,
Yes.
therefore they are challenging your degree.
That
order-
valid order of challenge, lordship, that the certificate given by this one, Guwahati University, that in the affidavit, not the certificate, the stand taken by them, that my BA degree is valid, that has not been challenged.
So when is the item
My lord,
next cases are what?
next case is my
Two
lord.
cases are what?
Disappearing.
About what?
Lordship, we have challenged the decision-making process of the university in
Where it says that
in compliance of the High Court.
her degree is, I mean, the BA degree is valid. Huh? Decision-making
No,
process.
Anupama Devi, my lord, Anupama Devi, the second one.
What is Anupama Devi?
Devi is no longer in service. She is already retired. Now, in her shoes, the other respondents step in, my lord.
Yeah.
He sets over the matter.
Who is
Says-
Anupama for Anupama?
Anupama Devi Boro was lordship.
You are there.
Lordship, I am in Anupama Devi and next case, Lordship,
Why
the
Anupama is there? Why she was only allowed to
Lordship,
hold the in
Anupama,
charge only.
Anupama Devi and the Bharat Chandra Talukdar and the other person has appeared in the selection process to the post of
So
principal.
Anupama is serial number 2.
Serial number 2. Because of his appointment to the post of principal, I have been affected. I have been not.
No, you have been allowed again.
I have been allowed to in-charge principal. I am not getting this scale. Before retirement of the service, I have challenged the decision-making process.
And what about this? Tulsir Baraba.
He is the third person.
He is
the
third.
He is the now
Number 3.
he is now in-charge principal of the college.
He is number 3.
Number 2.
He was a number 3
Number 3.
in the selection.
Selected. He was disqualified in the regular selection process.
He was not a number 3.
In the selection process, both 3 persons has appeared. He was also selected. He was number 3.
3 out of 3 candidates, he was number 3. What is the select list?
Lordship, I will produce that. Before that,
Select list is there.
Lordship.
Number
we have
3.
Next. 69 to 73 of the read petition, 6381.
6381.
Lordship will find page 70.
Select list, he was there.
Lordship,
Number 3.
Number
I just
3.
wanted to know.
He
He was there.
yes, Lordship.
Lordship, let us see the final one. my
Page
lord.
70, Lordship.
Page 6381
Lordship,
in his 70.
page 70.
Ah,
Lordship, the serial number 1, 2, 3, 4, 5.
sir, I want the select list, not the mark sheet.
This is the selection process. Lordship, this is marks given. 17, his marks is 17, his marks
Where it is? Bharat Chandra Talukdar.
is 19 marks, total marks. Lordship got it. And the Bharat Tulsi Rabba is 17.
Huh?
Tulsi Rabba is 5th one.
Yeah, Bharat Chandra. Where does it show? It doesn't, okay. Bharat Chandra Talukdar. Third one is, what third means what? Remark. Huh? Where is the select list? This is
Lord,
not,
I'll be pasting it. Lordship,
this is mark sheet
Will you
only.
give me just 1 minute.
Tulsi Rao.
He is not a selected candidate, my lord. I was selected, so I was appointed, my lord.
So that's why, madam, I just.
My lord,
wanted to
Lord,
say,
shall I-
before we go into the
Just to give me a minute.
very. So you are the in charge principal.
And it just, lordship.
No, she has not started. I just wanted to know whether the third repetition, I mean, was it?
They have prepared the select list. They have not published any final merit list.
No,
They
no,
have
no.
published the select list. This is the select list and Bharat Chandra Talwar was appointed.
Without publishing the select list, how can he be appointed as a regular candidate, my lord? Comparative statement to this one. Lordship, maybe please to give me just a minute, my lord. Team does a select for seal. Oh, this one just.
All the responses are represented,
Yes, my lord.
department, higher secondary, higher and technical, what is, higher education,
BTC authority.
NCT,
BTC authority. He is the,
BTC
they
authority.
are the authority to selection and appointment.
Ah.
Yes, number one.
Oh, that's why I'm ensure that all the responses, all the responses
Lordship,
are.
page 34, my lord, or writ petition, that Tulsi Rabha's case, my lord.
6381, page
No, Bharat Talukdar appointment.
30.
No, no, lordship, that is not my lord. উল্টা-পুল্টা করেছে তোমার petition গুলা। ভারতত ছোঁয়া।
You show us.
No, no, you please show us. I'm not finding it. I found it, lordship, it's not coming up before me, my lord.
I have enclosed the statement of the select list where marks are awarded to the person who has appeared in interview for various school conducted by the BTC authorities.
Sir, that
তিনটা মানুষের যে নাম আছে।
I have seen it already.
No.
Page 70. What I wanted to know is the select list,
Select list. That is with the BTC.
final
authority.
select list.
That is with the BTC authority, not with us.
My order of appointment is at Annexure 9, page 37, on recommendation of State Selection Level Selection Board,
Page 39 of
page
what?
37
Of what?
of my writ petition, Bharat Chandra Talukdar.
Page 37, 37,
Yes,
37.
Yes, my
37.
lord. That is my appointment order. On recommendation of Council Level Selection Board, in pursuance of the BTC approval accorded so and so, subject to reversion without notice and without assigning any reason thereof. Bharat Chandra Talukdar, M.Com, B.Ed, postgraduate teacher, Boroma High Secondary School, Boxa, hereby appointed to the post of principal on regular basis in the scale of pay so and so. So and so. This is my appointment order, my lord.
Okay.
This person, Tulsi Rabha, doesn't come into the zone of consideration. I was selected. After my selection is done, my lord, is Anupama Devi steps in. She, lordship, challenged my order of conferring B.Ed degree. And lordship, then thereafter, this honorable court send the matter back to re-scrutinize the matter by the authorities concerned. First of all, they gave a report in my favor. Then thereafter, it was again cancelled. I filed a writ petition. Then thereafter, it was again sent back, my lord. And your lordship, while this person, Anupama Devi, retired from service, my lord, the other person skips in. He sleeps over his right previously. He didn't challenge my order of this one, conferring B.Ed degree. Nothing has been done. Now, since this lordship, Guwahati University has given, like, they have clarified it, my lord, that the B.Ed degree conferred to me is a valid degree. Lordship, they do not have any case. Because, lordship, I have got judgment in my favor, my lord. Neither the Director of Education nor the school authorities have any right to cancel B.Ed degree other than the university concerned.
Where is the statement?
Lordship,
Of the state?
Guwahati University,
Yes.
in their affidavit filed by them, my lord, in my writ petition. Page 60 of my writ petition. That's the affidavit.
Filed by respondent number
Respondent number, Guwahati University.
Page
respondent number
107.
6.
Lordship,
Respondent number 6.
Lordship.
107.
Lordship, page 60. All the counts, Lordship, all the parties are heard.
Just wait. 63. Yes.
আমি affidavit দেখাতে আসছি। Has your lordship found it, my lord?
In 60. Sixty-three.
Or my page 16. Lordship, it's the affidavit
Is
filed by
that-
Guwahati University.
On behalf of the respondent number 6.
Lordship,
Yes.
yes, my lord. So in their affidavit, they have given the report, my lord. And lordship, page 60, last portion, last page of the affidavit will do, my lord.
Para 4.
Yeah, 7.
Ah,
Para 7, the NCT stated that in a statement that the validity of the degree of the petitioner comes under the purview of the affiliating body of the institution.
I'm not getting it. There's two affidavit, I suppose.
That was filed, that was served on 31/8/2023. Received on 9/11/23. Affidavit filed by Guwahati University. Received on 9/11. There's a date 31/8/2023.
Respondent number 6.
It starts with a proceeding of hearing, my lord.
Ah,
Starts on page 55. Please pila milana ase photo logo.
mhm.
It's in Bharat Chandra Talukdar matter.
No, this is something Bharat Chandra. This Bharat Chandra only. This respondent number 6 is page this one, no? This is the one. Only affidavit in open. Represent for and on behalf of the students to the Guwahati University. She's saying, para. That affidavit, there's a one affidavit, two affidavit,
Only one affidavit.
university.
Yes, my lord.
One.
Our copy has been
Yes.
given your lordship.
23rd November 2023.
My copy is of 31/8. Lordship, it was torn by the Hemanto Kumar Nath, Dr. Hemanto Kumar Nath,
Yes, okay.
Registrar Guwahati University. I said, Radha?
This, last is para 4 only.
Here, the copy which was served on us.
Yes.
Yes, on last to nahi different. Lordship, may kindly say Roman 7, maybe 3/7, my lord.
31 November.
Annex, yes. Also, এনেকে যোৱা নহয় নহয় এইটো হয় তুমি হেৰি কৰা টাৰ্ণ কৰা পেজটো আৰে টাৰ্ণ দ্য পেজ ন আমি যোনটো কৰি আছিলো ফটো দিয়ে আৰু কৰা টাৰ্ণ কৰা আৰু কৰা নেক্সট কৰা ঠিক আছে য়েছ পেজ ইজ 72 পেজ কোনে ভুল কৰিছে সেইটো
আমাক সব কৈছে বাইদেউ তেওঁলোকে ফেল কৰিছে।
এনেকে নকৰে আজিকালি একে ইনচিডেণ্ট নহয় কোৰ্টৰ ৰেকৰ্ডটো চাই ইজিলি নকল কৰিব লাগে আমাৰ মতে নহয় ৰেগুলেশ্যন Lordship, that page, my lord. Roman 7.
You should have said annexer. I was looking in the same affidavit,
Same.
but then I was looking in the,
Yes.
looking for the paragraph in the
Oh,
main,
no, they have not
body,
stated.
body of the affidavit.
Yes, in the
This is the
annexure they have
decision,
stated.
proceedings,
Yeah, proceedings.
annexer, huh?
Yes, my lord.
Page 7.
Lordship,
Page 15.
yes. Clause 7, Lordship, this one, Roman 7, the NCT is stated in his statement that the validity of the degree of the petitioner comes under the purview of the affiliating body of the institution, Guwahati University. The same may be ascertained from university's end only. As such, from what has been observed above, it is found that Bharat Chandra Talukdar is a bona fide candidate for awarding the BA degree by the Guwahati University. As such, the committee is of the humble opinion the BA degree in question as awarded Bharat Chandra is valid. So, Lordship, my selection to the post of principal.
So far as your, the writ petition, this in 435 is concerned, since this is the valid degree, the authority has said it's a valid,
Yes.
valid one, consequential order will follow.
My lord,
Okay,
that would do.
whatever you.
Now, the next case is this. And I'll be providing the, let him start, I'll providing the comparative
Yes,
statement.
you are in respondent here.
He's
Next two
responding.
cases too, you are respondent.
Yes,
So, you see,
let him start, I'll reply.
so, this in view of the subject to what is the, I mean, the final determination of these two other cases, we'll see as of now. Are you a respondent in this writ petition?
Lordship,
Are you a respondent
I'm a responsible.
in item 2? Yes,
I'm item 2, I'm the
He's the
petition.
petitioner.
yes. No. Item 2, you are the petitioner.
He's the petitioner, item 3 and 4, I'm the petitioner.
So are you in the item 2?
Yes, Lordship.
Yes,
Respondent number 10.
okay.
Who? 332.
DBC concludes, I can start off.
No,
I have
so as of
completed.
now, since it's a question of validity of the B.Ed degree. Since the authority
Has passed the order.
passed the order that it's a valid
Valid
degree,
degree.
matter ends there. So far as of now, the consequential order will pass. Because on the basis of this, the validity of, or otherwise of the degree was, I mean, her appointment, his appointment was, I mean, cancelled or decided. All right.
Lordship, my case is, Lordship kindly see my writ petition, any one of the writ petition, Lordship, 6381 or
So you have
639.
no argument in the item 2.
Lordship, I have the argument, I will place the argument from the facts of my writ petition, I will place the record. Because they have not enclosed all the documents, I will place the record. Lordship, kindly see, my writ petition 639, 6381.
And other one is become infectious. Onupama, she is no longer in service.
Yes, what do you say?
My submission will be, Lordship, in this particular case, National Council of Teachers Education, that is the NCT is the authority who can say that any degree obtained by a person in compliance of the NCT regulation is valid degree for appointment at the post to the post of teacher. Degree is not under
Sir,
challenge.
that is main argument.
That is the main argument. First of the argument.
That is on merit. What I am asking is, what about the item 3?
Lordship, that item 3 I am arguing, Lordship. Item 3.
You were allowed to hold in charge, right? Okay.
Yes,
You,
Lordship.
you are allowed to
Hold
serve as
in
an
charge,
in charge
yes.
principal because his appointment, Talukdar's appointment was cancelled or revoked, whatever, right? So what is your grievance?
Lordship. Kindly see petition.
She is retired. How her legal right is
Just
affected,
wait.
my lord?
Yes.
Kindly see petition number 6381 of 2020.
No, sir, I'm asking.
That
before
is why,
coming
that is
into
why,
the
Lordship.
merit, yes.
That is why. Kindly see page 79, affidavit by the NCT, National Council of Teachers Education.
Hmm.
Kindly see page 77 of the writ petition.
No, definitely we'll come to that. What
Lordship.
I'm asking is, whatever this item 3,
Yes, Lordship.
we'll definitely hear you in item 4.
Lordship.
You are challenging the decision of the university, right?
Lordship.
Either way, either in the item 3 or item 4, I'm just asking, what about item 3?
Item 3, I have challenged the decision-making process of the university on the ground. Lordship will find the order of remand by this honorable court to make a decision to the NCT.
What benefit you will get?
I'll
Now
pay.
you are retired now.
I have retired before retirement of service. I have filed a petition challenging the selection and appointment of the private respondent that was set aside. Thereafter, I have given the post of in-charge principal.
Yes,
But I continued as the principal and retired from service.
yes.
And before that, I have filed a petition challenging
Was there
that
any-
my service should be regularized as the principal to get the regular scale of pay.
And is there is there any order, interim order? Was there any interim order?
Look, there is an order passed by this honorable court to give the consequential benefit. The separate petition was filed, and there is an order from this honorable court to regularize my service.
To regularize your service.
Service.
In which post?
Lordship to the post of principal.
That has been given already.
That has not been given.
That is your prayer,
That is my prayer.
huh?
That is my prayer. Because I should get the regular scale of pay as a principal. I retired as the in-charge principal.
Sir, law is very clear. Even if you are selected, you don't have the individual right to be appointed. Suppose just because you are serial number 2, how can you claim matter of right?
I cannot say matter of right, but when the
If
private,
you don't have a matter of, do the question of now you have retired.
I have retired. Only thing is, Lordship, the validity of the Bharat Talukdar is under
Is there
separate.
any kind of any rule that if the in any case in the eventual in the event the first serial number 1, merit number 1 is it cannot be the what you call appointed.
Then second will come.
Second will come. What's the rule?
Because
That
if
is not permitted. Law is very well settled. What is law says? If a person select, that is called waiting list. You
Lordship-
have the provisional waiting list.
waiting list, that is why I have immediately filed application to the authority that his degree is not valid, then I should be
That's
appointed
up to
principal.
the, you have not been appointed.
They have not considered,
They have not considered. It cannot be because law doesn't permit.
Lordship. That is settled, Lordship. Now, Lordship, kindly see.
Only one post. Number 1 goes. That will be re-election. I mean, re-advertisement, press advertisement.
Lordship, I have not that effect. Only I like to submit the facts of the case. What is the actual facts of the case? I will say. Lordship, kindly see order of remand, page 97.
Remand of what?
Page 97 of the writ petition, 6381 of 2024.
6-3. Six.
Page 97 is the order
97.
passed by this court,
Saying what?
remanding the matter to the Guwahati University.
Hmm.
Now, Lordship, I will take you, Lordship, to the page 98, relevant portion of the order.
Hmm.
Para 4, B.Ed
Yes.
degree has been obtained from the Guwahati University. There is no objection to that effect. There is no dispute to that effect. And the NCT is the appropriate authority, regulatory authority under the law as regard to the acceptability of the valid B.Ed degree. In these circumstances, we are of the view there is a requirement of the Guwahati University to take the final decision on acceptability and validity of B.Ed degree of the writ petitioner Bharat Talukdar as to whether the manner and circumstances in which the degree was obtained would be acceptable in law to be declared to be valid degree. In doing so, the NCT is appropriate authority regarding procedure and requirement of obtaining B.Ed degree of Guwahati University while taking the final decision shall in consultation with the appropriate authority NCTE. Accordingly, authority NCT are directed to cooperate completely with the Guwahati University and make the decision. That is the order of this honorable court. Now I will take your Lordship to the page 78. Page 77. What is the requirement?
70.
7. That is an affidavit filed by NCT. Page 77 is a relevant portion.
Yes.
Lordship got it. Clause 2.2. 2.2. Lordship got it.
Yes.
Working days. There shall be at least 200 working days each year, exclusively for period of examination and admission. Institution shall work minimum 36 hours in a week during the physical presence of the institution, and all the teachers or the student teachers necessary to ensure their availability for advice, guidance, college, and consultation, and when required. Minimum attendance of the student teachers shall be 80% of the all courses working and per curriculum and 90% for the school internship. That is the requirement for attendance in a B.Ed course. That is the requirement of obtaining a B.Ed degree. Now, Lordship, I will take your Lordship to the information given by the NCT, by the college, page 62.
Are you challenging the decision of the university?
That is why. That is why, Lordship. Kindly page 62.
Yes. Yes.
Lordship got it. This is the information provided by the college. Bharat Chandragupta was a student of B.Ed course 2014-15. Bharat Chandragupta was a student of day shift during period of 2014-15. No attendance records are found in institution during this period. He was a regular teacher of a college, school. And that is a day shift college. And that is why, Lordship, I will take your Lordship to the impugn order. They have challenged passed as per report given by the Deputy Inspector of Schools, Baksa. Kindly see,
That has been put to challenge.
that is under challenge. That is his challenge.
That is in challenge.
Lordship, kindly see now, page
And
93.
then university has consequently passed an order.
After reading all the parties,
uh,
NCT also.
Yes.
Lordship, I will place the judgment on these points that is already settled by this court. Supreme Court has settled this point that LLB degree obtained without attending classes as per requirement of the Bar Council of India regulation cannot be enrolled as an advocate. Though B.Ed degree, LLB degree conferred by university is valid, he is not entitled to enroll as an advocate. In the same circumstances, B.Ed degree may be valid for degree awarded by the Guwahati University, but his degree is not valid for getting the post of
Drawing an analogy.
as a teacher, analogy. That is why
When the degree is valid
degree is valid, but that degree do not confer his right to be
for,
still
for a lawyer to practice a law.
law. Same thing, he is a B.Ed degree obtained from Guwahati University without authority of law, without taking permission from the authority. Now,
Once
BTC,
it is accepted as a valid degree, how can you say that?
LLB degree also has to be valid, but he is not entitled for enrollment.
No, it cannot be. Either it is held, it is valid or not valid.
No. Supreme Court has not said that LLB
Why
degree
not
is.
saying, why not on the LLB degree, why on B.Ed degree?
Lordship, I'm also saying, Lordship.
Yes.
Kindly see page 93.
Either it is valid or it is not valid.
This is for the Lordship, the
There
BTC
cannot be
authority.
two,
It is for the BTC authority where BTC authority have accepted that or not. BTC authority, it is for the BTC authority.
no, it's
whether
not your question of acceptance. Once the competent authority issues that this is a valid degree, valid degree.
Lordship, kindly see page 93.
BTC authority would not have authority to decide what is valid or not. Of course, university may be, you may have a point, NCT and university has to decide.
Lordship. And that is why, Lordship, decision-making process, I am under challenge, decision-making process, there is no report that NCT has said that without attending the class, his award B.Ed degree is valid. There is no report from the NCT. NCT's affidavit I have shown that 80% attendance is compulsory, and he is a regular teacher of a school.
What did NCT said in the
NCT has not said anything in the
proceedings?
report. That the university's report, NCT has not stated anything. That
Where it is, let us see.
NCT has not stated anything.
The impugn
They were hard.
order, let us see.
Lordship, kindly see
Impugn
before that,
proceedings.
page 93. What
What
is
is
under
it?
challenge?
Huh?
Page 93.
That's something. 93.
3. That is a report.
This is what?
Lordship, kindly see.
This is what?
Before that, Lordship, kindly see
Sir, what is this?
page 63 before that, Lordship. Page 63, that is under challenge. Page 63 is the report from Inspector of Schools, which was sought in compliance of the Honorable High Court's order by the BTC authority regarding his attendance as a regular teacher, page 63. May I read, Lordship?
No, it's okay. What's wrong in the decision of the university? You show us, that is your challenge.
Lordship, Guwahati University report, I have challenged, I have shown already Guwahati University report. Kindly see what has been stated by the Guwahati University, page 107.
You come to that.
There is no report in the finding that as
This
highlighting
is
the
as per the direction of this court.
direction of the report.
Yes. Then,
Lordship, as per page 11111.
after perusal of all the statement records as well as documents and the conclusion of the hearing, the committee observed that
As per NCT, SDP College of Teachers Education granted recognition B.Ed course academic session 1414 by the NCT. Bharat Chandra Telur were duly admitted in the college. Bharat Chandra Telur produced NOC allowed by the Inspector of School, Bhaskar District, Mosalpur, which was in consonance with the government of memorandum dated demand. That is also wrong because the affidavit has been filed by the
how
government.
do we know?
No, that affidavit has been filed by the government. BTC authority has said no permission has been granted in this petition. As per record, Bharat Chandra was allowed to SDP College of Teachers Education to appear in the examination after submission of examination form. When college was allowed the student to appear in the examination after following the requirement, including the attendance aspect, authenticity of the impeachable of the decision to accept it and maintain as all along in normal circumstances. However, in this matter, the present principal of the college could not supply the attendance register for the particular academic session, stating that all records were destroyed as per decision of the governing body of the college.
No. So
And
how you-
already I have produced the
how
record.
you come to know that once it is destroyed, from where you got this?
Before
information?
this record, I have taken an RTI information. As per RTI information, there is no attendance.
Why you are after each other? Yeah, leave.
Bharat Chandra appeared in the examination in the particular session. He passed in the examination for which B.Ed degree was awarded by the Guwahati University. NCT in his statement that validity of the degree of the petitioners come under the purview of rating body of the institution Guwahati University, same may be ascertained from the university and it only. What is the finding regarding attendance of the college also? Because as per NCT regulation, 80% attendance in the college is necessary. And he is a
What the
regular.
NCT has said, NCT has stated in statement that the validity of degree petitioner comes under purview of the university, affiliating body of the
Lordship,
institution.
that is why I'm saying his degree may be conferred by the Guwahati University, not part NCT regulation. NCT regulation 80% attendance is necessary. I have enclosed the.
No. That's why I'm saying either it is valid, it is not valid. See, degree obtained without following the, requirement, it will not be valid. See, right? When the NCC did, it's a Guwahati University to decide.
Guwahati University decide
They have
regarding
received the degree.
attendance, nothing has been conferred.
Huh?
Without attending the class, whether degree can be awarded as valid. That is the decision to be taken by the as per compliance of the High Court order.
And the NCT was or call.
NCT was not, there is no finding from the NCT. What NCT have
What is the
to,
statement?
NCT have to say regarding attendance?
Not by way of what you have said in here in the proceedings. What is this? statement?
Nothing, Lordship.
Convener of the meeting, polling members,
Polling members only.
controller exam, when the academic register, head of the department, Guwahati. Officer Guwahati, registered Guwahati University. Yes. Ah,
The college is, basically college is recognized.
ah.
That has been said.
For this purpose, we have a, one, found it. The NCT
No, just wait. What is your statement there?
No,
11109. You are there.
by video conference.
Where it is?
It's there in the council.
The control-
Proceedings.
Huh?
It's in the proceedings, Your Lordship.
One, full one, my lord. The NCT was represented by one by DRC.
True, we see, my lord.
Platform for Google Meet. And the opinion expressed by the NCT will be sent
You-
in writing. the-
This is what? Page 101. Huh? 111.
People one.
Gagangar, RCT, so and so, and the opinion expressed the NCT was also sent in writing on the same day to Guwahati. Huh? Annexure D. What is it?
Annexure D has not been
Annexure
given.
D? Huh?
Annexure D has not been given.
Where is Annexure D?
That has not been given.
No. You have, and the opinion expressed by NCT was also sent in writing on the same day to the Guwahati University. In these proceedings, there is a one Annexure D. You are writing in writing.
Annexure D is not there.
In writing, you have appeared through video, BC.
DC.
Huh. As per NCT,
In fact, maybe we are not a party in this issue.
Huh?
6381 22
He is not a, you are not a party.
So matter may be displeased for non-joiner of necessary parties.
Yeah, but it is lordship.
So anyway, we're hearing together all the cases.
Lordship in,
Just wait.
yeah, I'm sorry.
Yeah, page 4, my lord, we are not a party meeting.
Anyway, we're hearing all the, which you are, which
case?
case you are in? Which item you are in? Which case? Item 2 and 3. Okay. Anyway, we're hearing you. All the petitions together. Yes. Okay, just.
Lordship, kindly see the report of the Inspector of Schools. Page 63. It may be noted that Bharat Chandra, as per attendance register, was absent on 2 days on leave on 29/8/2015.
Sir, we'll go after the order of this court, where this proceeding has took place.
Lordship,
All right.
Lordship is correct. My submission will
You
be,
point
Lordship,
out what is wrong in this proceedings.
Lordship, BTC authority also file affidavit.
It's okay.
Did
I will hear them.
Lordship,
Have I said that I'll not hear them? You make your submission.
that is why, Lordship, I have made a categorical submission.
You
I-
what's wrong in
I-
this proceedings.
I am saying that the decision-making process of the university in compliance of the High Court's order is not correct.
Hmm.
Because High Court has specifically stated manner of obtaining the B.Ed degree. Manner of obtaining the B.Ed degree is as per NCT regulation.
See,
NCT's comment regarding his attendance in the college is not there. That whether 80% attendance is
annexer D is there. We'll see, and we'll call for the annexer D.
Lordship.
Ah.
And Lordship can see the annexer D.
That's all.
Lordship.
That's all.
Before that also, Lordship can see all these documents because I have to show the documents, which is kindly see page 63. He is not being a regular teacher of a school.
Sum and substance, your case is that the court has directed the manner how the talukdar has obtained the degree has to be taken into consideration by the university
Lordship.
with the support of the NCT. That's all. And as per the records obtained by you, there's no
Attendance.
NOC, no attendance, nothing.
And
Which is in the teeth of the NCT regulation. That's all. Why complicated?
Lordship, that is simple case.
So what is your right to be appointed?
Right to be appointed is
In
Lordship,
case we say that, suppose we say, if we all that this, it's not a valid degree, what is your right?
Lordship. Then this second repetition I have,
Your third one,
third one.
second also not, even if second will not be entitled. Unless you have a clear-cut rule to have a waiting list or second or third in list has to be considered for appointment.
And
Reason
Lordship,
being,
and
law is
Lordship,
what settled that even if you are selected, you don't have an indivisible right.
Please, ace barred, my lord.
in this,
So your
this-
right has to be looked into.
Lordship,
That's why I said,
Lordship, I understand.
live and let live.
Lordship,
Don't be after one another.
and that is why, Lordship, I have charged in case of MBBS degree obtained by this manner.
You are looking at some chances.
MBBS degree obtained by a student. Said that Supreme
You
Court has
would
said
have
no
never,
equity.
you would not be said this, who is this? Tulasi Raba would not have, would never would have filed this writ petition if Anupama Devi was still
no,
in the job.
There are a lot of litigation regarding selection of the post of principal. Earlier occasion, his selection was set aside by this honorable court. He has filed it appeal. Bharat Chandra Talukdar and the Anupama Devi and the this person, Lordship,
It is
the
akin to
Tulsi Rabha.
It is akin to challenge to the tender matters.
Not so. Tulsi
You
Rabha.
compete,
Now, Tulsi Rabha also challenged his,
you compete with each
Not
other
the-
in the examination or by your performance.
Lordship, Tulsi Rabha also challenged earlier selection of Bharat Chandra Talukdar. That writ petition, his election was set aside by this honorable court, and thereafter he has filed writ appeal. Writ appeal was dismissed by this honorable court, and thereafter fresh election was directed to be held. And this is the fresh election, and after fresh election, this proceeding.
Who has filed that? Whose writ petition was dismissed?
His writ petition was dismissed.
Huh.
Writ appeal also dismissed
So,
earlier.
huh. On what ground?
Only on the ground that there is a procedural irregularity without going to the, that time BA degree was not under challenge. His selection procedure was under challenge. The selection was
So
not in
it's
conformity.
purely, you are not looking for seeking a justice. It's a, purely a revenge sort of, revenging or avenging each other.
No, Lordship, in this particular case, myself has extinguished my right twice in the selection process of the principal, considering the seniority of the person above me. I have
Because,
extinguished my right.
because
Two
you
occasions.
are unfortunately not in a seniority and your performance was not that up to the mark. So
No, Lordship. Earlier occasion,
what is the criteria of selection? Criterion. Selection criterion.
criteria of selection is government has issued a notification giving the marks considering the selection process, BA degree, marks obtained in BA degree, graduation,
Factor is.
10 years teaching experience. These are the criteria. And that criteria was not fulfilled. Marks was added wrongly.
Okay.
Subsequently, she called the annexure D of the university.
That's all.
Now,
Judgment,
judgment.
LLB degree.
Lordship. That is one, Lordship, 89 to SCC. I'm giving the copy, Lordship. Page 91.
Said, sorry, I think.
Here, Lordship, the regulation of Bar Council was of challenge that Supreme Court has said that his enrollment is rightly rejected, though his LLB degree is valid.
Where it is?
Last portion, 1989 supplement to SCC, page 91.
Hmm.
Last portion.
Hmm. Where it says?
The policy underlying the relevant provision of the Bar Council rules indicates that the great emphasis laid down on regulation and attendance of the law classes. The condition is specified split out when the act is read along with the rules. When so read in the plain that a candidate desiring to enrollment as an advocate under Advocate Act must fulfill the condition mentioned in section 241 or section 241C read with section part 1 of India Rules 1975. In the present case, petitioners failed to do so. His application for enrollment is rightly rejected.
Yes. This was as per rule 24
Lordship. In case of
for enrollment as an advocate.
his enrollment as an principal
Hmm.
violating the NCT regulation.
Where is the rule for enrollment as a principal?
Not enrollment. To be a teacher of a school, every candidate must have the BA degree as per NCT regulation.
Valid degree, the GED has been recognized valid degree by university.
Here also, let's say the degree is LLB degree conferred by university. LLB degree conferred by the university.
Yes.
And that did not qualify him to be enrolled as an advocate. And degree was not under challenge. But university degree is valid. I'm nothing to say the university. It is for the university to do. But his degree is not
You are
valid to the
challenging the decision.
decision-making process.
What is decision-making process?
Because the decision-making process should be based as per compliance of the High Court's order. High Court has said the manner and procedure of obtaining the BA degree. Manner and procedure is
And direct the NCT to give full support. To cooperate with the university.
That's it.
And NCT was heard.
NCT was heard with what is the finding that NCT has said that without attendance of the class, he and entitled for BA degree is valid.
Not,
as per
that
NCT.
is your claim that he has not attended.
I have produced the record, information received from the college itself that he is not
RTI.
attended
RTI, through RTI.
to RTI. And the
RTI.
RTI and inspector.
Are you sure?
Yes, Lordship, I have enclosed that document.
No, no, enclosed is something. Then you made a statement that you have obtained it through RTI.
Yes, sir. I've enclosed the documents.
Enclosed, I've seen it.
RTA,
Made a
RTA
statement.
enclosed. RTA letter also I've enclosed.
Okay,
Page 61.
it's okay.
Page 61. And the, before that also, Lordship, I can show the affidavit filed by BTC authority. BTC authority has categorically stated that
He's there.
without taking permission, he has.
Are you want to deprive him?
No, sir.
Give him the privilege.
Lordship, we have filed a affidavit in item number 24355 of 2023.
Item two.
Item 2.
Item two, I think your decision was based on the findings of the school inspector of the
Yes.
school and as per the direction of this. Now, thereafter, court has directed to decide to be decided by the university.
Lordship.
With the cooperation and support of the NCT. That has been decided now.
Yes,
So far as
Lordship.
item two is concerned.
Lordship, as a appointing authority or the government, we cannot decide upon what is valid
Yes.
degree or invalid degree.
That's exactly.
It's up to the between the college and the university.
University.
They will have to. But here, according to our analysis, Lordship, the manner in which he obtained the degree, at least it can be stated to be a misconduct because he didn't follow the procedure of taking permission from the appointing authority. Because at one time he is doing his regular duties. At the same time, he is also pursuing the B.Ed degree.
There's a cloud.
Day safety.
There's a cloud.
Yes, Lordship. And according to us, it's a case of misconduct. And since the issues are pending before this honorable court, we have not initiated anything till now. Lordship,
No, see, writ petition is filed when you have decided to cancel his appointment or whatever by speaking order.
yes, ma'am.
Now, in this writ petition, during the pendency, there's another writ petition filed by you. Another writ petition or in this writ petition only.
In this repetition only, we have
Okay,
cadence there.
during pendency only. Huh?
Yes, madam.
In this writ petition, a
Lordship.
direction to,
Madam.
verify by the,
No, that was, those writ petitions have been closed on the basis of the university report.
on which writ petition?
That was by the private respondent. On the direction, as my learned senior friend has read it out, Lordship,
Okay, filed by the.
filed by the private respondent, Anupama Devi. And here in
Okay, in
item-
Anupama Devi's case.
yes, in item 2, the petitioner has assailed the speaking order first subsequent to the university report, Lordship.
Item 2.
Yes, fine.
No, speaking order is by whom?
By the BTC authority.
Then that's before that only. Where's the speaking order?
Okay.
Where's the speaking order?
Lordship, page 49.
Yes.
Lordship, at the top line, it is stated that the petition filed by the private respondent. And there was a batch of 3 writ petition, Lordship.
1026, Anupama Devi.
Yes, my God.
So
On-
here,
And
instead of the above, there has for,
our reasoning is at page 50, Lordship, second paragraph.
B.A. degree of Bharat Chandra.
Lordship, in our repetition, it was directed. What university is directed by?
Yes, it's something. This is on Anupama, right?
Yes, ma'am.
The university on
Lordship,
university,
In this case, it's a.
order was given, your lordship, order was passed.
4355. This
Yes.
has also been disposed of.
No,
No,
43,000, our matter,
Okay, the same here.
yes.
Okay, that's why I'm asking.
Yes.
During the
Yes,
pendency
yes,
only.
Yes, 31/8/2023 order.
Yeah. Let a copy of this order furnish, okay. Yes. So that your speaking order is on pursuant to Anupama's case.
Anupama Davis,
Oh, that has been put to challenge.
that has been.
By
put-
considering, after considering that only this order was passed
Yeah,
on by this court in the
31st,
present writ petition, right?
31st August 23.
In the present writ petition. So accordingly, university has taken, undertaken a
Lordship,
process.
University has taken a decision, and that lordship, since we have no authority to declare whether this degree is
Consequently,
valid
to
or not.
follow,
The
so far as this
consequence of
case is concerned. Since the university has decided it's a valid degree. All right,
Yes, ma'am.
there may be a aberration of obtaining it, but then once it is a valid degree, in my view, it has to be considered accordingly, right? So far as item 2 is concerned. Then item 3 and 4,
3 and 4.
you are not a
lordship-
party.
No, we are a party, but it will depend upon what lordship takes a call on the process of
Yes.
declaring that the.
So
degree
you have
is
no,
valid.
in fact,
We
you don't
cannot
have,
say anything on that
yes, say
process.
on this.
lordship.
yeah. So ball is with the NCT and the university. Yes. Mr. University.
Milord, my submission will be in a very short compass.
You have filed the affidavit.
Yes,
Milord.
fine.
Yes.
Milord, as per order dated 31/8/2023, Milord,
Yes.
Milord, item number 2,
Yes.
page 63 onwards, Milord, my affidavit.
Item number 3. 2.
Item number 2,
Okay.
Case. Bharat Chandra Talu.
No, you have, after the consideration, after 31/3, only you have filed the affidavit.
Yes.
yes, Milord.
Okay.
Milord,
Okay, that I am understood. You will obviously defend, you're defending your order only.
that degree
Then
is
come to
valid.
item 3 and 4.
Milord,
They are challenging your this thing, decision only, decision-making process,
Milord.
according to them.
So, Milord, this
What they are saying is, how can you decide when the NCT requirement is to have this certain areas, I mean, certain days of working,
Milord,
certain working days. They have referred it, have you heard it?
no, Milord,
There's a requirements that
Yeah.
for obtaining this degree, these things has to be a page. What is the page? Affidavit of the NCT.
Milord.
So how can you decide against the, I mean, the requirements that it is a valid degree? Plus, what they are saying is that you have not taken into consideration the records, which clearly shows that no NOC, right?
Milord,
And all these things were obtained. And yes, they obtained these records through the RTI from the office record. Though you have said that the records, principal said that records has been destroyed.
Milord,
These are the things you have to answer.
Milord,
How you will decide the are you an authority to decide whether this is valid or not? Is it not NCT?
no, Milord, the Guwahati University, since Guwahati University conferred that degree.
Huh.
So automatically, Milord, Guwahati University had got that jurisdiction and authority, Milord.
What about the NCT?
And
What is the role of NCT and the
Milord-
authority of the NCT?
Milord, that NCT authorities have also been, Milord, called
Okay.
to the, Milord, hearing, Milord. So, Milord, in the order dated 20, not order, Milord, the concluding part on 29/9/2023 of the
Have you
hearing.
filed affidavit here?
Yes, Milord, in
3 and 4.
in
Item
three,
3 and
Milord.
4.
In item 3, Milord, we have filed affidavit.
Okay. Hmm.
Milord, repeating the same, my lord, the conclusion of the hearing
Ah,
dated 29/9/2023. The
hmm,
degree is valid.
hmm.
And so, my lord, it is as per direction of this honorable court.
When it has been obtained, without following the requirements of NCT,
One
NOC and other things.
one major aspect, my lord, on the last occasion, I have pointed out that affidavit has not been furnished to me as yet, my lord.
Of the NCT,
Yes, my lord, NCT
Okay.
and BTC, my lord.
BTC. BTC, it's okay. NCT,
My lord,
NCT has filed an affidavit saying that these are the requirements,
my lord.
and that
So-
has not been taken into
So
consideration.
I'll have to respond them, my lord, but I don't have that affidavit, my lord.
That is the repetition management, 69. They have balanced it.
639.
Is-
That is your affidavit or whose affidavit?
NCT
639. 639.
40, man.
Yes, 639.
Kuntu case.
Read petition 639.
Page 40.
Yes. Yes.
My lord, it is prior to the order dated 31/8/2023. It was, my lord, filed on 28 December 2022,
Hmm.
1 year back.
Hmm.
Exactly.
Right.
After the hearing, my lord, what is their stand, my lord, the NCP or BTC, my lord?
No, BTC, it's okay. No
Lord.
issue. BTC, I don't think, BTC now they have nothing to say. Once you said, university, the NCT says that it's a valid degree, they are helpless.
My lord.
All right.
So, my lord, it was
And they
since,
may explore some other way out to punish, initiate, not punish, to initiate something, whatever they want to do.
normally in the writ
But
proceedings,
now they were on the validity or otherwise of the B.Ed degree.
my lord.
So, prima facie, you have not taken into all these requirements of NCT regulation 2014.
My lord.
When a degree was obtained?
What degree?
14, 15. When did you admit, when you were
Re degree 2016.
16?
Nothing they have done, my lord. They set over,
No, it's okay. I'm asking for different purpose.
lord.
This is regulation is 2014. When did you, when you were admitted?
I was admitted, my lord.
Most
14,
prob-
15.
Most
session.
probably 15,
Yes.
14. Yes. So what is your stand here,
My lord,
Mr. NCT? Just wait.
Regulation.
In course from 2001, and namely National Council for Teachers Education Legal Procedure, which laid down for norms in STEM B.Ed program and all the B.Ed institutions follow B.Ed program their respective close to science and science. B.Ed degree, 2 academic years, working days, 200 working days. The students will work for a minimum of 30 years. Attending student teachers will have to get 80%. Whatever attendance was there, 80% attendance
Yes,
was.
my lord. And their case was that no prior permission was taken. That is not even required. This honorable court judgment has come up. Coordinated by judgment, my lord.
Withdrawal. Affidavit is nothing, they are just quoted the requirements, all right? Which in violation mentioned and the norms and so for a direction for inquiry and aesthetical for conducting their program. It is explicit criterion pertaining duration working days and is a subject matter of examining body, appealing body in view of the same it is for. Yes, correct. They have not said that it has been obtained in violation of this. Para 6. It is explicit that the criterion pertaining to duration and working days as enumerated under clause 2 of the appendix so and so regulation is a subject matter of the examining body. That is affiliating body, in this case university.
University.
In view of the same, it is for the affiliating body strictly adhered to the norms and regulations laid by NCT. What we'll have to see is whether NOC is not a requirement, whether there is a attendance of 80%, whether he has, whether he or she has spent 2 hours, 2 years. These are the requirements. NOC is not
Because he's
required.
a regular teacher of a school.
If NOC, it's up to them. That's what I'm saying. They said, because of the pendency there, he said it's a misconduct. It's a
Misconduct.
different ball game altogether.
Practicality is, Lordship, he is a regular teacher and day shift college,
Sir,
and
what I'm
he
saying.
attending day shift college. How
This issue
simultaneously,
is a different ball game altogether. Whatever they want to do, if it's a misconduct will be that will
equity
different
did not
thing.
come in favor of the person. who has-
Therefore, whether this degree is valid is or not, unless they say there's something very glaring
Affidavit
that
should-
there's no, he has not obtained it after, I mean, pursuing for 2 years, number one. Number two, there must be an attendance of 80%, that's all. Whether he was in the regular teacher, regular job, who do we know?
But the finding given by the Guwahati University, the manner and procedure of obtaining degree, that has not been stated.
Record. Thank you, that's all. Can you furnish the annexure D?
Annexure D, they have to.
Do
Milord,
you have the annexure D?
Milord, may I take your lordship to page 92, Milord,
Of
of item number 3,
69,
639,
yes. 90,
92,
okay.
the hearing proceeding, Milord, the
Yes,
relevant portion.
yes, we have seen it. That's the reason. I'm asking for
92,
annexure 3.
next 93, Milord.
Yes, annexure 3, annexure D.
Page 93, Milord.
Yes.
The
annexure D.
NCTE was represented by so and so
Hmm.
through online mode, and the opinion expressed by the NCTE was sent in writing on the same day to the Guwahati University, Annexure D.
Yes.
So, Milord, the NCTE has taken part in that hearing proceeding.
So would like to see what is there in annexure D. Annexure D, you should have read already.
Milord,
You have read there right now.
page 93,
Yes,
then,
in
Milord,
bracket it said bold letter, annexure D.
Annexure D.
In writing, they have furnished their opinion.
Milord,
It is annexure D. You produce that.
I'll produce, Milord.
Anything else?
May I have to produce the certain judgments? Do not have to.
See, you cannot deprive the senior
Their
lawyer.
case was no permission
We
granted.
cannot deprive senior lawyer.
Lordship, they said that no permission was granted to me because I was in another school.
Okay.
I fairly submitted my lord after attending my regular classes because it takes your lordship search to Google. It takes only 17 minutes to attend the paid course, my lord.
Okay.
So your lordship, after attending my regular classes, after taking due permission, I have attended the B.Ed degree, your lordship,
That's how
B.Ed
this period
classes.
will not go.
Now this honorable court comes up, lordship, this honorable court by order dated, a coordinate bench, my lord, dated 15th of 2025. The permission even not required, my lord. Dayananda Bhuya was the state of Assam.
Yes, sir. Madam,
Sir, let's hear.
right.
Subsection number?
No, no,
For
excellent.
petitioner in the WPC 4355 of 2023.
Six.
Just read. Dayanand Bhuya versus State of Assam, WPC 416 of 2024.
Then another judgment, Honorable Calcutta High Court, my lord. I'll be providing the copy,
Saying what?
saying that no authority other than the university can cancel the degree.
It's not enough.
But I'll be placing.
Where is the Supreme Court judgment?
Supreme Court judgment, I have not brought.
Mr. Ekramul Bari versus Mrs. Aparna Ghosh, WPC 2957 of 2013, Calcutta High Court. For this, in petitioner, Mr. Goswami, in 69 of 2024. Baldev Raj Sharma versus Bar Council of India and others. What is reported in 1989? Supply 2 SCC 91. Right. 1989 supply 2 SCC 91. What is this?
On the ground of waiver, my lord, what is the indefeasible right of the repetitioner? Tulsi Rava. I'll be placing AR 2013 SC 1613.
I think is it required?
Lordship, I think your lordship prima facie facially satisfied, my lord. We have got a
Not
case.
that,
my lord.
not that.
But I'll be just placing the prayer portion,
The
my lord.
facts of the issue of the present matter, will it be required? Is it
Won't be
necessary?
required, my lord. I'm just placing it. Take us. Lordship, I'll be just placing the, relying on my lord, I'll be referring the prayer portion of repetition.
Of
What
your writ
what was
petition.
their prayer?
Of your writ petition.
No, not mine. Tulsi Rava, who had challenged my main.
I'll see, I'll look
Right.
into it. I'm
Right.
not dictating order right now.
Right.
Had MS D. Buya, learned senior counsel assisted by so and so. Then counsel for the petitioner in WPC 4355 of 2023. And respondent number in other two
Oh, right.
writ petition you are
Yes,
responding.
my lord.
And respondent number so and so.
18 Tulsi Rava matter 6381.
In the other two, 69 of 2024 and 68 one of 2024. Yes, sir. And also I have MS SK Goswami, learned counsel for the petitioners in both these 69 and 68 one. Okay. And respondent number in item 2.
In item number 2, I am respondent number 10.
10 in WPC 4350. Right.
Milord,
Mr.
PJ Fukan,
PJ
Standing
Fukan
Counsel,
for
Guwahati University,
University.
for respondent numbers. Milord,
Respondent.
respondent number 6 in two.
It's okay. Respondent University,
Milord.
Guwahati University, then
I am for NCT.
IN for NCT. Respondent NCT, huh?
7.
We'll fix this
Day after
matter
tomorrow.
Friday, only for production of
Yes.
Annexure D. All right,
Milord.
no further hearing.
Lordship,
Anything
Yes, Lordship.
you want to?
I have given a judgment of the Supreme Court relying this, Calcutta High Court has allowed the writ petition that university has conferred a decree, same cannot be set aside by the Bar Council, allowing him to enroll as an advocate. Single judge has allowed the Calcutta High Court division bench of affirm, thereafter Supreme Court has set aside.
Which one? Why Bar Council? Why not BA degree?
Lordship, BA degree regarding this point, it has not come out, charged out. And in case of MBBS degree, I have found out. Generally, these are points do not come, Lordship.
Bar Council of India versus Aparna Basu Malik and others, 1994, 2 SCC 102. That's one. That will be in a separate seat. Separate seat. Here, hearing to continue on 6/6/2024. Mr. On that day, Mr. PJ Fuka, sorry.
Standing council got invested. Annexure D.
To produce the, what is that, annexure?
Annexure D,
The
page 93.
opinion of the, to produce the copy of the opinion of the NCT,
Miller.
placed before the university during the course of
Hearing.
proceeding. Where is that, where is that proceedings?
Miller, page 80, 92 and 3, Miller. 93, Miller.
Proceedings dated
29/9/2020.
12/09/2023 as Annexure D recorded at para 111 of WPC 6181 of 2023.
Yes, sir. Record also, Lordship.
Huh?
Record of the proceedings.
What record?
Record of the that resolution. That will be relevant, Lordship.
This is a
Because-
resolution only.
Their record, Lordship, regarding resolution.
I think
Record
annexure
What
D will be.
resolution? This is the resolution only
No, resolution,
of the NCT.
resolution of the NCT as well as the record given by the college. Record given by the college.
Record they have not produced. They said that it has been destroyed because
Destroyed,
so
but they have submitted something, Lordship.
what submitted?
I presume hearing is concluded today, Miller. Then
And
again, Miller,
No more hearing.
I'll
Only
furnish
for
that annexure D
production.
only, Miller.
They will be listed, but in any case, or if I need some clarification, if you want to make some clarification, not the argument,
Yeah.
you may,
It's highly obliged.
only for 5 minutes
Highly obliged.
on that day.
Most of this.
As part of your lordship?
No,
Huh?
judgment
Yes.
reserve.
Not reserved. It will continue, but with the understanding that no further argument,
Yes.
only for production or any
Clarification.
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 From,
So it will come up in the
What's
column to be spoken to or
no, it will
For
be
the
listed for hearing only.
Hearing.
Listed for hearing only.
Obliged.
as part of your lordship?
Yes.
Part heard.
But in this case, my lord, I have highly affidavit reply yesterday, my lord.
Saying what?
My lord, to the affidavit in position filed by the respondent number 5, my lord.
Yes, who is respondent number 5?
Yes, my lord.
Who is
So,
respondent
I
number
am,
five?
my lord, I am.
Yes,
My lord, the said affidavit filed by my senior friend, it is not there on record. My
who is
lord,
Prabha Kumari Bora?
I am Prabha Kumari Bora.
Who are you?
My lord, I am the legally wedded wife, my lord, the legitimate wife.
Which number?
Number 2, my lord. The earlier wife died,
You are
then
number 3.
Yes, my lord.
history.
She left, thereafter petitioner got married.
Okay. Who has been given the family
No.
pension?
Nobody has.
Not,
given-
no one.
Not
can-
yet settlement.
Not
How do we decide? Who is what?
my lord.
Who is what?
My lord,
You have deserted, you have left your husband.
No, my lord, I am
Was
not,
any
Yes.
legally, the valid divorce?
my lord, I was getting
divorce was
the
not there, but.
Divorce-
How they
maintenance I
how
was
they are
getting.
separated?
Yeah, the-
125 CRPC maintenance I was getting also, my lord. It is there on record,
How they have separated?
not separated. my
Not,
lord.
in fact, they are not separate.
Or
but-
then your marriage is, are you Hindu?
Yes, yes.
Hindu?
It is void, my lord, section
It's a void.
11, void, my lord.
Void, in fact, void, my lord.
No,
Void,
But
my
in
if
fact-
it is in fact, what's the
But the
entitlement?
children of the say, third petitioner.
Yes,
my lord,
they'll get.
They will get, my lord. That is the issue, my lord. only.
Huh?
That is the
But
issue.
they have not
You are
come,
not
my lord.
entitled.
My lord, the minor children will get.
Huh?
But they have not come before this honorable court, my lord.
No, she is.
They will
They
also
will
have
just
to
say
come.
petitioner had already annexed the.
No, no, no.
They
They will have to,
birth
Are you
certificate of the-
representing them also? Huh?
They have not met party, but the petitioner, my lord, they annexed the birth certificate of their children, my lord, and that was disclosed, my lord.
How old they are now?
My lord, right now, my
What
lord,
is the age of these children?
my lord, one was born on my lord in the company. One was born on 12/1/2014, my lord, and another one 24/4/2012. So, my lord, ultimately they will 10, 11, 12 years,
You implead them.
my lord.
You yourself represent
lord,
and
my-
implead them.
Yes, yes,
All right.
my lord.
Heard Mr.
Yes,
So-and-so.
sir, my lord.
Then, Mr. Have you received the reply?
Yes, my lord. But yesterday only it was filed, so it is not on record also.
So it doesn't make a difference. What he says,
Yes, my lord.
what he's saying.
He's saying that he doesn't have a right, my lord, per se the petitioner, but children have a right, as my lord has pointed.
He said so. He said so.
It has fallen from
Yes,
my
my lord.
senior
It is
friend
there.
only.
Then we'll dispose of that way.
My lord,
Because, my lord, it is a void marriage under section 11 of the Hindu Marriage Act, my lord. We are all Hindus, my lord.
in the terms of the Rameshwari Devi case, my lord.
Children, my lord, there is no
Children-
quarrel to that.
Heard
Rameshwari Devi
Mr.
is-
So-and-so, learned consultant, the petitioner who submits that he has filed his affidavit in opposition, affidavit in reply to the affidavit of opposition filed by the respondent number 5.
Five.
But the same is not on the court. Registered to verify and take the list after 4 weeks.
My lord,
Mr. So-and-so, learn counsel for the respondent is present.
my lord.
After 2 weeks.
Yes, ma'am.
Well,
I am deeply obliged. my
Obliged.
lord.
Please, your lordship, withdrawal may be taken after some time, lordship.
Why?
Conducting counsel is on leg.
Lordship, then Lordship may fix the matter on any other day.
Where is the matter?
Lordship, in this case, Lordship, they are claiming for the promotion from grade B to grade C, Lordship. In this case, it is a time-bound promotion, Lordship. Otherwise, also we have not given only because of the his criminal case is going on, Lordship.
Yes.
Yes,
Lordship, at two.
Why don't you adopt seal cover?
Lordship, already seal
Is
cover
it-
is
is
there.
it outdated?
Already, they are placed under seal cover, Lordship.
Already placed under.
And this is time-bound promotion, Lordship. Lordship may
It's
fix it.
already, it's already in seal cover.
Yes, Lordship. Yes.
So matter ends there, what's there?
They are,
So
claim-
have you said so?
Yes, Lordship.
Alright.
Lordship may use our affidavit, Lordship.
A2,
At
A2, you call your senior. You plaque mark that page.
Please, Lordship.
What
Uh,
they are seeking is,
please-
the admittedly criminal case is pending.
Yes, Lordship. And
You are,
criminal
o-
case,
you
criminal
are
case,
for,
I am for the oil in the limited, Lordship.
huh,
And criminal case under for moral turpitude.
whatever.
Yes.
Have you put the proceeding has been taken and put it in the seal cover?
Yes, Lordship. Page 20209,
It's
Lordship.
okay, you place that only, if they, that is what he wants.
Lordship, now they are claiming for the ad hoc promotion already because.
No, we'll not all do all these
Yes.
things. We'll say, once you have adopted the seal covered procedure,
Yes, Lord.
all right?
Yes.
You show other, then we'll dispose it of, nothing.
Lordship, may kindly peruse the page 206 of our affidavit.
206.
Yes. It started from 203, Lordship, promotion.
206.
It started from page 203, promotion order, Lordship.
203.
And 206, Lordship, page.
Permission to grade B to
Grade
C
C.
in level 1.
Yes,
huh?
yes, Lord.
This is the post
Yes.
he is seeking.
Page 206,
Then
last, Joydeep Nandi. Name of the last.
he was imposed with measure withholding of permission so of 18 months and also permitted to be placed in seal cover and also promotion to be placed in seal cover due to ongoing training.
Next, page 207, Lordship.
Hmm.
Roman 2, Lordship.
Huh.
Sri Nandi has completed the required span for promotion from grade B to C in the level 1 and is to be considered for promotion with effect from 1/1/2022. However, he was imposed with major penalty of withholding of promotion for a period of 18 months by the disciplinary authority by order date so-and-so. Also, criminal proceedings are ongoing against him as per available records with us. Hence, as per clause 1, Roman 3 of the guidelines on seal cover procedure, his promotion will be placed under seal cover procedure. Circumstances leading to seal cover procedure arise after recommendation of DPC, but before he is actually promoted. And Lordship may.
Only
Oh.
under seal cover.
Yes, Lordship.
And
He
mine,
will- He
mine,
will
my,
be placed under seal cover.
yes, Lordship.
Where
And
it
my,
is?
Lordship. Minutes also dear Lordship, minutes of the review committee meeting,
Hmm.
that minus 231 Lordship.
231.
231. This is
Yes.
September 12, 2000. The review also was done, Lordship.
Hmm. Review of the cases under seal cover. Okay, this is of
12
20
September
24.
2012. Yes, Lordship. This was communicated to the petitioner also.
Then, has he filed any documents?
Lordship,
Has he brought on record?
Lordship, we have annexed this, Lordship.
No,
and-
no,
and-
has he brought on record this fact? This has been communicated.
Yes, Lordship.
So what
That
you
is,
say-
that is not
What
communicated.
you have said,
Yes, Lordship.
what you have said here
Lordship, page 231.
is still under continue,
Yes, continue.
is still under seal cover.
Yes.
Page, yes. Review of cases under seal cover procedures, Sri Jadip Navsandra. Where it is said?
But regarding ad hoc promotion as claimed by the petitioner, that was not considered, Lordship.
No, no, that cannot be.
Yes, Lord.
Where it is?
Page 233, Lordship, last
Ah.
paragraph,
For
6.3.
opinion, ad hoc promotion should not be granted to so and so of this so and so, the charges against executive of remuneration. Where is seal cover again? You still put on
Yes,
seal
yes,
cover.
is still,
A part of conveyance of seal cover, also a moral authority. Where it, in view of the above, we propose not to grant ad hoc permission to so and so, and the policy of seal guidelines on seal cover procedure. So it's still put under seal cover.
yes, and paragraph 34, Lordship, of page 168, wherein we have stated that this is a time-bound promotion, is a time-bound promotion and not a vacancy-based promotion, and therefore he can be promoted accordingly. However, subject to disposal of the said criminal case. So this is time-bound promotion, Lordship. It is not that case.
Lordship fix.
You note down that and appraise your senior.
Obliges.
Hello.
Continue it. We'll take it about two.
Please, your Lordship. Lordship, item number 14, Lordship.
Hmm.
Today some difficulty, Lordship.
14.
Lordship, item number 14.
Why?
London Senior Counsel, RP Sharma has to leave the court for some personal difficulty, Lordship. Lordship, I
On the prayer of Mr.
PN Sharma.
PN Sharma, learned counsel for the petitioner on the ground that Mr. R.P. Sharma, learned senior counsel, leading in this matter, has some personal difficulty today. List this matter after 4 weeks.
May I pray for fixing a date, Lordship?
Please, your Lordship. Lordship, item number 8, my lord.
Yeah.
My lord, I appear for the Cotton University, my lord.
Ah.
My lord, basically, it would be between the education department and the petitioners.
Hmm.
Today, after some time, there might be some difficulty, and I'm told Mr. Gogoi is also on legs. He has some other problems. my lord.
Who is Mr. Gogoi?
The Standing Council Education, now additionally.
So what is to be done?
Lordship, the financial accreditation of the.
No, what is to be done in that case? 8 and 9.
Yes.
8 and 9.
Lordship.
Okay. On the prayer of Mr.
Mr. Gogoi is.
Ah. Adjournment.
Lost any damage.
2015 matter. What is there? Is there anything left?
It is
Yes,
there, Lordship. If
Lordship.
they succeed, they will get the benefit, Lordship.
Financial level.
Financial upgradation.
Yes, Lordship.
Otherwise, issue is almost settled, Lordship. Lordship, push
But
the-
settled was there. How it is settled?
It's not said, Lordship.
Lordship, as per our High Court judgment, Lordship, they are not entitled that part, Lordship.
Show it to her.
So, Lordship, push the any day, I will.
Any date, Lordship.
Okay. On the prayer of Miss, who is asking for the prayer? I mean,
Joint pair, Lordship.
on the joint prayer of learned council for the parties. Hold on it. Let this matter be listed on after 4 weeks, 3 weeks, 4 weeks, 4 weeks, sir.
Lordship.
As a last chance. Two thousand fifteen matter, I didn't realize.
My. Deeply obliged.
That is the lordship. Here in this case, there's a procedure, the seal cover procedure that has been given so far as the petitioner is concerned. And this
Review has also been done.
exactly, lordship. In the year 2021, the petitioner was placed under seal cover procedure. Now I'm just referring to the provision, relevant
Two
provision.
thousand twenty-four is been.
I'm just
Still
ref-
the criminal case is pending.
Exactly, yeah.
The grave, I mean, the charges are
And
there.
the FIR was lodged in the year 2000. And now
What
it
is
is,
the, what is
now
the offense?
2020, the FIR,
Offense charge is what?
the 254D, it's
Ah.
a stalking,
Ah.
and the 66C and 66D of
Involves the
the
moral turpitude,
66C and 66D.
Serious offense.
involving the moral turpitude.
Lorships, the thing is that in my representation that has been given by the
You
petitioner.
say that
Yes.
it should adopt the seal cover procedure.
Yes.
They have already adopted.
No, the thing is that lordship, I'm just by this representation that has been submitted, I am praying for ad hoc promotion because of
No,
the
that has been rejected.
yes, lordship, that has been
Then-
rejected because of the pendency of the criminal case. Now, if you want to kindly see the guideline of the seal cover procedure, I'm just referring to the affidavit in opposition that has been filed with the well.
It's okay.
Lordship,
If you are-
kindly
if
see
you
the
are-
page
if
number
you-
one
Are you
sixty-four.
challenging that the last communication, last review consideration of seal cover? Page, have you, do you have the affidavit?
Yes.
231.
231.
231. We'll close it and you challenge that if it is not been properly, considered in the review.
Yes,
Your prayer is for adopting, to
Exactly,
adopt the
Lordship.
seal cover. That has been done. That has been done.
exactly.
No issue.
Now, the fact is that
Even
lordship,
after review was done, your prayer has been rejected.
And
no, lordship, my representation was with regard to the, I'm just referring to my representation. Lordship,
It's all
kindly
right.
bear for a moment,
It's all
lordship.
right that
Yes.
2004, they have revised your seal cover. And then your ad hoc permission has been, you read that
Page lordship 235 lordship.
235,
Page 235 communication to him lordship.
huh?
We have already communicated about our decision lordship. Page 235
235.
or affidavit lordship.
Subject request for ad hoc permission from so and so, yes? This
Yes.
is communication, where is this order?
Order 231.
31,
Yeah.
an extra R11.
You challenge that if you are agree. There is
Now
no
also,
challenge
lordship,
to
I can
this.
take the liberty by amending the writ petition. Otherwise, again, I have to file another writ petition.
No,
lordship.
this is a fresh writ petition. File a
Because-
fresh writ
because-
petition. File a fresh writ petition.
Giving a liberty, lordship.
Yes. Because there's nothing in your, in its prayer, nothing is there. You have only prayed for adopting seal cover procedure,
Yes.
which they have done.
But the fact is
Not
that.
only that,
yes.
in the meantime, you have.
No,
sought for
subsequent to that, lordship, the representation.
subsequent
yes,
representation saying that it should be on ad hoc permission.
Ad hoc promotion, that has not been
See,
considered.
even the promotion is not it's not a right to be promoted, only
But the ground, yes, consideration,
Ad hoc, where the ad hoc comes.
because the.
It's up to them if.
No,
you-
lordship, I'm just referring to the representation. If your lordship kindly bear for a moment.
No, no.
In the representation, I have made
You
a.
challenge this. It has been communicated to you.
Yes, yes. Lordship can give a liberty for challenging.
Yeah, and Mr. So-and-so, learned counsel for the petitioner. Next para, Mr. So-and-so, learned counsel. Having been receipt of the order dated 12/2024. Passed by the company, 12/09/2024,
Chief General Manager.
passed by the Chief General Manager, within bracket HRD. Oil India Limited. Whereby his prayer for ad hoc promotion has been rejected. Submits that he may be allowed to withdraw the present writ petition with a liberty to challenge the same, challenge the order dated 12/09/2024, if so advised. Not if so, Mr. Mr. So-and-so learned counsel for the petition.
I am for all the
The standing counsel.
I am appearing on behalf of the A. Sharma, Learned Standing Counsel. I am K. Kolita, Lordship.
For all the response.
On behalf of the
Is
Learned Standing
present.
Counsel, A. Sharma.
Is present, huh? Next, having considered that the prayer made in this writ petition is for adoption of seal cover procedure during the pendency of criminal trial. Criminal trial. And the and for basically that is for adoption.
Consideration for ad hoc promotion.
There is a prayer here.
Yes,
And consideration
for
for
ad hoc.
promotion. As well as the which the petitioner has, which the respondents have already undertaken. And by way of review of the seal cover procedure in respect of respondent petition, the prayer for subsequent, the ad hoc promotion having been rejected, I'm of the view that there is no surviving course to be executed. Accordingly, prayer for withdrawal is accepted. And the writ petition. No, does writ petition still dismissed as withdrawn?
Giving liberty
With the liberty
to assail that particular.
liberty to express for. As liberty express for.
Hello.
May I please address?
Yes.
So this is a case whereby the service of the petition has been terminated, Lordship. Because of the fact that, Lordship, the time of his joining, he issued an affidavit, Lordship, as per their clause of the advertisement, showing that, Lordship, at the time of his appointment, there was no criminal case pending. This is the basic issue, Lordship. Subsequently, Lordship, it was perhaps come to the knowledge of the responding authorities that there is a criminal case pending against him. And accordingly, a so-called notice was issued to this petitioner.
Who is for respondent?
Lordship, by the state, Lordship,
State, which department?
the Home Department,
Huh?
Home Department.
Who is appearing? Who are disposing it of? What is the judgment?
Judgment of?
Where is the judgment of the Supreme Court?
Yes, Lordship. The judgment that I have referred my writ petition, Lordship.
Give that copy of the judgment. Who is for respondents? How many judgment?
Lordship, 5 judgment I have referred.
Why 5 judgment? Give the latest.
Lordship, latest is.
Latest. Latest might have
Yes,
referred the
latest
earlier
is-
4 judgment. Then. Yes, Goswami sir. We are allowing the writ petition.
এটা কোনটো দিলা তুমি?
রবীন্দ্র
হ্যাঁ?
রেফার করেছে রবীন্দ্র।
রবীন্দ্র তো?
Admittedly, there was a concealment.
Yes, Lordship.
In the Pende case was
That's
with the family members.
এটা কোনটো কৰিছে কি?
রবীন্দ্র।
Was the complaint? Who was the complainant?
His elder mother, Burma, which is.
Elder mother,
Yes.
ah.
The family dispute was there
Family
regarding ancestral
dispute.
property, yes.
It has nothing to do
Yes,
with integrity and It doesn't involve any moral turpitude.
Lordship, it was so person again.
We're admitting, I mean, we're accepting what you are going to make.
Yes, Lordship, because this is here in this matter, Lordship, is the discipline force, Lordship, here in this case. And
What is the case?
Lordship,
What was the case?
no, the case is that Lordship, his
What Supreme
concealment.
Court says,
The Supreme Court
it
stated
has to have a
it is
bearing on the job.
yes, Lordship.
What is the section? What is the allegation? Yes, what is the allegation?
Lordship, allegation is Lordship that I have any the judgment also.
Huh?
Yes.
Not judgment, allegation.
The allegation was under section 294, like if using of Lordship.
Judgment of what? Judgment of what? Huh?
Judgment passed by trial court, Lordship, whereby he has been acquitted.
You have been acquitted.
Lordship,
Where it is?
Lordship.
No,
In
it
page
is-
number, Lordship, 46,
46.
Lordship.
Section 447, 294,
Yes.
325, and 34.
Yes.
This is the subsequent development, Lordship. But so far, Lordship, the matter is concerned when the petitioner obtaining the appointment letter.
No, I
Yes.
wanted to know what is 447, 294,
447 is a criminal trespass, Lordship. And 294 is the obscene language. 325 is the heart. It is
Between whom?
Uh-huh.
Who is the complainant?
here-
Elder mother.
Elder matter, Lordship.
you can from here, Lordship, this is a informant Srimati Alpana Hazarika.
Yes.
We cannot say that from this judgment, we cannot, this order, we
He
cannot
is
say.
saying his elder mother.
Lordship. But see, one thing is that.
Who,
What is,
who you are to this?
no, this, we are not disputing the judgment, Lords. But, no.
Are you change, can we change someone's relation?
No, Lordship, this is the basic things is that.
The requirement is
the
you
approach
should
of-
not conceal anything.
No, the approach of the petitioner to obtain the appointment letter have some lack, it is, he concealed and have some mind, Lordship, it is a fraudulent mind, Lordship. Yes, because after knowing the fact that he was proceed in a criminal case, and in the column of the any criminal cases are pending or not, he stated no. Have some minds, and it is that he is approaching for discipline force. That is the issue.
Where you, have you been, after the appointment, have you worked?
Lordship.
Did you
after-
work?
Yes, Lordship, I have completed my Lordship, even I have completed my basic training also.
Thereafter?
Thereafter, Lordship, I was posted in the head office.
Okay.
In between, Lordship, some information received regarding it. Now, we have
Posted
been
and you have worked also?
yes, Lordship.
Okay.
So subsequently, Lordship, now both the parties have been deciding, Lordship, peacefully.
So what Supreme Court says?
Supreme Court says, Lordship, sometime when Lordship, the person in young stage, basically, when at the time of his appointment, he was Lordship 21, 22 years. Some indiscriminate Lordships of unintentional sort of mistake may be happened, Lordship. So that should be condoned, Lordship. First thing. And second thing is that, Lordship, the offense that has been, the nature of the case. Here the nature of the case, Lordship, is a purely civil dispute, Lordship, because the
No.
title sheet is going on.
325 is not the civil
That's true,
dispute.
Lordship.
It
Text
is
of-
the criminal, it is a
Text-
grievous
Show me,
harm.
wait, your
Yes.
turn will come.
Only sections are there, title sheet is also.
Where
still
is
going.
that, where is that judgment?
Yes. Page 46, Lordship, that I have read.
No, yeah, the paragraph.
Judgment, yes, Lordship.
Jean Valjean
Lordship,
in Victor Hugo's novel Less Miserables.
yes.
Have you gone through this, Mr. Goswami?
No, but regarding the Supreme Court case, Lordship, I'm not gone through that, Lordship.
Quoted in my reply, Lordship.
Character of Jean Valjean
Yes.
Hmm?
Repetition, sorry.
in Victor Hugo's novel.
Reply to
Repetition, Lordship.
You read this novel Less Miserables.
Yes.
Victor Hugo's.
Page number 13.
Para, which para you are
It's
this-
para, Lordship, 8 in page. Para 8 of Lordship, this Sandeep Kumar judgment of 2011. 8, 9, 10. And in
Sandeep
Avtar Singh case, also I have also referred to para 34, 35, 36. Page number 13, 14, sir.
it to 13, not to read it.
Sir, para.
Para 8, Lordship, is Sandeep Kumar judgment.
Huh?
Para 8 of the Sandeep Kumar judgment, Lordship. I have quoted in my writ petition also. Yes.
While looking at this judgment, Rabindra Kumar.
Rabindra Kumar judgment, yes, Lord.
He ref-
Para number 30, Lordship. Para number,
30.
yes. Lordship may come to para number 20 of the judgment, Rabindra Kumar.
Para
20. At Lordship, internal page number 6 of the judgment. The law on this issue is settled. Yes.
yes, Goswami.
Lordship, the contention of this paragraph, Lordship, it is contention of this paragraph 30, Lordship. It is that, Lordship, in our opinion on the particular facts of the case, we do not think it can be deemed fatal for the appellant board grossing every non-disclosure as a disqualification will be injustice, and the same will tremendous to being completely obvious to the ground relates obtaining in this great vast and diverse country. Each case will depend on the facts and circumstances that prevail thereon, and the court will have to take a hostile view based on objective criteria with the available precedent serving as a guide. It can never be on size fits of steno. Now, Lordship, contention of the case may be different. Here we have to go. We have to see the contention. Now the contention is that the petitioner, when selected, Your Lordship, when he was selected, and when the authority stated that you have to disclose about any pendency of the criminal case, after knowing the fact by the petitioner that he was a pendency of the criminal case, he stated, he delivered in his affidavit that no criminal case is pending, Lordship. Therefore, Lordship, the intention of the petitioner in the eve of joining his service is not in a clean hand, Lordship. And therefore, we are on that, Lordship, because this, he approached for a disciplinary force, Lordship. এইটো কি আছে বস্তু? মানে হেৰিটো Lordship, if your lordship will fix the matter in the day after tomorrow, Lordship, I have some coordinate bench judgment on this regard, Lordship.
I am aware on Supreme Court judgment.
No, Lordship, but Supreme Court judgment is not definite, Lordship.
This is definite.
No, it is not definite because Supreme Court judgment stated that every case there have the separate issues that is discussed. In that case, which is subject matter of the this Ravindra Kumar may not be the same of my case.
Where is your requirement?
Lordship,
Where is the requirement?
Lordship, I am not gone through the minutely to this judgment, Lordship.
No,
All
no,
the
not this judgment.
Yes.
Where is that requirement?
My
of-
requirement, my requirement. Yes, Lordship.
Following are the terms and conditions of service of appointment.
That is a page 27.
Candidate, any of the, which clause?
Yes,
Page
it is
28 clause 6.
page 28, yes.
Appointee shall also have to submit notarized affidavit as per provision first will be determined so and so format of the is up to report of this. Where is this? Where is this permit? Clause 3. Any selected candidates for class 4 post found to be, you are class 4.
Lost.
Class
Yes,
4.
constable lost.
Yes, it is class 4 post.
Lost.
Found to be overqualified, found to have suppressed information about our education in terms of advertising and during entry in service.
Annexure 1. No, annexure 3.
What is the other criminal thing? Requirement of submitting penmanship.
Even if lordship go by the lordship the impugn order, that is also lordship not as per law because
Sir, I am asking what's the requirement?
is notarized affidavit of clause
Furnishing the,
6 laws. Page 28.
No, but Lordship, Annexure 1 is not enclosed here. Because there is a personal department OM, Lordship. On the basis of that OM, one Annexure 1 is
That is
was
part-
prepared, Lordship.
So that the next video reply.
No. That and
appointee shall have to submit a notarized affidavit as
Yes,
per
Lord.
provision
Yeah.
of, so what is the annexure 1?
yes, therefore Annexure 1 is not
Their notification says that is not with us.
Annexure 1.
Sir, first we'll have
Yes.
to,
Lordship, notification is not with us. Lordship.
not the notification enclosure, annexure 1.
Yes. And except for format lordship the affidavit.
Yes.
This is lordship subsequently you have got it. এখন
Where the requirement is to be,
দেখেন এখন
It will be on. In Annexure 1, you know, Annexure 1, your lordship, that
this is the format,
this is the
affidavit format.
Lordship, in paragraph 4, in that format, I hereby declare that there is no pending criminal case against me.
Sir, nobody is
Yes, we have
disputing that.
Yes.
Having said that, this whether, having admitted that, having not been disputed that he has not revealed the pendency of the criminal case, pending criminal case, the criminal case being instituted on the complaint of the family relatives, with regard to which has been
Their
stemmed from
ancestral property.
property dispute.
No, but his duty is that to disclose whatever it may be.
Yes.
What the case, if the pendency of a case, he have the duty, he had, at that time of his appointment.
Obviously.
Yes, he have
but
that
he had
duty.
not done.
Yes, therefore,
Will it
this,
have any
this violation of this
will-
OM lordship.
No, anyway,
Yes.
will it have any connection with this his with his job as a constable?
No, lordship. No,
Will it impair?
no, lordship, because
That too, he has been acquitted now.
lordship, I do admit it, lordship, but lordship, every candidate who wants to appoint in the government service, there have some police verification, each and every government. Now,
Okay.
lordship, now, lordship,
What
before,
disposing?
no, lordship, lordship, we have some coordinate bench judgment also here in this case. This judgment is not, I have to go through this judgment, lordship, and lordship, this judgment may not be the similar to my case, lordship. And therefore, kindly
Others
fix the
also-
matter, kindly fix the matter.
Then first we're fixing day after tomorrow.
Yes, lordship, yes,
We're
lordship,
fixing day after tomorrow.
yes, lordship,
You read the novel,
yes,
Les
lordship,
Miserables,
I will,
Victor
I
Hugo and come.
yes, I will read the novel, lordship.
Day after tomorrow.
Yes.
Heard Mr.
Jay
So and
Kolikar.
so learn counsel for the parties. After arguing the matter at some length, Mr. J.K. Goswami,
Yeah, lordship.
Jammu and Kashmir. J.K. Goswami, learned state council.
Additional senior government, additional senior government.
Respondents press for listing the press for two days time to place the relevant case laws which you would be relying. Prayer not being objected to by learned counsel for the list is letter 05-06-23.
As a part, as a part, possible.
We'll see.
Lodge.
Lords.
Oblige, Lodge.
Lordship,
No steps.
Lordship, kindly see the Lozima court order
Yes.
dated 2/6/25. Respondent number 7 is not necessary party and may be strike off and list the matter for admission.
You file an approval application.
Sorry.
You file an appropriate application. Why is not necessary party? Why you have implemented him?
Lordship, actually, Lordship, the case between KK Henry, who is the respondent number 3 is the main party. This matter relates to evaluation of answer script. And respondent
So
number
yes,
3.
any objection?
My lord, I don't have any objection.
Okay. Mr. So and so, you will record her name. MS so and so, learned counsel for the petitioner submits that although steps, fresh steps has to be taken, the petitioner, respondent number 7 has been inadvertently added as a party respondent, as he is not a necessary party for adjudication of this matter accordingly. Please, therefore, tell that the name of the respondent 7 may be struck up from the struck out and maybe struck off from the array of parties. Please, Mr. Having considered that the respondent number 7 may not be a necessary party and the prayer for striking off the respondent having been, having not been objected to by Mr. Learned Counsel for the respondents, huh? Come on. The respondent number 7. The name
Lord,
of the respondent number 7 stands
We are not
Struck
on the
off.
merit of the case, my lord.
struck out.
My lord, his prayer, my lord, we don't have any objection.
Prayer also.
No, my lord.
Prayer also you don't.
No, no, my lord, prayer regarding striking of,
No, that's why I'm
my lord.
struck off. In view of the above, in view of the order passed, in the above, the striking of the name of the respondent says. Let this matter be listed for admission after
date may be fixed.
3 weeks.
So date may be fixed, Lord.
Why?
Lordship is on 6/2/24, court directed the Lordship University to file affidavit within 10 days.
But you have not taken steps.
Yes, Lord.
Today we have
My lord. After 3 weeks, my lord. Most-
3 weeks, let them file. All right. You have not filed.
No, my lord.
With the direction of the court. Why you have
My lord,
not filed?
by 3 weeks, my lord. No,
More than 3 months already been passed.
You are not making anything. There's a judicial order to file.
my
So
lord.
we are listing the matter after 3 weeks.
After 3 weeks,
We're not passing any order
my lord.
on affidavit.
My lord.
Otherwise, it will be amount to review of that order.
My lord.
All right.
Oblige. That is also, no, this is a covered case, my lord.
Robert Kelly,
Yes, yes.
do you agree?
Yes, I agree.
So,
Agree that only my submission is let him approach the bank. He will have to file some documents and application, all these things. He may approach.
Actually, my lord, he was a bank manager. Initially, he was dismissed from service. Thereafter, he preferred an appeal. And in that appeal, my lord, his order of dismissal was modified to the extent of removal. Now, my lord, whether he is entitled to pension and other,
so you are not questioning the removal.
huh?
You are not questioning the
No,
removal.
I am not questioning the removal now.
So which paragraph you are reading? I mean, relying.
Judgment of that.
Same UCO Bank,
You go, same rank is also same.
where it is the relevant paragraph.
Paragraph 12, 11, 12 and 13.
Receipt to section made by allowed the respondent is directed to complete the person open. Where is the finding?
Paragraph 13, girl.
Finding.
12, for the reason stated above, herein above, the petitioner succeed is hereby allowed. The respondent bank is directed to compute the pension as well as other terminal benefits payable to the petitioner in the light of the observation made herein above.
That is the
and-
observation I wanted to see, sir. This clause 6B of bipartite settlement is also applicable to you?
Yes,
Yes, sir. Clause 22, same.
no, clause, yes, regulation 22, yes, same.
Clause B of bipartite, there was a bipartite settlement
There was a
also
bipartite.
here,
Yes.
in this case also.
Yes, no.
Here,
but-
present case.
So far, this case.
You are relying on clause 7, clause 22.
Clause 22 will not operate here.
Huh?
Or clause 22 will not operate here in view of the bipartite settlement.
So,
So he is entitled to have the pensionary benefits. Clause 22 debars me to have the pension and etc. Like regulation 22. That is paragraph.
regulation 22 of what?
Bank regulation, the service
Bank regulation.
for
Please
future of
tell us
service.
the name of the bank regulation. What is the name of the bank regulation?
UCO
So
bank.
there is no bipartite settlement.
That's what happened here in this. The petitioner is the
Sir,
bank.
I am asking whether there was any settlement, bipartite settlement,
Yeah, there was a
which-
bipartite settlement between the
whether
bank
it
and the
applies to your case also here.
paragraph 5B. 5 and 6. By referring the above decision, Supreme Court rendered the bank such online has argued that the interpreting clause 22 of the bipartite settlement of the
That's-
UCO bank. the
Sir, I
honorable-
am asking, is it also applicable to your case here?
Yes, yes.
This is what I am asking. So, dispose of similar order.
Yes.
That's right. Heard Mr.
That is.
Let
It does
him
look
direct to approach the bank for.
What is
procedure.
the direction here?
No, there is no subject.
There is no such direction. But in that case, he has approached the bank. In this case, he has not approached.
How you approach?
Oh. So interest was given due to delay. But he has not yet approached the bank to pay this pension and all these things.
No,
So he will not entitle any interest.
I'll leave it to your lordship whether your lordship will grant here pension.
Heard Mr. A. Dasgupta, learned
He is
senior
against
counsel, assistant
Ah.
prime minister.
on pension only.
Be
Hey,
He does learn counsel for the petitioner. And also heard Mr.
PC Goswami.
P.C. Goswami, learned counsel for the standing counsel or what? No. Standing counsel.
no,
Yes,
bank council.
yes. Bank counsel.
Learned counsel for the respondents.
Well, I have prepared my list of dates also. If required, I can give
What
it. to you.
list of is required? It's a covered case.
No problem. If people love to request, I can give it. Yeah.
By instituting this writ petition. The So you are not, though you have prayed for, you are not challenging the removal now.
No, I will not change. I have been instructed to say so. Because we can-
Prayed for. The direction. Writ petition, the writ petition. Has prayed for. The direction to the respondent authorities. To release to pay the retirement benefits like
pension.
gratuity also.
Gratuity, pension, leave encashment.
Encashment.
Fair portion is at page 14.
But this will go against the final, the present prayer again.
No. Oh, yes, but consequential
Anyway,
benefit,
on superannuation.
consequential benefit will be there, right?
on
Even if we are assuming
superannuation.
that this removal order, hold the
Next
field,
paragraph. The-
then also I am entitled to have.
Petitioner was initially joined as clerk in the. What is this? Clerk in the UCO Bank on 29/11/1971. Thereafter, he was promoted to junior management cadre -1 in 1980. Then to middle management grade 2. Finally, grade 2 officer
Yes, Lord.
in the year 1997. Next. While the petitioner was serving as middle management grade 2 officer. And posted as manager, Rangia branch of the State Bank. By dated 25/08/2007, a so-called notice was issued to the petitioner to explain as to why discipline action should not be initiated against him for certain irregularities under advanced portfolio committed by him. It is alleged that in spite of transfer from Rangia branch to Rajgarh branch and being relieved, he continued to work as manager and irregularly sanctioned some loans by violating the bank's guidelines, thereby exposing the bank to serious financial risk. The details of the irregularities alleged. The alleged irregularities in disbursing the on loans were given. We need annexed with the so-called notice. The petitioner filed his response to the so-called notice. Then what happened? Department inquiry was initiated.
Yes, inquiry initiated, dismissal order inflicted, but I preferred an appeal. Appeal was not disposed of. Then again, I had to come before this honorable court. This honorable court passed an order to directing the appellate authority to dispose of this my appeal memo by reducing the order of dismissal to any other punishment.
Mr. The petition was placed under suspension, contemplating departmental proceedings. Mr. Next slide. Memorandum of charges. Memorandum of charges were memorandum containing article of charges and statements of allegation were issued and served to the petition. And thereafter, up to due process from the inquiry, departmental inquiry comments, and on 20/02/2008, the inquiry officer submitted his report The inquiry, a copy of the inquiry report was communicated, furnished to the petitioner, to which the petitioner filed his reply. On next paragraph, on consideration of the, on the basis of the inquiry report, the disciplinary authority by the order dated 28/03/2008 imposed the penalty of dismissal from service, which would not be disqualification, future employment, and other penalties against the petition. Being agreed, the petition, the petitioner filed a statutory appeal on 09/05/2008. The petitioner opposed this court, being WPC 4798 of 2008. By which, this court by an order dated 07/08/2015. Disposed of the said requisition with a direction to the appellate authority to consider and pass reason order. Accordingly, the appellate authority by the order dated 28/09/2015 has disposed of the appeal. Now that the order, dismissal has been modified.
Modified, converted to
Modified.
removal.
Order from dismissal from service to removal from service, which shall not be disqualification, future employment, and other penalties against each of the charges, including recovery of ₹9 lakhs from the petition. Mr. A. Dasgupta, I'm a senior counsel.
By virtue of this removal order, I am entitled
That
to
is senior
pensionary
counsel
benefit,
for the
gratuity,
petitioner.
and all other retired benefits. Sorry.
Submits that. Although
All other
the
terminal
petition has initially challenged the order of dismissal as well as order of removal from service with a penalty, and recovery of ₹9 lakhs from the petitioner and for a and for release of the, and for grant of the retirement, all the retirement benefits, including the gratuity from a pension, leave and scheme, etc. By flex of time, the petitioner would pray for a release of the retirement benefits in terms of the, in terms of the judgment and order of this court. In the case of dated 01/05/2025, in the case of Salendo North Property versus UCO Bank and two others, UCO Bank in WPC 5390 of 2014. He submits that the case of Salendo North Property within the Supra squarely covers the case of the present petition. Therefore, similar relief may be granted to the petition. That's it.
No, I mean,
That is what
pen-
it is.
pencil
Your only claim is initially, although you have challenged initially the penalty. Now your only claim is as per this as per the order of this court, whatever you are entitled, it should be released. It should be granted to you. That's all.
that is clear. We also may clarify it, paragraph 13 of this judgment. Pension, etc., etc.
Yes, yes. We'll
Paragraph
record,
30.
we'll quote this. Next paragraph. Mr. Yes.
Respondent bank is directed to
Goswami.
complete. Paragraph 13.
BC Goswami, Learned Counsel for the Respondent Bank. Where submits that the judgment referred by the learned senior counsel. Judgment referred. That is Salendranath Nakoti. Referred by the, relied by the learned senior counsel for the petition. To cover the case of the present petition. You are saying so? This
Yes.
case will cover.
Yes.
Next page.
Except interest for.
Having,
I agree.
huh?
Except interest for.
In this case, it was
Except
directed.
except the interest part which has been directed to the
6% interest.
except the
Figure.
6% interest.
Per annum.
Because he has not
per annum
applied for.
to be is directed to be paid to the petitioner in the above case as the petitioner has not approached the bank as on today, whereas the petitioner in that case has approached and
According
approached
to
the
him,
bank
as I have not approached
and it
for
was-
that purpose, this interest should not be given.
pending for, it was a delay of 17 years on the part of the bank and no justification was put forth. Put forth. That's the reason 6% interest. Yes.
But my case is also
I
17.
no. I have considered the submission.
It is 17 years.
And also there is the, then including the,
The time should
and
be
there is the
6 months.
judgment and order
Let it be 3 months.
that it
Not 3 months, 6 months. But no,
0105/2025
it takes 6 months.
in by the coordinate bench of this court in Salindor, not property within the fixed sector. Next one. Is noted, the is noted here in able, the
Paragraph
petitioner initially. No, petitioner has challenged the order dated 07/08/2015. No, 28/09/2015. Where is that?
direction.
No, 28/09/2015. Removal order, penalty
Last
of removal.
Page 98.
Page 98.
Is the last portion. Usually order is start from
As by the
Remember 28,
General
19,
Manager,
15.
Personal Services Department within the appellate authority. Whereby the penalty of dismissal from service imposed
page 88.
Hmm?
Page 88.
against the petitioner by the disciplinary authority has been modify to removal of services, removal of the petitioner from services, which shall not be a disqualification for future employment and recovery of rupees 9 lakhs from the amount payable to the petitioner, comma. But today the basic the prayer is only for release of the retirement benefits which is entitled to the petitioner in terms of the judgment and in terms of the similar matter, in terms of the order, judgment and order, that is 01/05/2025. In a case of similar nature, 05 within bracket, there's cylinder not affected here, in a similar nature of the case. Next paragraph. The government mentioned
Paragraph 13 probably,
the relevant paragraph would be
12.
cylinder not property within the
He actually is 12.
is reproduced in the para 8, 8, 9, 10, 11, 12, 15. 8 to last, this judgment. Woman, this judgment. 8 to 13, last paragraph. Next paragraph. Having considered the submissions and the of the learned counsel for the parties, and also in careful perusal of the on careful consideration of the judgment and order in so and so, so the I deem it, I'm of the view that the above case of cylinder not so and so, squarely covers the case of the present petition. That's, it would be appropriate to grant a similar relief to the petitioner as granted.
Just like within a period of 3 months.
It should be 6 months.
Just wait, I have not completed. Please. have
Yes,
some
Sorry.
patience.
3 months of dating, not for that long.
You're right, because 3 months.
So I'm an advocate, it's time for like a section of that.
Next one.
So who consider the
Accordingly, it is provided to the respondent bank. No, accordingly, it is directed that the respondent shall compute the pension as well as other permanent benefits payable to the petitioner and release the amount as expeditiously as possible, but not later than 4 months from the date of receipt of the certified copy of this order. 4 months. 4.
No, 6 months.
4 months.
No, I don't think in 4 months it will be completed.
Why?
It generally, it takes 6 months.
Why?
Because he will have 5 to the branch.
They will
Branch
impose
will record on all
impose
the, he will send to journal office.
interest.
It will settle by the head of.
Will impose interest. Will impose the interest.
Yes.
Will grant interest. Will grant interest in that case, 6 months, 8% interest.
Because in general, he will have to file for pension before retirement of 6 months to calculate all these things.
5 months, in that case, 5 months.
হবে যায় না।
The petitioner shall file, they approach the bank, respondent bank with
By submitting
Record-
certified copy.
and they shall approach the bank and submit the certified copy of this order along with the requisite documents that may be required for settlement of the benefits as
Yeah.
expected to be released herein above.
What along with that?
Requisite document, any requisite
yes.
document
Allah.
may be required for settlement, within a period of 15 days.
Okay.
15 days from today.
Much appreciated.
Very soon. See you then.
Yes, ফাইলটা দাও তো।
Yes,
Well, this is a part-hard matter.
what that matter? What that matter?
Part-hard matter, my lord.
It was, I think.
Huh?
It was part of.
So that is released.
I don't know, but I think possibly Lordship has released.
Yes,
Justice Suman Shyam.
Even today there is a number of part-hard matter was taken up by that court.
But considering the situation of my lord Justice Suman Shyam,
Yes.
I doubt very much if his lordship will take up this matter any further. It came before him twice or thrice, it was heard also, but I don't think it was made part heard.
As a
BH, it
fix-
was not made, but the nature of orders passed are such
as
that
a fix-
indication is it is part heard.
As a fix for third matter.
That is,
11/3/2025.
Yes. And that
Then
it has not been
24/4.
released.
it has not been released.
Oh,
It has not been released. That is the problem.
Let's before let him pass.
No, yeah, let him
Let him
release.
release,
ultimately,
because that has not been mentioned in the subsequent
but
order.
yes, but ultimately Justice Shyam will release it.
Yes,
That is different thing.
heard Mr. A. Dasgupta, London Senior Counsel, assisted by Swansha, and Mr. P.K. Tiwari, London Senior, assisted by
G Swamin.
G. Swamin, for respondent, all the respondents, all the respondents,
Lord, yes, management, all the respondents.
all the respondents. It is noticed that this, having noticed that this matter was
How it came before this court?
By mistake.
Possibly. Even
That is-
with,
No, let him release, no
That is-
problem.
okay, that's true.
But without
it is
And
noticed that
naturally, that's true, that's true.
the
our
matter was
transfer is
Hmm. I didn't read the order. I thought possibly
fixed
PH
as a
was
part
not
of matter on 11/03/2025. Although, in the subsequent two dates of listing of the matter, no mention is made to the, with regard to the hearing of the matter in part, I deem it appropriate to direct the registry to place the matter before the appropriate banks for necessary orders. Place before the appropriate banks. I'll not say necessary orders.
Finally, it will come before your lordship.
No, it makes
Finally,
no
it will
problem.
come. Huh.
Just a
Can't be
formality.
overlooked. Correct, that's true.
Program is here.
Is it possible today, sir?
My lord,
Will it be possible to complete today?
Of course, today it may not be possible. I think on our side also there are 2, 3.
On the last occasion, your lordship has asked the state council to call for the records.
Records,
The
right?
records will be necessary in this case.
Basically, my lord, a policy decision was taken
Yes,
whereunder we were recruited.
yes.
Now our services are sought to be dispensed with and they resort to the same ad hoc. And my lord, most importantly, the decision of the board of directors by which we were recruited, whether that resolution has been overruled by subsequent, that also has to be seen. End of the day, my lord, Assam State Transport Corporation is an autonomous body. Whether the government can dictate that is also another aspect. So all these things can be revealed only by the records.
Do you have the records?
Yes, sir. We have this.
Then we can proceed. We have-
Yes.
Are you ready? There has to be ready.
Lordship,
All of you have to be ready, otherwise.
Mm.
Lordship, although I have received record yesterday only, Lordship, I have not yet gone through the record. So if Lordship wants to peruse the record, then it's okay, Lordship. But if Lordship wants me to submit on the basis of the record, in that situation, Lordship, I would like to have 2-3 more days.
It depends on how you.
Record,
depends
Lordship, I
on-
received only yesterday.
But
That
you-
is it.
Do you think that a record is not required?
Yes, my affidavit is sufficient, Lordship.
Huh?
My affidavit is sufficient.
No, my lord, affidavit, though my learned friend may say it is sufficient, but we'll take advantage of the affidavit only. Because the affidavit itself says that now they're seeking to replace one set of ad hoc by another set.
No. That language has never been used anywhere. Lordship. We only have decided to outsource.
Anyway.
Yes.
So will, if necessary, we'll peruse it. We'll
Yes.
see. Since record is there, it's okay.
Yes.
Yes.
My lord, will
This
take
is item-
WPC 4068 of 23, item number 1.
40.
68 of 23. my lord.
Yes.
Hey, good, good.
40.
Item number, good.
Item number
1 second, my lord.
4068.
199.
Yes, 19. Item 19. So this item 16 is by the association.
No.
Item 16 is by the association
Act by the association.
and rest are the employees. I
Yes.
mean, the member of the association separately. Huh?
Others are also there.
Yes. Yes.
My lord will kindly first come to page 26.
26.
This is 29th of November 2019.
Hmm.
Consequent upon withdrawal of services of Messrs. Agnis Security Agency Tinsukia for providing security guards to Assam State Transport Corporation with effect from 15/12/19 and with a view to maintaining uninterrupted duties and services of security personnel in various offices, places to protect the physical infrastructure and other belonging to corporation, it has been decided to select Suraksha Sahayak, security assistant through interview and engage them on contract basis in the interest of the corporation. Accordingly, the divisional office-wise requirement of such Suraksha Sahayak assistant has been reviewed and worked out as under. These are my lord 238 in all.
All are security guards.
Yes.
All the petitioners in this.
Not all petitioners are not security guards, my lord. There are different
Okay, you are this in this writ petition, all security guards.
security. Yes.
Okay.
In this context, after careful examination of the aspects relevant to the aforesaid selection and engagement of Suraksha Sahaya, security assistant in corporation, all divisional superintendent of divisional offices of the corporation are hereby directed to strictly adhere to the following guidelines while conducting the selection process.
Yes.
Suraksha Sahayak security assistant will be selected locally by a committee comprising of 3 to 5 officials headed by divisional superintendent of the respective division. One officer from the head office will remain as observer. That apart, there should be an external member either from police, CRPF, Army, NCC in the selection committee. The selection shall be made through interview of all those candidates who have prior experience training of security guard, candidate having 2 years service experience or more,
a security guard will be given preference, provided she must be physically sound enough to discharge duties of a security guard in the corporation. The selection should be done at the earliest. An intimation may be sent to the Assam Skill Development Mission with a request to inform their training partners for wide publicity amongst all those who have received training of security guards through various government schemes. Further, the divisional office may apprise all local security agencies functioning under the division to apprise their security guard to appear in the interview if they desired by them. The select list of candidate has to be finalized by divisional office before 10/12/19, and it should be submitted in seal cover to respective observer, who in turn shall submit the same to MDSTC latest by 11/12/19. Suraksha Sahayak, a security assistant, shall be engaged on contract basis for a period not exceeding 2 years, subject to extension for further period, and be entitled to draw monthly fixed remuneration of 8,500 per month. Then, my lord, this was followed by another circular at page 28. Now, kindly have a look at this, my lord. In pursuant of the recent head office order communicated on 29/11/19, this is to notify that the undersigned is intending to organize formal interview of the security guards currently deployed at various stations under this division at the office of the undersigned on 10/12/19 at 11 a.m. and thereafter, which the selected candidate will be engaged as Suraksha Sahayak or security assistant contract basis, and you also have to enter into a contract agreement with STC. Consequently, all state superintendent, assistant engineer, assistant station superintendent, and assistant in charge are hereby informed to send over the security guards functioning under them to the office of the undersigned on the above mentioned stipulated time and date in order to appear in the said selection process. Further, the security guards are required to bring all their relevant documents, including etc. etc. As such, as per direction provided by the headquarters, a committee of interviewer comprising of below mentioned members are hereby constituted to carry out the selection process. So, divisional superintendent, assistant, etc. So, these are the persons who constituted the selection committee. Then at next page, on 6th of December, this order was issued in reference to this office notification dated 29/11/2019 in the matter of holding interview for selection of Suraksha Sahayak, a security assistant by committee constituted in respect of the divisional office of the STC as per instruction content.
The appointment of observers.
Yes, well, these are the observers. Yeah. Then my lord will kindly come to the next page, page 30. Subject to termination without notice or assigning any reason thereof, following selected candidates are hereby temporarily engaged. As so, this is the appointment order.
Yes.
Then my lord will kindly come to page number 32.
Here 21 persons.
My lord.
21 petitioners.
21.
22.
Yes. Now please come to page 32, my lord. In pursuance to the minutes of meeting of the Assam State Transport Corporation chaired by Honorable Chief Minister, Assam on 29/4/23, in the conference hall of the Chief Minister, and as per approval of the Board of Directors of ASTC in its 185th meeting held on 24/2023, those who were engaged purely on contractual basis on payment of fixed consolidated remuneration per month, and which on verification found to be engaged without following any recruitment procedure as laid down by the corporation, to be released and to renew and not to renew their contract beyond 31st of May 23. Therefore, in view of the above, Srimati Pratima Datta, the petitioner number 1, security assistant contractual under establishment of ASTC Insecure Division, is hereby released from his or contractual service from ASTC with effect from 31st of May 23 in the interest of the corporation as well as the public at the public service as large. Now, my lord, the reason assigned is that when it came to recruitment of the petitioners, it was not by following any recruitment procedure laid down by the corporation. Now, my lord will kindly come to their affidavit.
All these are similar.
Yes.
Same and similar.
Yes, same.
Similar.
It was affidavit, I think it starts at page number. Yes, actually it was filed in WPC 3422 of 23, which they have adopted item number 16 number to the assent. Milord will have the affidavit in item 16. Page 88.
The decision was to release those
With
security
effect from
guards
31st, yes.
whose appointment were without following the due process.
That's the case. Now, Milord will kindly come to page 94 of that affidavit, para 12.
Yes.
That as regards the statement made in para 11 of the writ petition, the deponent begs to deny the same as incorrect. It is pertinent to state that the statement made in this paragraph of the writ petition is based on document annexed as Annexure 13 with the writ petition, which appears to be as stated by the writ petitioner, a proposal put up for decision of the Board of Directors meeting of STC. It is categorically stated that the document that has been annexed as Annexure 13 with the writ petition was never placed before the Board of Directors of STC. So far, so good. Now come to the sub-para. In this regard, it is pertinent to mention that a meeting of the Board of Directors held on 24/5/23, wherein the board granted approval for engaging security assistant on short-term basis through security agency, manpower agency, as resolved in the 184 board meeting as a stopgap arrangement. Now, my lord, before we were recruited, the whole security apparatus was outsourced to these private agencies. Before our recruitment, a policy decision was taken that those security personnel who are being engaged by the security agencies, from amongst them, we make a selection process and make recruitment, and accordingly we are recruited.
Or contractual.
Yes, as contractual. So it is not that we have not undergone a selection process. We have undergone a selection process. Everything was monitored. Eventually, we are selected. Now, what is sought to be done again, Milord? They want to go back to that as a short-term measure. So that means for this short-term period, they would like to replace us by some ad hoc. So therefore, my learned friend cannot say we have not said that in our affidavit. The consequence is that if this sub-para is to be given a meaning, what follows is that we will be removed and in the interregnum, some people as a stopgap arrangement would be brought in. In other words, a set of ad hoc employee will be replaced by another set of ad hoc employee. This cannot be permitted. Then please come to para 13. That as regards to the statement made in para 12 of the writ petition, the deponent begs to deny the same as incorrect. As claimed by the writ petitioner, no decision has been taken by the board of STC to engage another set of ad hoc employees in place of 77 number 1 employees already released. It is pertinent to mention here that as and when there will be requirement, proper recruitment will be done by following all normal public employment, wherein 771 number of released employees shall also be eligible to participate, subject to fulfillment of eligibility criteria to be laid down by the appellate authority in such manner. So my humble understanding of para 13 is, Milord, those 771, including the petitioners who were released following the decision taken in the 184th board meeting, now in their place a proper recruitment would take place. Now when that recruitment will take place, nothing much, this was in 2023. Now we are in 25. Nothing has happened. So now they are. So now, my lord, as has been stated in the sub-para of para 12, they have resorted to again adhocism because some others has been engaged. So therefore, our
Presently,
play-
they have been engaged.
Yes.
Others have been
our
engaged.
prayer is very simple, my lord. Since we are already working, since say according to them as stated in para 13, if they advertise the post, we'll get an opportunity to participate. So why not we continue till a regular recruitment takes place? That is only we are asking for, nothing beyond that. At least as far as my clients are concerned, that is my limited prayer. Otherwise, my lord, you have violated that norm of replacing one set of ad hoc by another set. You cannot blow hot and cold at the same time. If your policy is to go for regular recruitment, till then why not retain us? No, my lord, other than, my lord, just satisfying the ego of some officer or some political executive, nothing is going to happen, my lord. We were working, we have undergone a selection process. Yes, it was not a regular substantive appointment, neither we are saying that. But till such time a regular recruitment takes place, we should be allowed to continue. Well, that's it. That is our limited, my lord, prayer. Now, my lord, I'm just relying on the latest judgment of the Supreme Court, my lord.
Your appointment for the contractual period is over.
Yes.
That has been extended from time to time.
No, they did not.
Extended.
Hello? Yes. Initial period was
Have they
over, but we
extended it?
continued.
Continued.
Yes,
There's no
until the impugn order.
Okay.
From 19 until mid of 23, we were there, my lord. Now, if a lordship should kindly come to para 14 of the judgment, my lord, at page 16. Please come to para 14.
Yes.
A respondent employer places reliance on Uma Devi to contend that daily wage or temporary employee cannot claim permanent absorption in absence of statutory rules providing such absorption. However, as frequently reiterated, Uma Devi itself distinguishes between appointments that are illegal and those that are irregular, the latter being eligible for regularization if they meet certain conditions. More importantly, Uma Devi cannot serve as a shield to justify exploitative engagement persisting for years without the employer undertaking legitimate recruitment. Given the record which shows no true contractor-based arrangement and a consistent need for permanent horticultural staff, the alleged asserted ban on fresh recruitment, though real, cannot justify infinite daily wage status or continued unfair practices. And at the end of the day, my lord, do we have any choice or option, whether it is a regular substantive recruitment, whether it is a daily wage, whether it is a contractual, whether it is ad hoc? We are in need of job, my lord. And Supreme Court has recognized this. Now, therefore, when it comes to we staking a claim for some enforcement of our right, it's very unfortunate that state comes up with the plea that Uma Devi is coming in the way. Supreme Court is now clarifying every day. So Uma Devi is not coming in the way. On the contrary, what Supreme Court said, Uma Devi cannot serve as a shield to justify exploitative engagement. So, my lord, this is a pure and simple case. A due process, though may not be strictly in accordance with the recruitment procedure, was undertaken. We were selected. We are continuing. Then all of a sudden, my lord, a new regime comes and takes a decision whereby, my lord, our tenure is truncated. Now we say, you yourself has professed that you are going to make a regular recruitment in place of that 771, which includes the petitioners, that you will make a new recruitment. Very well. We should be allowed to participate. You yourself said you will give us. Till then, why should we not continue? Why another set of ad hoc or, my lord, part-time person should be inducted? That is our simple case. That's my humble submission.
Fair submission. Fair prayer.
Yes, ma'am.
So far. So far. Because without hearing, before the respondents are heard.
Deep level.
May it please your lordship.
Item 16.
Item 16. My lord, I represent the 771 members of the association,
Yes.
which is a registered trade union.
Yes.
Your lordship will find my credential at paragraph number 2 at page number 6.
This way.
Paragraph 1 and 2, your lordship may kindly take note of it.
This one. Yes.
Your lordship will kindly take page number 6, paragraph number 1. The credentials of the association, my lord.
Yes.
That the petition number 1 is an association of workers of the Assam State Transport Corporation and registered under the Trade Unions Act 1926 and having registration number 216 dated 7/5/1952.
Sir, it's okay. No,
Then 2
there's
is
no
the matter
dispute.
we
There's no
represent. It's not in a, no, they wanted to say in one of the paragraphs in the affidavit that our association is not registered. We have a registration and that is reflected in our license and everything is there as required under the statutory rules. And we have given a statutory additional affidavit contravening those allegations. Now, your lordship will kindly take note of the impugn order at page 43.
Since members also, they have they have also come forward already.
Yes.
By other writ petitions, so why we should
Yes.
deliberate on this?
Yes.
Will not
No,
delve
but
on it. We'll
since
not
they
delve
have
in.
disputed our
It's okay,
registration,
we'll not
that's
delve
why I
into it.
pointed it out.
Because
But
it's not that important to decide the issue.
yes, ma'am.
Yes,
Now, your lordship will kindly take note of the impugn order at page 43, annexure 12.
43. Same.
Same, my lord. Your lordship will see that it was in the review meeting of the Transport Department on 27/6/23. It was decided to inquire into the procedure followed in the recruitment of contractual staff in ASTC and verify whether due procedure was followed in such recruitment. So, paragraph 1, 2 and the decision at 1, 2, 3, 4, 5 maybe taken note of it. Now, at this stage, your lordship will also take note that pursuant to this decision, my lord, an FIR was also registered against the persons who gave the appointment to us. But they have not updated or given any statement in regard to what action the state has taken against those managing directors and the officers who had appointed these persons, because we did not go through to them to get the appointment. It was notified in their notice board. We took up the appointments and
All of them, same that procedure.
same procedure.
Order was issued
Yes,
for recruitment.
yes,
And the observer, everything, interview is done.
Yes.
And then appointed.
yes,
All
all,
is submitted by
yes. But only thing is that
Mr.
there-
Chaudhary in,
yes,
item
only
9.
thing is that there was no paper publication at that particular point of time.
Okay.
But since we were aware of that notice, we followed the process and we were appointed. Now, the question earlier it arose was that whether any action was taken against those officers who had given this appointment.
Yes.
Yeah. They said that an FIR has been registered. But what action the government has taken, that they have not apprised this honorable court.
Registered has been, case has been registered.
Yes.
Against those.
Yes, they have
persons who had
submitted
appointed you.
earlier occasion that as a CID in the CID department and FIR was registered.
Okay.
But we have not heard of any of this managing director being arrested in connection with this case or what steps the government has taken. Simply to give an IWAS, they may have registered an FIR, but I don't think that any steps
After the decision, after this.
Yes, after
this minute.
Yes, yes.
29/04/2020.
Yes, because my lord, the political bosses were also involved at that particular point of time in giving appointment to this 771 employees, because there were recommendations of the ministers, MLAs and all also to give appointment to some of them. But your lordship may inquire from the state what steps they have taken. Because so far we are concerned, there is, we have not been summoned as a witness in that case to answer whether how our appointments have been made. So that one your lordship will take it, that is one part of
You
the,
are not the accused there.
no, we have not even summoned as a witness in that case to give a statement against those officers who had appointed us. Because simply people who are in need of job, they have gone and they have followed the interview process and the recruitment process. Just because at that particular point, the advertisement was not there, that's why now they are terming us this appointment as illegal. I would rather say that it may be irregular, but not illegal. Then your lordship will kindly see the page 47.
Yes.
Page 47, my lord, reflects the intention of the ASTC. They want manpower, but they don't want to take the liability of the other benefits which are to be given to the regular employee at page 47 here. Lordship will see the last paragraph of page 47. 1, 2, 3, after 4 lines. In view of the direction issued by the Government of Assam Transport Department, ASTC had decided to release 771 numbers of contractual employees from their respective services. However, after releasing of the said employees from their respective duties, there will be a shortage of manpower in ASTC. Therefore, after threadbare discussion and by looking at the urgency of manpower and security of the office asset, ASTC has decided to hire the services of the casual workers through outsourcing agency, where entire liabilities, including the service benefit of the said workers, will be covered by the manpower agency through whom the said workers will be hired. The only responsibility of ASTC will be to pay them their monthly salaries through the respective manpower agency. Accordingly, the minimum requirement has been yamak as per the enclosed annexure enclosed herewith. Then your lordship will see the next paragraph. As per the minutes of the 172 meeting of the Board of Directors held on.
This is resolution.
Yes.
Board resolution.
Board resolution. They need manpower. They say that we need this manpower, but we don't want to take the financial responsibility. Then your lordship will see page number 287 of our additional affidavit, my lord.
Yes.
My lord, in the meantime, after the impugn order and till this order at page 287 was passed, there was deliberation between the association and the ASTC management. But ultimately, they stick to their policy. That is at page 287. You'll also will see that they have appointed 263 ad hoc employees from different agencies.
This is which
This is after the impugn order, my lord.
immediately.
Yes, my lord.
So you are not in the job now.
No, no. Our case is that if you need this temporary workers or if you need persons, if you have manpower, so you ought not to have replaced us till a regular process of recruitment has been done. Now your lordship will find this is the list that goes in the next page. Your lordship will find the list of the employees which were appointed after the impugn orders. Up to page 298 is the list. If your lordship looks at the last page 298, your lordship will find that 263 have been appointed in different, on ad hoc basis in different places. 298.
To 98.
You'll also find on the left column, the total 263 were appointed in different divisions of the ASTC member.
So these are the list.
Yes. Now, and in terms of that,
from serial number 1 to 263.
263.
That is
and in
page 288 to 298.
287 to 298.
page number 287 to 298.
Yes.
Then your lordship will find that in terms of this, they executed the engagement of manpower agreement that your lordship will find at page 338.
Okay. Yes,
This is the deed of engagement of manpower agreement,
yes, yes.
and which was executed on 7th of January 2023.
From the security agencies.
Security
private
agencies, different security agencies,
Okay.
private security agencies.
Yes,
Your lordship will find Protection Security Service having registered office at house number 42, Hamchandra Borua, being represented by its proprietor, Sri Kulen Bachcha.
okay.
So these are the different types of. So basically, my lord, when we had worked so long for this organization, if you had the requirement of the manpower agreement, these people with experience should have given their preferences over the others. Even the association could have taken into confidence to see that these persons who had worked for more, some have worked for more than 10 years, my lord, then their services ought to have been considered for this replacement.
These are all only security guards or?
No, different. They are now contemplating to appoint some are office assistant, some are drivers, but different categories.
They've been all filled
They
up.
are electrical,
That's outsourced.
all capacities. There are some.
These have been all from outsourced.
Yes,
have
now
been
they are
outsourced
contemplating to outsource from all this from.
for all the categories of
Yes,
force.
yes. It's because this matter is sub judice, my lord, after the security guard, when he brought it to the notice of this honorable court, they had stopped it at the moment.
Any order is there?
No.
Any interim order?
No.
Any
no
pleadings to that effect, Lord.
No, interim order.
submission.
No, interim order is in only in respect of one of the case. There is a item 17. There is an interim order.
You are continuing.
Well, when the first
AJ?
As technical assistant mechanics.
if Malad, a fleet of bus cannot run without a mechanic, they will require. It's not that they will not require manpower to manage the AS. Their resolution itself says that they will require
Sir,
manpower.
it's a corporation. They have their board of directors. They have their own policy.
Yes,
All right.
yes. And problem is that our provident fund was also deducted when we were in employment.
No, that will.
But problem is now they are showing it as zero balance. Now problem is that when we had worked for so long, you cannot replace one set of ad hoc employees by another set of ad hoc employees as you have termed it. Now your lordship will see what this citation, my lord, 2007 13 SCC 292.
ML Kesri.
No, after that, my lord, I'm placing the new judgment, the same ML Kesri, and even I will place one of the judgment, Jagu versus Union of India. This is in regard to ad hoc, my lord. Your lordship will see. The appellant in this case were employed on ad hoc basis in several colleges in the state of Punjab. There being a threat of termination of their services, they filed writ petition before the High Court seeking for the relief of regularization minimum pay scale and to continue in the present post until regular appointments are made. All the reliefs were rejected by the High Court, and so far the relief relating to continue them in the present post until regular incumbents are appointed. The High Court stated that the government will have to follow its policy decision dated 23/7/2001. We have carefully looked into the judgment of the High Court and other pleadings that have been put forth before this court. It is clear that though the appellants may not be entitled to regular appointment as such, it cannot be said that they will not be entitled to the minimum of the pay scale, nor they should not be continued till regular incumbents are appointed. The course adopted by the High Court is to displace one ad hoc arrangement by another ad hoc arrangement, which is not at all appropriate for these persons who have gained experience, which will be more beneficial and useful to the colleges concerned, rather than to appoint person afresh on ad hoc basis. Therefore, we set aside the orders made by the High Court to the event the same deny the claim of the appellants of minimum pay scale and continuation in their service till regular incumbents are appointed. We direct that they shall be continued in service till regular appointments are made on minimum of the pay scale. The appeal shall stand allowed in part accordingly. Then your lordship will look into the next judgment citation, that is 2024. Did I have to? This is 2024 SCC online, SC 3826, Jaggu versus Union of India. Now your lordship will see
there was always a hurdle of citing Umadevi to give benefit to people like us, madam, to the petitioners, madam. Your Lordship will kindly see paragraph number 26.
Yes.
While the judgment in Umadevi sought to curtail the practice of backdoor entries and ensure appointments adhered to constitutional principle, it is regrettable that its principles are often misinterpreted or misapplied to deny the legitimate claims of long-serving employees. The judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of employee, even in cases where their appointments are not illegal but merely lack adherence to procedural formalities. Government departments often cite the judgment in Umadevi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment explicit acknowledgement of cases where regularization is appropriate. So this judgment,
Hopefully, Mr. Nayak will not rely on Umadevi now.
yes.
Regularization or continuation is not even a prayer in this petition.
Yes.
I don't know why these judgments are so.
Okay.
They will have their chance. So a basic case is that you cannot replace our employment by another set of ad hoc employment. Till the regular process of appointment is done, my lord, we should have been allowed to continue and to continue to give us the benefit that we have enjoyed all these years. And secondly, my lord, as I have said at the outset, that people who have given us this appointment, no action has been taken except registering an FIR. I don't know, that was a submission made in during the earlier time for denying us the interim benefit, that an FIR has been registered.
Will not be possible to direct you, those who are not continuing as on today, already replaced or whatever, will it be proper to direct that? At least it ought to have been. Till the regular appointment is made,
No.
you should have been allowed to
No,
continue.
no, my problem is here.
Now you
by
have
this-
been replaced.
Yes, my lord,
already.
we
It's
have-
been 2 years.
No, my lord,
Nearly
my
2
lord,
years?
see, we came at the earliest point of time. It is not that our termination was of 23 and we came in 25. When first day when for three petitioners in this case, when stay was granted, we also sought for a similar prayer. But the court said that we'll hear the entire matter and give it the final judgment. It's not that there is lessons or negligence on our part in approaching the honorable court. We came at the earliest moment of time challenging our termination orders, saying that since we have continued and for such a long time and we have followed the particular process of recruitment, at least the principles of natural justice ought not to have violated. At least we should have heard before you, at the stroke of a pen, you have terminated all of our appointments.
That I doubt. This court doubts that submission. But there may be point. I mean, it's reasonable, as I said. Till the regular appointment is made, you would have been allowed to continue. That
Yes.
would have been the best way out. I mean,
Yes.
the best course of
But
action.
Malad, when
But
they
as a matter of, I mean, natural justice, you
yes,
cannot.
Malad, what I was at the moment is that we
It's a
trusted.
cardinal principle.
Yes,
but then we
Malad, your
cannot,
lordship will see the time taken.
apply it in all
Yes,
instances.
your lordship will see if there was a delay in approaching the court.
Yes.
Say if it was the termination of 23 and we came on 25, then it was a different case. But we came immediately before the court and the court has granted the stay. When the court says that we'll hear it, you don't have to worry. If you are entitled to not replaced by another set of ad hoc employees, we'll consider. Then we have to trust the wisdom of this honorable court, my lord.
But what is the discretion for that matter? The discretion of the authority, the board of directors and the corporation to decide which way, I mean, how to employ their employees. Don't they have any authority or discretion to go for it?
Well,
Way of policy.
your lordship is right. That
Because
in-
they have
yeah.
decided, only thing is that there's a little, I mean, sound to be little stigmatic on your part, that those who have been appointed by not following the due process of law should be released or terminated. That was the decision of the meeting. Now, you are trying to project that the process was followed except for publication.
In the
I mean,
advertisement.
Advertisement, by way of advertisement.
Yes.
Otherwise, normal basic requirement was followed. So there's no illegality as such, at best could be irregular.
Irregular. And that is number one. Second, my lord, no action has been taken against these persons who have made these irregular appointments.
So ultimately,
That's the issue.
you cannot, rather, I mean, in fact, you are not vehemently opposing the filling of the post by a regular process.
But that we cannot,
Yes, you
my lord, because we know our limitation to the extent in case of para 53 of Umar Devi. But Umar Devi also, your lordship has seen in Jaggu's case,
When this matter was filed, within 2-3 months should have been,
13/6/2023.
this should have been decided.
My lord, they took time in filing their affidavit. After that, my lord, their officers were busy.
Okay.
So, my lord, that's why otherwise too we would have, because since there was no interim order, we are always in the urgency to get the matter here and dispose of it finally.
I think, Mr. Naik, it's, except all other, I mean, apart from other things, the basic prayer they are seeking, that till the regular appointment, why don't they be allowed to continue?
Let one of the petitioners show that prayer in one of the writ petitions.
Your lordship will see,
Nowhere.
no, your lordship will
Nowhere.
see my prayer specifically at page 20. And it's not that, my lord, in a writ petition, your lordship can always mould the prayers. Your lordship will see my prayers at page 20.
Sir, it's, molding is one of the biggest problems. Yes. What
Now,
is
your
it?
lordship will see para 4.
To afford an opportunity to produce selection for regular present one such a it doesn't say so.
And these employees, since they were appointed subsequent to the filing of the writ petition, we brought it on record by filing that additional affidavit.
No, that may not be, there's no specific prayer as such.
No, my lord. These persons, my lord, they were appointed after filing of the writ petition. That's why we brought this on record by filing an additional affidavit.
Where it is, page?
But this, just now we have pointed it out at page, you have a appointment, 280, to that 287 to.
No, what is prayer? You said you are referring to some prayer. Your
No,
prayer,
that prayer number 4,
page 20,
page 20.
20, huh?
Yes.
What does it say?
To afford an opportunity to the said 771 contractor to participate in the selection process for regular appointment, as and when such an exercise is undertaken by the respondent by giving weightage to the expense and also by condoning overage as may be required. This was the prayer, but after filing of this writ petition, that's page 287 to 298 came, my lord. There were 262 people were appointed.
Some of the posts are vacant still.
Yes, my lord, still.
It has not been pinned up.
No. Because they are waiting the outcome of this writ petition.
So
Because,
how it's functioning?
my lord, I don't know. My lord. I don't know how to, because their
The
decision.
corporation is functioning. More than half of the employees have not been appointed.
And their resolution says, my lord, that their requirement of manpower is there, my lord.
We'll just, okay, we'll come to the.
Your lordship will see again their decision, my lord.
Okay, I
At page 47. They said that manpower is required. Only they don't want to take the financial liabilities of pension and gratuity and other dues, PF and all.
Yes.
It's not that the manpower is not required. That's my humble submission
Yes.
for you. Okay.
Yes. Just keep it. Yes,
Item 17.
yes.
Lordship, we are
Any,
assistant mechanics.
uh,
Unlike the other petitioners, we were appointed through a process which mirrors regular appointment.
okay,
Lordship, may I first take you
item 17.
the impugned order, page 45. Writ petition 3314. Lordship, we are the only ones who are continuing by virtue of a stay order.
Mechanics. This is mechanics.
Yes, trainee mechanics.
Mechanics. Yes.
Lordship, the impugned order is at page 45.
Hmm.
Annexure L, page 45.
Yes.
It's dated, it's by the Office of the Managing Director, ASTC. It's dated 30th May 23.
Same.
Yes, just a point.
Yes.
In pursuance to the minutes of the meeting on so-and-so, chaired by the Chief Minister in the conference hall, as per board approval of so-and-so, those who were engaged purely on contractual basis on payment of fixed consolidated remuneration per month, and which on verification found to be engaged without following any recruitment procedure. So the reason why we were released is because it was found on verification that we were engaged without following any recruitment process as laid down by the corporation to be released and not to be renewed. So the grievance against us is we were recruited without following any recruitment
This is,
procedure.
this is not to be renewed. To be released and not to be released.
Yes. To be released and not to be renewed.
Okay.
So the ground for releasing us is because they found on verification that we were engaged without following any recruitment process.
Yes.
So basically we were an illegal appointees.
Yes.
Lordship, for that, let me show you, Lordship, what is our selection procedure. Page
Yes.
26.
Hmm.
Page 26, Lordship, Annexure A. Lordship has page 26. Is dated 2/6/14.
Hmm.
So this is from ASTC to Divisional Engineer ASTC. This is from DGM. It's an internal ASTC correspondence, and subject is engagement of mechanic apprentice in Silchar district. With reference to above, I'm directed to inform you that it is decided to engage 10 ITI past mechanics as apprentice in Silchar division initially to manage the repairing maintenance work to the vehicle smoothly. Applications from eligible ITI-based candidates may be obtained in consultation with the local ITI authorities and local employment exchanges, verification of valid necessary documents, followed by a personal interview, should be conducted to select 10 suitable candidates as per current requirements of trade. Proper weightage should be given on marks of ITI final examinations, personality, health, willingness to undergo training with discipline, and any other criteria that you deem necessary to be included. After final selection, the name of the selected candidates along with the relevant documents, including marks awarded in the interview in respect of all candidates, should be sent to the head office for final approval and further action for engagement. In view of the above, a select committee is constituted with the following officers: Division Engineer ASTC, Divisional Superintendent ASTC, and a representative of the Principal ITI Silchar. So this is a requisition to the employment to ITI. Please send us qualified people on the basis of this thing. That's the beginning, the kickstart of our appointment process. The next page, Your Lordship, page 27.
You are 10 in numbers.
10 in number. We are only 3. Petitioners are only 3.
Okay.
We are,
Others?
the others have not in this petition. We are only 3.
Yes, very good.
Yeah. There. Others are also there. Others are also there.
Okay, not in this petition.
Other 7 writ petitions.
Yes.
7 writ petitions. 7 persons are there.
14 were there, my lord. We are 11. There are 3 that I see.
No, it consists of 10 only.
Total 14 persons were appointed, my lord.
By the same process.
Yes, yes.
But then it shows only 10.
Later on, there was another.
Anyway, we'll come to,
Yes,
we'll
Lordship,
see you
we will show
when
you
his
and
time,
then
when his
we'll
turns come.
the rest.
Yes.
Yes,
But
sir.
at least you are safe, it's only 10.
Yeah, yes.
Here only 10.
Yeah.
Starting
So
is 10.
we are pursuant to, 3 of us are appointed pursuant to this 10
Yes,
requisition.
within 10.
Right.
Yes.
Page 27.
It's okay. I've seen it. These are the selection.
So Lordship, now what happens is
When the appointment orders.
appointment
Page
orders.
39.
Page
39.
Page 38 is the beginning, and our appointment order is page 41. So
Yes.
they first ask for 10, they don't get 10, then they keep going back, and our appointment order is page 41.
Okay. There are only 2 persons.
The petitioner number 1 is page 41.
Hmm.
That's number 2, Javed Akhtar Lakhpal.
Hmm.
Then Your Lordship, page 42, 43.
Okay.
42, 43. 43, Your Lordship, is Sabir Sohail, petition number
Okay.
2, and Sahil Alam Barbuya, petition number 3. Lordship has page 43.
Yes.
So Lordship, our procedure is very, and Lordship, the other pages for procedure is page 27.
Okay, okay, I've seen it. So,
Yes, Your Lordship. So my submission, Lordship, is
except for issuance of advertisement, there was a
Your
communication.
Lordship. Lordship, I rely on K.N. Vishwaraya,
One judgment,
1996.
only one judgment.
Lordship, 3.
Why 3?
Lordship permits me because they're threatening to release us. It's our livelihood.
Letters in process nearest
Lordship, this
among these 3.
yes. This Lordship, this is a 3-judge bench. Just to Lordship let you know that until this case law, the only way of actually recruitment in public service was through an employment agent.
Yes.
So what was pursued in our selection process was the norm till 3 judges decided that no, it should be more than just employment agents.
Yes.
So what happened in our selection process? We asked for a requisition from ITI and the employment agencies. That was the law till 1996. So it's not something what was done to, in our case, or something unknown. And Lordship, that is just one paragraph, paragraph 4.
Yes.
This court in so-and-so noted the contention of the counsel appearing for respondents herein that excluding the candidates who were not sponsored through medium of employment exchange and restricting the choice of selection to the candidates sponsored through the medium of employment exchange would offend the equality cause of 14 and 16. So the contention was the converse, that just restricting employment through names from employment agencies violate 14 and 16. What was done, this was what was done till this particular case. And the contention is, sorry, no, you can't just go to an employment agency and ask for names because that violates 14 and 16. What I'm impressing upon your Lordship is what was done through an employment agency held forth till 1996 as the only way to conduct selection process. In this case, finally, they said, but in view of the facts that even paper publication would not reach many, a handicapped, who would not be able to have access to newspaper. It was held that sponsorship through a medium of employment would not violate 14 and 16. On the other hand, it would advance the rights of handicaps. In that view, this court upheld the restriction imposed on the state and the central government to consider the case of the candidates through medium of employment exchange, while holding such a restriction was not intended to be applicable to private employment. Thereafter, your Lordship, paragraph 6, they say no, you must also now advertise. So an appointment process through employment agency is not per se illegal. It was what was done for a long time.
Yes, this not only that.
Paragraph 4 and then paragraph 6. They say in addition to employment
circulation and also display on their office notice board, announce on radio, television, and employment based bulletins.
Yeah.
Okay.
Lordship, the challenge there was you can't just do it through employment agencies. You should also advertise. That's how advertisement, after this advertisement came into being. My point is, it doesn't mean that without advertisement it was illegal. This was how it was being done. Lordship, 2 cases to say appointments made long time pursuant to a selection process must not be disturbed.
Yes.
Buddha, 1990. Yeah, 2001. 2001, volume 3, SCC 328.
See, appointment is for, it shows a contractual
Yes, your Lordship.
for 1 year.
Lordship, here, in fact, what was happening, this was by the commission, and what happened here was they did not qualify. They did not possess the necessary experience. And the court held, Lordship, paragraph 5, last 3 lines. Paragraph 5, placetum C. Lordship has paragraph 5, yes. Placetum C, thus the dispute, Lordship has, thus the dispute narrows down to one aspect, that is the selected candidates may not possess necessary experience, which is now required to be examined by the Transport Commissioner. So the challenge was they don't have necessary experience. The selected candidates who have been appointed are now employment as motor vehicle inspectors over a decade. Now that they have worked for such a long time, necessarily they would have acquired the requisite experience. Lack of experience in any case at the time of recruitment is made good now. Then your lordship may come to classitum F. We have extended.
Yes,
We have extended, your lordship has?
yes.
We have extended equitable consideration to such selected candidates who have worked in the post for a long time. But the contesting respondent do not come in that class. Now what follows is what I'm relying on. The effect of our conclusion is that appointments made long back pursuant to a selection need not be disturbed. Such a view can be derived from several decisions of this court, including so and so. So this is the proposition. Appointments made long back pursuant to a selection need not be disturbed. And this is two judges of the Supreme Court, and this relies on media. H.C. Puttaswamy. Paragraph 12. Same proposition. Appointments made long back pursuant to selection process should not be disturbed.
When you were appointed,
Yes, your lordship.
when you were
2014.
14.
Yes,
Okay.
10 years ago.
Sure.
August 2014 is petition number 1, and January 2015 is petition number 2 and 3.
This has been culminated into Uma Devi. 91.
Lordship, and Uma Devi has been watered down. If you want to, Lordship, if we have to go Uma Devi, then Uma Devi has been watered down to say your initial, if I'm illegal and backdoor, then I'm out. That is the pith and substance of Uma Devi, nothing more, nothing less. Lordship, then may I show you?
Otherwise, before that, PRSing also there, who really
Yes,
helped
yes,
those people.
Yes.
PRSing.
Lordship, my first ground is that I have been selected by a procedure which mirrors a regular procedure.
Hmm.
And it satisfies Article 14. And it's not backdoor and not illegal. There was a selection procedure that was established and devised by the respondent. And there was an interview held. So it cannot be held to be an illegal appointment.
Not illegal, nor irregular.
Yes.
Not even irregular. It's not an irregular also, according to you.
Yes. It's pursuant to a proper regular appointment process, which they have adopted and they have done. Lordship, this is again, Lordship, one paragraph.
Yes.
Paragraph 12. Having reached the conclusion about, Lordship has paragraph 12.
Yes.
Having reached the conclusion about the invalidity of the impugned appointments made by Chief Justice, we do not, however, refuse to recognize the consequence that involves on uprooting the appellants.
Yes.
Mr. Gopal Subramanian, counsel for the appellants, by highlighting the human problem involved in the case, pleaded for a sympathetic approach and made an impassioned appeal for allowing the appellants to continue in their respective posts.
Yes.
He has referred to several decisions of this court where equitable directions were issued in the interest of justice, even though the selection and appointment of candidates were held to be illegal and unsupportable. So this is a threshold higher. I'm not even saying that I'm illegal and I'm unsupportable. Even in that situation, Your Lordship, the Supreme Court has held on equitable grounds, you must continue. And that, Your Lordship, will find paragraph 16.
Yes.
Precedents apart, and they discuss all the case law.
Hmm.
Lordship, may I read paragraph 13?
It's okay.
Lordship, may I read paragraph 13?
It's okay. It's okay.
There is a good sense in the plea put forward. So they accept it. There's a good sense in the plea put forward by the appellant. The human problem stands at the outset in these cases, and it is not that the problem that motivated us in allowing the review petition. It may be recalled that the appellants are in service for past 10 years.
It's okay, madam.
Yes? Lordship, then one final case of Tejveer. Justice Nagaratna. Thank you. Lordship, the whole selection process was set aside, but they said that no, you must continue. Lordship,
This way.
paragraph 71,
Hmm.
cancellation of the entire selection process, whether justified.
Hmm. Para
Lordship, para 71.
70. No.
Lordship, the heading is cancellation of the entire selection process, whether justified. Lordship has that?
There is no para transition. It's up to 65. No, para 71. It's up to last is 65. Para 65.
Lordship, it's Tejveer Singh Sondi versus State of Jammu and Kashmir,
Yes.
Justice Joseph and Justice Nagaratna. Lordship, then may I have?
Yes.
Lordship, I think I have different copies. Lordship, there is a section which says cancellation of entire selection process
Hmm.
and basically holds the same thing. That in the end, if they have continued to be in service for about 10 years, a considerable period of time, then there's no justification in taking them out. And they cite Mohinder Sen Garg, and they set aside. Lordship, may I read the relevant
Sure.
paragraph? Lordship, may I just take out the relevant paragraph? I think it's select this one, citation 2. Lordship, the citation is different from. Lordship, may I read it and I'll mark it here and give it to your Lordship. Lordship, it's just one paragraph. In the light of the pertinent selection procedure that was followed, we are unable to hold that the same was mechanical or casual or suffered from irregularities which are so grave or arbitrary in nature so as to justify quashing the entire selection process. This is what I'm relying on. Lordship, I'll mark that and I'll hand it over.
Para 71.
Lordship, in this it's para 71, but I think Lordship has it. Yes. Paragraph 51. Sorry, Your Lordship. My submission.
Is also SCCM.
Paragraph 51, Your Lordship.
Okay.
In light of the pertinent selection procedure that was followed, we are unable to hold that the same was mechanical or casual or suffered from irregularities which were so grave or arbitrary in nature so as to justify quashing the entire selection process. That is my proposition. Was our selection process so mechanical, casual, or suffered from such irregularity which are so grave and arbitrary in nature that it justifies quashing it? And they've held no.
That's all.
Lordship, we've been at work for 10 years. So Lordship may, and we are continuing. We are the only 3 who are continuing. So Lordship, our prayer is still, they start with regular process, they must not oblige it.
I thought we'll finish up this matter today.
I am appearing in item number 27. My prayer is similar to the item number 16, and my learned senior friend has already submitted. Yes,
You record it. One by one recorded.
yes.
MS so and so for
Item number
rest,
27.
I'll dictate later.
Similar to the item number
You are in item number
27, my lord.
27. MS so and so in item 20. You mark it, just mark this. WPC 4343 of 2022. Adopting the
Mechanical.
submission of the senior counsel in item 16, BD core, huh? BD core and 10, sorry, huh? Yes.
Lord, if your lordship is.
Anything to add?
My lord, just.
Anything to add?
Some judgments, my lord. Yes.
Why are so many judgments?
Just lordship may see what the principle.
We'll finish it up today. I think we have to make it CAB. in that case.
It will not be over.
What few? Just
Few paragraphs, my lord.
Huh?
Few paragraphs.
How many judgments?
4 judgments, my lord.
Why you need 4 judgments in such a case? Anyway, that's stupid. 18. 17. This is item 17.
May I add one more case?
Why, madam, why it's not required?
777 people are just struck out. So one more case. Okay, basically. that
Just
is
add that.
basically for ad hoc.
You add that judgment?
Not sure, I'll just tell you the paragraph. Paragraph 12,
Just add that.
13 and 16.
Para 12, 12.
13 and 16.
Just
Settled
mark
principle of law that ad hoc cannot be replaced by another set of ad hoc.
16.
12, 13 and 16. Obliged to look.
Yeah, my lord, first judgment is Vikas Pratap Singh, my lord.
No, yours, what you, how you are appointed?
My lord,
Same-
I
same
am
process.
similarly, in item 18, I am similarly appointed as the
Item
petitioners
17.
in item, I am in item 18.
Yes.
The petitioners were appointed as similarly as the petitioners in item
But
7.
there were, they talks about only 10.
Lordship will see, I am the first 7 are there in my names are there, my lord.
5/7.
Yes,
And
my lord.
then,
My lord, in the first list of first 10, the next 3 did not join. So, my lord, the next, there were more persons selected. I am in the first 10, my lord. Again, number 8 is me again, Jahangir Hussain Khan. So, my lord, at least in the first 11, I am there.
no, only 10 were the recruitment was for 10.
Later on, approval was given for 13.
No,
Actually.
that is something different. Approval is something different. It was only the process he has clearly pointed out is only for 10. Out of within the 10, 3 of these in item 17 they were appointed. Now, what is your case? Were you within this 10?
Yes, my lord. My lord will see the names.
How many petitioners are here?
I am 11, my lord.
So how can there are one more is this? 11 plus 4, 14.
Lordship will see there 14 were selected.
11 plus 3, 14.
Yes, my lord. So in that 10, at least 10 of us are there, my lord.
No, don't say that's 10 of us. You just clarify it. What she has said is their selection, 3 petitioners, item 17. They've been appointed by following all this due process.
Yes.
Which shows that there were 10 mechanics, right?
Yes.
Out of this 10, 3 of them were there.
My lord,
Your petition, the petitioner and this petition is 11.
11, my lord.
So there's the excess of 4.
No, the first 7 in the list of 10 includes us, my lord.
The
We are the first
petitioner
7.
1 to 7.
Yes, my lord.
It includes. What about the rest?
Rest, my lord, in that list of 10, 3 did not join.
Read petition number?
3790.
3790. Mr.
S. Dev.
Dev.
S. Dev, my lord.
Dev.
DEY.
Ah.
So 3 did not join from the list of 10. So further persons were selected, my lord, from the persons who had appeared in the interview.
Huh?
From the list of persons who had appeared in the interview, my lord, they selected more persons because 3 did not join. So, my lord, the remaining 4 of us were brought in.
3 did not join.
3 did not join from the original
List of 10. 10.
Yes, my lord.
Then
Then remaining, another 7 persons were given appointment. So 7 plus 7 makes it 14 actually. From the list of 10, 3 did not join, so there were further
now, when
selections
was
made.
the selection was for 10 posts? How can there be a 14? I'm recording it. As per the selection, it's a 7 and 7 was appointed later. Huh?
Because 3 did not join, so we, at least 10 of us will be there in the list of 10.
3 did not join. So yes.
And lordship has seen the impugned orders, my lord. It was, we were not given any opportunity of hearing.
Not required.
So in that respect, I'll make some submission that, my lord, even a contractual employee is entitled to a hearing, my lord, before being terminated.
Which page?
I'll go, my lord, there are 4 judgments. The first is Vikas Pratap Singh. My lord, para 22, 20. Para 22, my lord, the pristine maxim of fraus et jus nunquam cohabitant, fraud and justice never dwell together, has never lost its temper over the centuries, and it continues to dwell in spirit and body of service law jurisprudence. It is settled law that no legal right. My lord, para 22. Vikas Pratap Singh, my lord. The pristine maxim of fraus et jus nunquam cohabitant, fraud and justice never dwell together, has never lost its temper over the centuries, and it continues to dwell in spirit and body of service law jurisprudence. It is settled law that no legal right in respect of appointment to a said post vests in a candidate who has obtained the employment by fraud, mischief, misrepresentation, or malafide. It is also settled law that a person appointed erroneously on a post must not reap the benefits of wrongful appointment, jeopardizing the interest of the meritorious and worthy candidates. However, in cases where a wrongful or irregular appointment is made without any mistake on the part of the appointee, and upon discovery of such error or irregularity, the appointee is terminated, the court has taken a sympathetic view in the light of various factors, including bona fide of the candidate in such appointment and length of service of the candidate after such appointment.
Yes.
So unless the fault was on our part in our appointment, my lord, the honorable courts have always been sympathetic and allowed us to continue in appointment. Similarly placed persons, my lord. This continues, my lord. These employees herein were protected, my lord, in this judgment. This was followed, my lord, in.
You are not able to show that your all the except for this 7. All
10, my lord. We are
petitioners
11, but 10. The 10 of us come in the list of 10 at least. And in fact, later on 13 were approved, my lord.
Where it is?
Lordship will see there is in the petition.
No, it may since there was a requirement for filling up of 10.
Yes. So initially they selected 10, my lord. Out of those 10, 7 of us are there. 3 persons did not join. So they made further selections, my lord.
Was there any record to show that?
Yes, my lord. Kindly see. That's there, my lord.
3 of them have not joined, and in that place you are appointed. You are appointed.
Yes, my lord. See, kindly see page 42.
What does it say?
it shows the names of the persons who were initially selected, the list of 10 persons.
Yes,
The first 7 is all the petitioners here.
yes.
The remaining 3 did not join, my lord.
Uh,
Then they made another selection where names of 2 persons went in. Their petition number 8 is there. Another post still remains, my lord. Another selection was made subsequently wherein petitioner number 9 was brought in. 3 persons came.
Selection, how it was made?
All these persons, their names feature in the
No,
intermediate
it's not the
list of
question of
candidates.
featuring only, how it was appointed, how the selection was made, this is why I'm saying.
Well, it is same as item number 17, my lord. We were ITI trained candidates. From the ITI, a list of candidates was sought who were trained mechanics, my lord. Our names were forwarded to the
Is there
department.
any documents?
Yes, my lord.
This
The first is at page number 25.
additional post has to be filled up, apart from 10.
10 plus 13. My lord, page 57. I didn't.
57.
This was after our appointment, my lord.
Yes.
In view of increase of strength of the corporation to about 1,000 numbers at present, the ratio of bus and mechanics is very low as in comparison to the norm of. As a result, there are substantial resultant vacancies in the in the department. As the process for regular recruitment will take time, as per decision of the Board of Directors taken in its 167th meeting held on 27/11/2014, the respective divisional engineers, divisional superintendents may engage casual hands based on the bare minimum requirement, observing formalities with the prior approval of the undersigned to meet the exigencies for repair and maintenance works of the buses. For this purpose, the maximum limit of casual hands to be engaged in each division against resultant vacancies of mechanics is given below. Clause number 6 is Silchar, my lord. We'll see 13. So 13, my lord. We come within this 13.
This is for a stopgap arrangement.
Lordship.
Engage casual based on the bare minimum requirement observing common with prior conditions.
And this was issued by the managing director of ASTC, my lord.
No, it is for engagement on casual basis. There is no selection process.
No, the selection had already taken place, my lord. On the basis of the documents already shown, my lord.
It doesn't say so. What does it say?
Oh, lordship will see.
You have read it already. The respective divisions may engage casual hands based on the bare minimum requirement.
Lordship. But 13, my lord.
Observing formalities with the prior approval by so and so, may exchange or repair and may this for maximum limit of casual hands to be engaged in making. Yes. Doesn't say anything that the selection process, after the selection process or whatever.
Because
at least for this 4 persons.
We were already joining, my lord. No, the list, because I already showed your lordship the list of 10. 3 did not join. So rest 3 have to come in, my lord.
Where you have shown that you saw that 3 have not joined.
Page number 42, my lord.
Yes, 10 were selected. Name of
Yes,
the
my lord. The serial numbers 8, 9, and 10 did not join. Total, there are 14 petitioners from this whole group, my lord. So these 3 persons have not joined. First 7 are us. First 7 are us. So since 3 did not join, my lord, they selected more persons.
Where?
Next page, my lord. Page 43. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . Sri Jahangir Hussain Khan, my lord, he is petitioner number 8. And Javed and Javed Akhtar Loskar is also another petition.
This is,
He is in petition number 17. So total 9 now, my lord.
The instruction is available of the FIR.
trainees are here by direct report to, but then it's, the continuation are allowed to work as mechanic training.
I can guess.
Is it not addition to this 10? It is not in addition to these 10 persons.
No, because my lord, 3 did not join, so 3 posts still remain.
It doesn't indicate, sir. That is what I wanted to know. See, doesn't indicate. Yes,
Yes,
then
my lord, we will see the heading of the,
it simply
State
says in
notification.
continuation.
yes, of the head office. The first one also says the same thing, the list of 10.
Sir, that's what I'm saying. You said out of 10 first list, 3 have not joined.
Yes,
So in their place, these 2 persons has been appointed.
yes.
So what does it indicate? It doesn't say, just say in continuation of the order. It's like addition to this 10 only. Right?
Yes, my lord.
And then what about the rest?
Then, my lord, now it's 7 plus 2, 9, my lord. Then another person, petitioner number 9, page number 46, his appointment order.
Yes. So this is again continuation.
Yes, my lord.
Huh? Page 46.
Page 46, my lord.
There are 3 persons.
Yes, my lord.
So,
Now they exceeded the number 10.
huh?
Till Sahidur Rahman, my lord, there are 10 persons.
So what is the other one?
The remaining 2 and another person, my lord, they would be a little excess to the number of 10, my lord. Originally sanctioned.
1, 2. So first page 43 is 2 persons. Then
Yes.
page 46 is 3 persons. 5,
Yes,
5,
5.
right?
5 plus 7 comes to 12, my lord.
Then
And another person was appointed.
now you have increased 1 more. Earlier it was 14, now it's 15.
No, it's 14 only, my lord, total.
How?
11 petitioners in this case, my lord, and 3 petitioners in item number 17.
What about the others? Who is missing? 12 plus 3.
No, it's 11 plus 3, my lord.
Okay. 7
plus 5.
7 plus 5 is 12.
Somebody did not join, my lord.
Somebody, no, total appointment is 7 only. I mean 15. 7 plus 5, 12, then 3, 15.
7 plus. Sabir, Sunil, and
Somebody might have joined with you. This is different. Yours is 11 petitioners.
my lord.
One might not have joined with you in the petition, but then problem is the way you were projecting and arguing is not correct.
No, my lord, there is another appointment order, page 52.
Then it's become 16.
15.
Yes, then.
Petitioner number 10 and 11 were later they were brought in, my lord. Though in continuation of these earlier orders.
Okay.
And my lord, all these persons had appeared in an interview, my lord.
Hmm.
That interview result I have annexed at page 36.
Hmm. There's 36.
Yes, my lord.
Okay. What's the original?
The original is page 40, my lord.
9. "20% appeared in the interview, according to you.
Lordship.
Right.
Lordship.
Out of 20 persons, 15 has been appointed, have been appointed,
Lordship.
15 persons. Where's the original?
The original is at page 40, my lord.
List of candidates appeared in interview held in the office of so and so on 23777. Yes. Anyway. So maybe that relevant to consider the case. Yes. Then
So lordship, that's
Principle of Natural Justice,
lordship.
Vishwas Prasad.
Then, my lord, there's the next judgment is my lord Anmol Tiwari, 2021 5 SCC 424. Para 11, my lord. This followed the judgment, the earlier judgment I have shown to your lordship. Para 11. If I may read.
This is because that's why I'm saying, why you unnecessarily troubling yourself and us when it is referred and relied, considered.
Then Radhesham Yadav, my lord.
2003. This is also referred and relied by two judgment.
Lordship,
Because Prakash and the other one is?
Anmol Kumar.
That's why I said the latest and the nearest.
I'll just mark the paragraphs in this judgment, my lord.
And then this
And
other one is?
Jaggo, my lord.
Jaggo, they has already relied.
Just one thing I will show to your lordship in this judgment, Jaggo, my lord. Para 14, your lordship may kindly see one. Wherein
14 they already read.
14, in para 14, in Jaggo, my lord.
Having given careful consideration. 14.
Para 14, my lord. The abrupt termination of the appellant's services following dismissal of their original application before the tribunal was arbitrary and devoid of any justification. The termination letters issued without prior notice or explanation violated fundamental principles of natural justice. It is a settled principle of law that even contractual employees are entitled to a fair hearing before any adverse action is taken against them, particularly when their service records are unblemished. In this case, the appellants were given no opportunity to be heard, nor were they provided any reasons for their dismissal, which followed nearly 2 decades of dedicated service, my lord. Even contractual appointments, before terminating contractual employees, my lord, they have to be given a notice and an opportunity of hearing.
Meeting. Yes. Mr. Day, Mr. Day. M Day, A.
Yes, they might.
S Day, At a meeting, This recording, Mr. President. That's all. That's all, sir.
Lordship, in items 26 and 28, Mr. S. Bodhakur will appear. Lordship will probably take it up on another day.
No, we'll complete today. Same thing.
Similar facts, my lord. Irregular employees, my lord, but they were not given any opportunity of hearing before their termination. And they have been serving for long durations.
Since when? 2014.
2014.
26 also.
My lord.
27 also.
Yes, my lord.
Yeah. Bodhakur. Attempt 26 is Bodhakur. Heard. Same.
Lord. Much obliged.
Lordship, if they are not,
From the
if they are not given the opportunity of hearing, Lordship, next day they will approach the division bench citing the same argument, Lordship. No opportunity of hearing, Lordship. Lordship, what I am submitting today, Lordship, let this matter come on Thursday, Lordship. I will take some time. Today, it's only 10 minutes left, Lordship. It will require some time, Lordship.
I have done a big mistake. I
Lordship.
should have granted adjournment when the senior lawyers were
No, they have completed, it's good, Lordship.
indicating.
It's a long pending matter. They have completed their part. On Thursday, Lordship, I'm completing. I'm going to take hardly 45 minutes, Lordship.
We have another 5, you can sit up to 5:30, 6 o'clock, no issue.
They have cited some judgments also, Lordship. I would like to go through those judgments.
That is the whole problem.
Yes, Lordship, that is the issue.
I have no other business. I can be here up to 9 o'clock. Normally we dance.
Lordship, only issue those judgments and the records, Lordship, nothing else, Lordship. Otherwise, so far as facts are concerned and my case is concerned, I'm prepared, Lordship. But these two will remain incomplete, Lordship.
Seriously, I don't want to keep it CAB. I thought of finishing it and dictating it out. But then
On
because
Thursday,
I'll be away for after this week. I'll be away for 5, 6 weeks.
no, that is why I'm praying for one day only, Lordship. On Thursday,
You want
Thursday,
burden
Lord.
me
Thursday,
to
Lord.
carry all this file to the back home.
Yes, that is there.
You want to enjoy the holiday. What about us?
Just one day, Lordship. On Thursday, Lordship, nothing else.
Yes. I still Friday I'll be leaving by second half. It not be possible, I think. Can it be day after tomorrow? Oh, no, day after tomorrow is the
Yes, I'm
Thursday.
praying for Thursday only.
Anyway. The record all this. It's there, huh?
Lordship,
Thursday.
let me have the record. Lordship.
Thursday.
Let me go through it. Lord.
Yeah, okay.
Next day I will produce
And
it.
tell them in that case, Bortakur, we'll fixing hearing it again. Water, huh? You record all this then. Then so they do before and it's here only. It's recorded already. So names are already recorded here earlier. No, some of the cases, some of the lawyers are not there. Madam, your name is not even recorded in last occasion. Ah. You just take all the lawyers, I mean, including the recipient, huh? Method, the hearing remains inconclusive. Hearing, please stop hearing to continue on Tuesday, huh? 6/5/05/06/2020.
Lordship, obliged, Lordship.
So we'll just make it part.
I'll complete
We'll
it.
continue.
Yes,
You complete on that day.
yes, Lordship.
What is going to be? All are represented except Bortakur in item 26 and 27. You kindly inform all the other lawyers who have not been, who is not present today to complete their argument on Thursday, day after tomorrow. Can you check out the list and kindly inform them? As he rightly pointed out, tomorrow they may immediately go to the division bench. Why not modern? But it's your statutory it's a right, everyone's right, but then it will, in the process, the litigants may suffer. Okay. Kindly inform, huh, Mr. Dey, all of them. Mr. Rahman, one M. Rahman is also there, item 29. And then Bortakur and rest. Bujar Boru also, item 27. Das is there. Sorry, Bortakur is there. 27 and 26, 27, 28. Mr. Bortakur. Madam is item 27. Okay. Okay. Okay, one Rahman is also there, item 29. 29, you are 29. You have anything to say? No. If you have anything to say, you argue now. Huh? Okay. 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 Next. Yes.
Lordship, this matter is about termination of service. My case is that notice was issued on ground of negligence of duty. I have filed my reply. They are not satisfied. Then they initiated departmental proceedings and
Yes.
asked me to appear before the inquiry committee,
Yes.
but no inquiry was conducted. Without
Yes.
conducting any inquiry, they have terminated me from the service.
Yes. So,
Accordingly, I have prepared an appeal after termination, highlighting those facts that no inquiry was conducted, no inquiry report was prepared,
yes.
neither any witness was not examined,
Yes.
their statement was also not recorded. So while these are the issues that I have highlighted while preparing the appeal, but the appellate authority mechanically dismissed my appeal. And then Lordship, it is the second round of litigation. Then I approached this honorable court, and this honorable court observed that the manner the authority, the appellate authority mechanically, without appreciating the evidence, dismissed my appeal
Yeah.
and directed the appellate authority to re-appreciate the evidence and to pass a speaking order.
What do you say?
Yes. My lord may come to page number 28, my lord, of the writ petition.
28.
28. Here he had admitted to the charges.
Yes.
Then later on, my lord, he says that he was made to sign on blank paper, and he did not do this voluntarily.
Yes.
My lord, if he was made to sign on blank paper, my lord, why was the issue raised after the order was passed, my lord?
Yes.
And that is why this is, my lord, the second round of litigation. First round,
Have you filed your reply?
Pleading complete, Lordship.
No, no. Have you filed your reply after this so cause? So cause was issued
Yes,
to
yes,
you.
I have filed reply.
Have you mentioned that
Yes,
this
everything is-
confession admission was before your filing so cause or after?
Lordship, that is the, this admission. This admission is after file, it is not admission.
During
so-called
the course
admission.
of what?
It is
During the course of inquiry.
during the course of inquiry.
So,
No, that is the fact that this one is disputed. I have never signed any declaration. And they are telling that
declaration is when? After the filing of your
on the
reply.
day of inquiry,
After the filing of reply.
reply.
Then,
Lordship, issue is that, and this honorable court in the earlier round of litigation observed that since it is a disputed fact, only the appellate authority can take up the issue and they pass the absolute order. So my case is that without conducting any inquiry, they have
you are the inquiry committee.
yes, ma'am.
inquiry committee was constituted, but
In front of the sorry.
what is the formal inquiry? Lordship, the inquiry means that the statement of the witnesses shall be recorded and the defense opportunity shall be given to the delinquent to produce his defense witness. And it is the mandate of the law, Rule 9(7) of the Assam Discipline and Services Rule says that after inquiry report shall be prepared and that shall be communicated to the delinquent person. But if this system is not followed, if the procedure is not followed, then it can be said that inquiry is not proper. The inquiry is not conducted as per the requirement of the law. And they have admitted that inquiry was conducted. Lordship, Lordship will say that in page number 40.
How many inquiry committee? It's a why the inquiry committee.
Yes.
It appears to be not in accordance with law.
There was an
This is just a preliminary inquiry or fact-finding committee.
yes, I hear it was a committee for hearing, my lord. Inquiry committee, my lord.
Inquiry committee,
Yes.
not as per the procedure.
But on the very first day, my lord, in front of the committee, he had admitted.
Only one day.
That is why it was not proceeded, my lord.
No, it has to be. It's not that. There are two inquiry. It could be two, three.
Yes,
Number one, inquiry committee can be constituted
yes.
for preliminary or fact finding. Then only you have to initiate. It is also only ascertain.
Yes.
Preliminary inquiry and fact finding only to ascertain whether there is a case to proceed with disciplinary proceedings. Here is a case, disciplinary proceedings will apply, is not it? So the confession, I think, when sitting with the former Chief Justice in division bench, I have authored one judgment on that, basing on the, of course, Supreme Court judgment. Even confession, admission confession before the preliminary or fact-finding committee cannot be relied to punish, to impose a penalty. It appears that the confession,
Yes, ma'am.
whether made or not made,
Yes, ma'am.
right, it cannot be relied on until unless that could be a basis for initiating. And if he make a confession during the sentencing, that can be recorded, that can be examined and all that thing. That is something different. But it appears that in this case, there was an inquiry committee. He has confessed. On that basis, he has been imposed a penalty. I think
I don't let the records be called then because
that is not the way. This is not that is not be properly.
because
We'll see.
my lord may
You produce
call for the
records
records
there.
in the order, my
Ah.
lord. Then I'll
Not Mr. So and so, learned counsel for the pre. There is no time. No time
Yes, yes, yes.
for you.
Lots.
For you, there is no time. The matter as agreed to by learned counsel for this party, let this matter after 3 weeks. On the next day, Mr. I Botak learned standing counsel,
Assam Agriculture University.
Assam Agriculture University to produce the record. Record, right?
Record.
Since Lordship, I have a small one more submission.
Yes.
That my petitioner is almost bedridden, so if I
After
request.
4 weeks, after 3 weeks, I said, after 3 weeks, final court judgment.
Lordship.
It may help you. Are you saying so? That there is no discipline inquiry?
No, there is no formal inquiry, Lordship. Exactly. correct.
There is no departmental proceedings as such.
Yes, yes.
I cannot, I'm not, we're not making you more wise.
On that day of hearing, I
Can you
tried.
find out that?
Yes, I'll.
There's judgment.
Okay.